And this morning, we're blessed to have the Reverend Randy Jones from the First United Lutheran Church lead us in opening prayer. And then with sadness, I had announced that Officer Ott today will be leading us for the last time in the Pledge of Allegiance with Melissa. All right, I want to make sure this is a special day for both of you. All right. So with that, those who are willing and able, please stand. And Melissa, you can come up now too if you want.
Let us pray. Almighty God, you have called us to labor in your vineyard, and without you we can do nothing. Grant your gracious presence at this meeting, that we do what we do will build up your whole creation. Let your Holy Spirit govern and direct us, that we may consult together peacefully, pleasing you with all that we say and we do. We ask these things in your name. Amen.
Amen.
Please join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, and thank you, Deputy Sharon, for also leading us in the pledge this morning. And also thank you for your service. Officer Sharon is a United States Navy veteran. I almost said that. Okay, we have a couple of presentations this morning. The first will be led by, I'm sorry, I'm being distracted by my commissioners. It always doesn't take much here lately. Jessica Gwynn is going to lead us in the is going to make a resolution in support of the 2020 decennial census. Those who are going to join this presentation, please come up. Thank you.
Good morning, everyone. This morning I have Linda Baptiste and Doris Turner with the Census Bureau. Also, I have Tom Brooks with the libraries. Our agency, the Community Development Agency, has been leading up the Complete Count Census Committee for 2020. This is very important. It's a very important initiative because this is how we make sure that everyone is counted in Cobb, and that way we'll be able to get the maximum federal dollars back to Cobb County for all of our residents. So a couple of months ago, the board approved this resolution in support of the census, and this morning we would like to present this to the Census Bureau. So the resolution says, a resolution of the Cobb County Board of Commissioners to support the 2020 U.S. decennial census. Whereas the United States Census Bureau is constitutionally mandated to conduct a count of all persons living in the United States every 10 years, whereas the effort to conduct the census requires partnerships between the Census Bureau and state and local government entities to help ensure a complete, accurate count of the population. Whereas on November 27, 2018, the Board of Commissioners authorized the creation of the Cobb Complete Count Census Committee and assigned Mr. Jason Gaines as the county liaison to the committee. Whereas the Cobb Complete Count Committee brings together a cross-section of community members that utilize their local knowledge and expertise to reach out to every segment of the Cobb community. Whereas a united voice from business, government, community, and faith-based organizations, educators, media, and others will enable the message of the 2020 census, and it's important to reach a broad range of Cobb citizens. Wow, this is a lot. Chairman, I don't want your job. Thank you, though. Now, therefore, be it resolved that Cobb County is committed to partnering with the United States Census Bureau by way of the Cobb Complete Count Committee to support the goals and ideals of the 2020 U.S. decennial census. Be it further resolved that Cobb County encourages all Cobb residents to participate in events and activities that aim to raise awareness of the census and promote participation. Be it further resolved that Cobb County is committed to achieving a complete, accurate count of all individuals living within its borders the 16th day of December 2019, and it's signed by our chairman as well as the county clerk. So thank you all for being here. We'd love to have the commissioners come down if you'd like to support this census. And also for all of you, we just encourage you, keep an eye out for your census documents. A lot of it's going to be filled out online this year, so that's going to be a great opportunity, but please understand and please share with your communities that this is very important. Thank you. Would you like to say anything?
I would like to say on behalf of the U.S. Census Bureau, my name is Doris Turner, and I'm a partnership specialist. And I want to thank the Board of Commissioners and Jason Gaines for a wonderful opportunity to support the 2020 census.
Again, thank you all. My name is Linda Baptiste. I'm a partnership coordinator for Cobb County and Northwest Georgia, and I appreciate all of the support that you all have done in supporting the U.S. Census.
Give her the application, and then we do the famous photo op.
Right.
Here we go in 3, 2, 1, and we're done.
And Officer Ott now has a presentation.
No, Officer Ott doesn't. Commissioner Ott does.
Commissioner Ott.
Officer Ott can
your
join me
day,
if he
Ott.
wants. Will Joe, Tommy, and Aaron Wolf come down here, please? Or come up here, whatever. See, he's got everybody all confused now. Loosen that tie. So this is, before I let Joe Tommy tell you what we're here to do, this is one of the best parts about this job, is to kind of highlight the hard work and dedication that our county employees have and the extra effort they go to get their certifications and kind of be a step above. So Joe, you want to tell everybody?
Okay, thank you, Commissioner. Good morning, everyone. It's my pleasure this morning to recognize Erin Wolf. Erin is a senior buyer in the Cobb County Purchasing Department. She's only been with us about a year and a half. But in December, she was notified that she had successfully met requirements for certification as a certified public purchasing buyer. This is an internationally recognized certification. Takes a lot of hard work, and the pass rate for first-time test takers for this exam is about 60%. So, Erin, this is a tremendous accomplishment, and we're so proud of you. Okay? There you go.
So let me just read to you before, and she's going to kill me when I tell her she's got to say something. But so what's on the plaque here? It says Universal Public Purchasing Certification Council. The UPPCC has conferred upon Erin C. Wolf the classification of CPPB, Certified Professional Public Buyer, for having fulfilled prescribed standards of competency in public procurement as demonstrated by education, professional experience, and the successful completion of a rigorous examination. So congratulations.
Thank you.
Want to say something? Not a chance. All right, you go to your picture.
Got it, thank you.
Congratulations.
Thank you.
Thanks.
Yeah, congratulations.
All right, now we have 4 public hearings, and the first item to be addressed is the pending motion from the January 28, 2020 board meeting to withdraw proposed Cobb County Amendment 10-135, the prohibition on the sale of dogs and cats at pet stores, from consideration for adoption to the county code. It is Commissioner Burrell's motion, seconded by Commissioner Gambrill. Commissioner Burrell and Gamble voted in favor of the motion to withdraw the proposed Cobb County Code Amendment 10-135, and Commissioner Cooper and myself are in opposition to it. So Commissioner Ott, if you would please place your vote. Okay. So now, for those who are curious as to what that means, is that when Commissioner Burrell made the motion, She included in the motion that people would still be provided the opportunity in public comment, public hearing, at the public hearing to make comments about this proposed amendment. So even though the motion has been passed to withdraw the proposed amendment, those who are here today to address that proposed amendment can still come to the podium during public hearing for their 3-minute comment period to address this issue. Does everybody understand that? Okay. There's also some confusion about between a public hearing and a public comment. The public hearings are this first part of the meeting. There's going to be 4 of them. And then after the public hearing, we're going to have public comment. During the public hearing, you're allowed 3 minutes to address the issue. During public comment, you're allowed 5 minutes. So I just want to make sure that there's no confusion about that, although clearly there's going to be some. But I'll make sure that before I close the public hearing, I will emphasize and ask once again if there's anybody who wants to address that particular issue. I want to make sure everybody knows they have the opportunity to be heard this morning. Okay? So with that, the second item is to conduct the second public hearing to solicit comments and input on the proposed amendments to Chapter 2, Administration, Chapter 10, Animals, Chapter 18, Building Regulations, Chapter 54, Fire Prevention and Protection, Chapter 66, Historic Preservation, Chapter 78, Licenses, Permits, and Businesses, Chapter 90, Parks and Recreation, and Chapter 134, Zoning of the Cobb County Code, and to consider adoption of the proposed amendments. With that, Mr. Hosak, you have the floor.
Morning. Thank you, Mr. Chairman. This morning, as you are correctly identified, we are going to request that the board open the second public hearing to consider amendments to the official code of Cobb County. There was a draft package, Mr. Chairman, that was sent out under a cover memo dated February 6th that did highlight some of the changes that had been made to the draft amendments as a result of the first public hearing and subsequent communications. Did want to call to everyone's attention that this particular version does exclude or will now exclude 10-135 per the board's previous action that was ratified by Commissioner Ott in the first item. There will also be some changes to some definitions that will probably need to come out, and I believe we can address those at the end of the hearing following the receipt of public comment. Starting with our First Amendment, beginning in Chapter 2. This is a change related to the Historic Preservation Ordinance and allows for the enforcement by our Code Enforcement Division of both our film ordinance as well as the Historic Preservation Ordinance. I'm going to ask our subject matter experts to follow now. I believe we're going to be moving into Chapter 10, which is our animal control-related regulations, and Interim Director Randy Kreider is going to come up and move the board through those amendments as has been amended per the board's direction, sir. Thank you, Randy.
Yes, sir. Good morning, Chairman. Good morning, Commissioners, County Manager. There are some proposed changes to, as a result of the first public hearing, and I'll go through those very briefly, and we'll start out with the definitions. The term director was added on page 3. The definition of feral cat, which is defined as has no owner, was added to better clarify the meaning. That also is on page 3. In addition to that, as the county manager commented, there are some definitions that we're proposing to come out as a result of 10-135 being withdrawn. Then on section 10-11 on control of animals, we've changed that leash length to 10 feet. And there was clarification that was added that related to dogs participating in sporting, herding, and agility competitions, and that's on page 4. And then down in 10-37, we removed the word fees, and the original change allowed for an assessed fee when pets were relinquished has been removed because Cobb County Animal Services accepts donations without an ordinance. Okay, and that's on page 5. So that is the only recommended changes that we have at this moment. Any Comments from the board?
We've received various comments with respect to 10-67 subsection C. This is regarding the T&R program.
Yes, ma'am. There was, has been some questions coming that we better define the trap, neuter, and return program and defining what that actually means.
I do see a catch-all clause at the end, which may help, where it says CCAS has discretion to determine whether to keep an eligible feral cat at the shelter or release it pursuant to this provision, and I think that's helpful. Now that I take another look at this, as there are some persons who have concerns about the challenges with those cats being returned to their communities.
Yes, and Commissioner, this is actually a program that we have been doing for quite some time.
Okay.
And it has been very effective.
Okay.
And so we wish to continue that, but maybe give some definition to the trap, neuter, and return definition, if you will.
Okay. So you're just now codifying that?
Yes, ma'am.
Practice, yeah.
Could I ask another question about the same section while you're in it? I've gotten some phone calls and emails, and I think, Shauna, you might have to answer this. The question was, why do we only do that with cats? And why do we not do it with, say, raccoons and other animals that we capture? I mean, I told them that I thought it was because of the rabies and all that, but could you just, it may address some of what people might want to
Yes, sir.
ask.
DNR handles all of the wildlife, but raccoons are rabies vectors, so we wouldn't be able to.
Right, so basically anything that's a rabies vector, you can't do the TNR.
Yes, sir.
Okay.
Yes, I also received some revised language from the county attorney's office this morning on the 10-11, A1 and A2A and A2B. Number 8 with the exception, section 1011A2 shall not apply to operators of a Cobb County Animal Services approved trap, neuter, return program for feral cats. So that would keep really the ordinance that we have in place and remove the exception of cats, but apply only to the TNR program with the approved vendor.
I'm sorry, Commissioner, can you repeat that subsection?
Okay. I'm trying to find it in here. It's 10-11, 10-11A1.
Okay.
A2A and A2B to add to section 1011A the following, number 8. Exception, section 10-11-A2 shall not apply to operators of a CCAS approved trap, neuter, return program for feral cats.
And correct me if I'm wrong, Commissioner, that request was also to remove the language with the exception of cats in those 3 sections, A1, 2A, and 2B. Is that correct?
Yes. And I have it printed out here, but I didn't know if this was the time to do this or after the public hearing or.
Well, first, I'm looking for
There's,
1011A8.
this would be.
I don't see
number-
I don't see a
This would
7.
be adding number 8.
I don't see a 7. That's my problem.
Page 5, there should be a number 7 at the top of the page.
Okay.
And we would be adding.
There it is,
8.
okay. That was on the wrong page. Got it, thanks. Going too many pages in here.
Yeah, that would remove the cat exception from the proposed amendments. 1011A1, A2A, 1011A2B. Basically, it would leave our ordinance the same with the exception of the TNR program by the approved vendor would be allowed to be off leash.
Right.
But pet owners' cats would still, I know it's not enforced, but it would protect pet owners' cats that are, you know, have their shots and are spayed or neutered and belong to someone.
So the only cats that would be permitted to be off a leash would be the ones that have its ears tipped. That would be the
That-
visible recognition
Are part of the
For-
TNR program.
to show that it's part of the TNR program.
Yes, ma'am.
I would recommend that, this change.
So, Randy, if you make that change in 10-11A1, would you take out the section of cats? You also need to take out non-feline, correct?
Yes.
Right, both parts, because you're just basically removing any reference to cats.
Yes. Any more questions?
That's all I had on that.
So are we all in agreement about adding 10A, at 10A8?
Okay.
Okay,
Do we want to consider, is this the discussion of our changes, or maybe we can hold this and consider this as an option after we hear public comment?
sure, we can do that.
Okay.
All right,
We won't vote till after.
Yeah,
okay, all right.
and that way, I do like us discussing it now, because the public has the ability to make comment on these suggestions or options.
Commissioner Gamble, you had a comment.
Just some cleanup, Randy and Shauna, on page 5. In C, we still have CCAC. It hasn't been changed to the CCAS. And then it also is twice in line D. And then on page 6, D, we again have CCAC twice, and then in E, CCAC once. So that just needs to be cleaned up, please.
Good catch.
That's all I have.
Okay, any other questions from the board for Randy? Okay, thanks, Randy.
And, Mr. Chairman, just
Sure.
clerk told me that because in definitions it changes CCAC to CCAS, she's going to get the vendor to go through and do a change throughout the code all at one time. So
Okay.
I don't think we need to go and do it on each section, because the vendor can do it.
All right, now chapter 18, I believe, building codes, regulations, Jessica.
Good morning, everyone. Jessica Gwynn, Cobb County Community Development. Chapter 18, as you'll recall, this was simply the amendment in order for Cobb County to adopt the current codes that the state has already adopted. So there are no changes to this from the first public hearing. If there's no questions on that, we'll move on. Next is
Fire marshal.
Good morning. We've got two proposed amendments to Chapter 54. The first has to do with a copy of 123.3 rules, which are issued by the State Fire Marshal's Office. We discussed this yesterday. This would be a duplicate, and there have been, related to this matter, there have been changes in the newly adopted 2018 code, which were not in the previously adopted 2012 code, which give us, as an AHJ, more freedom within the code to address occupant load issues, and it also an occupant load factor change. So as we discussed yesterday, this would be a duplication of something that's already in effect.
Right, so, Mr. Chairman, just for you, for the commissioners and the public, what the Chief Westbrook and I talked about, as he said, that the changes that came from the national standards, well, the state standards, basically came about after we had moved forward with putting this in the book. And they basically say the same thing. The only thing, and we just have to figure out where we're going to put this, and I think we talked about this yesterday, that it's probably going to be a fire department policy. But one of the things it says in the state code is where substantial evidence and documentation is provided. And then it talks about the authority having jurisdiction. My question was, what does that mean, substantial evidence and documentation? And so what Randy sent me yesterday, and my suggestion will be that if we don't vote on this, that we do ask the fire marshal to add to their policies that basically the statement, as used in this section, the Cobb County Fire Marshal's Office defines substantial evidence and documentation as a report that is sealed by a fire protection engineer, meaning it's stamped and accepted by the Cobb County Fire Marshal's Office.
Seems
Okay,
reasonable.
so then that, we stick with using the state code, but we basically say that if somebody's coming in and want to know what does substantial evidence and documentation mean, we will have a definition in the fire marshal's procedures so that if one fire marshal looks at it and another one looks at it, everybody's looking at the same thing.
Do we have to add that to the definition in the code here?
Well, I believe that the code gives us the authority to do that administratively.
Okay.
Yes,
make
what
that
we talked
decision.
about was more of directing Director Kreider to basically add it to the fire marshal's policy manual and make sure that all the fire marshals know moving forward that that's what the county definition of substantial evidence and documentation is.
It seems reasonable as long as there's support from staff to do that.
And that was actually Jay's language.
Yeah, we would support that, and we sent that draft to Commissioner Ott yesterday about defining that.
Okay. I just have a question. I'm sorry, Commissioner, were you done? Yes. With the change that's listed here with the revisions to 54-55 for the appeals board, is that just clarifying that language, or are we changing the appeals board makeup?
So I was getting to that next.
Oh, okay.
But that's okay. What was originally proposed when we did some research did not match up to the national standard, and it also did not match what the building department has done. So in order to match what they do and to be more consistent, we are also adopting Appendix A out of the International Fire Code.
Okay.
So that we can follow that for that appeals board.
Okay.
That was a change since last time. And that's the second proposal and the last proposal for Chapter 54.
Okay, thank you.
Okay, the next section is chapter 66. There have been no changes to this chapter since we last met. We've had several conversations with, some of the commissioners. I know that some of you have also spoke with some of the residents in the neighborhood. We've also met with them, and as well as the county attorney's office to talk through this. But just to hit the highlights, as you'll recall, the changes to the historic preservation ordinance are really to provide more clarity. There's a new definition for building, whereas that hadn't been included before. Again, just providing clarity in terms of what standards would be used and determining whether or not a certificate of appropriateness would be issued. Also, we changed the language that currently refers to immediate neighborhood to historic district, so that way it's clear which area we're taking into consideration whenever we're reviewing historic certificates of appropriateness. I'm glad to answer any questions.
There has been discussion about how we determine immediate neighborhood, and there's disagreement perhaps amongst residents and staff how we should define that. If we walk away without that term defined, or if we were to hold this, would this cause any detriment to the function of the Historic Preservation Commission?
So with regard to the immediate neighborhood, and the reason that the language was changed from immediate neighborhood to the historic district is the historic district is something that's very clear. There's a map that identifies it. It's easy to identify exactly what area are we talking about. To your question about whether or not holding this to further define immediate neighborhood would be detrimental to the Historic Preservation Commission. There is an applicant that we expect is going to be submitting an application soon, and it's one that we've seen before. So whatever comes forward will be considered under the current code. The Historic Preservation Commission will continue to function just as they have. They'll continue to function under this code. Any applications that come in will be reviewed under this code, the current code. So that may, it may keep us in the cycle that we've been in. And frankly, staff does not recommend any additional changes to the code.
Okay.
Jessica, I know in talking to some of the folks that are involved in historic preservation things, the concern was that the manual that's referenced here, the Secretary of the Interior Standards for Rehabilitation and Guidelines, talks about rehabilitating historic buildings. And the issue has always been not so much that, but more new construction, because I know the one that we went through numerous times was new construction.
Correct.
So my understanding is that there is a consensus among some folks that that the rehabilitation manual really doesn't address new construction.
And our historic preservation planner, Mandy Elliott, has looked at this. The language that's in there, and the standards that are referenced are pretty typical of most historic preservation codes. It's something that's frequently referenced, the Department of the Interior standards. One thing that Mandy and I were talking about recently is, you know, it's clear that the intent is not for new construction to look like the old construction. You know, best practices in historic preservation call for new construction that is in keeping with, but that it's clear what's old and what's new. I don't know if Jason or Mandy are here and want to add anything to that. Jason, do you have anything to add this morning? Okay.
So do these changes mirror the state definition of historical preservation areas?
There is a model ordinance, and I think that's where perhaps some of the confusion has come in, is that there is a model ordinance that has been prepared decades ago for historic preservation. Cobb County's ordinance, to some extent, matches that. I mean, it sort of reflects that to some extent, but as far as the State Historic Preservation Act, when we've reviewed it, there's nothing in this amendment that is inconsistent with the requirements of the State Historic Preservation Act. So we are confident that we are in line with the state codes.
So where are we different?
I'm sorry?
Where are we different than the state code?
We are not out of line with the state code. Are you asking with regard to the model ordinance?
Yes, I mean, because I just, you know, following up on Commissioner Ott's comments here about new construction, having some similarity to what's already in the area.
Mm-hmm.
I mean, the issue then becomes, what does that mean, all right?
I agree with the chairman. Does the state address new construction versus rehabilitation? Does the model ordinance?
I'm gonna let Jason Gaines come up and speak to that.
Sure.
Good morning. The state code, it doesn't specifically speak to new construction, but there are elements in the state code and elements that you'll find in a lot of local ordinances as well that basically mirror the direct content of what are in the Secretary of Interior Standards for Rehabilitation. So it has been, those standards have been tried and true as appropriate for both rehabilitation, renovation, and new construction.
So I guess my question would be, after we just had Jay Westbrook come up for fire marshal, where instead of making our own county code, we said we're just going to follow state standard. Why would we not? Is there something that's more restrictive with ours, or why would we not just follow the states?
There's nothing more restrictive than in this code, there's nothing more restrictive than what's in state code. Again, like what Jessica said, we have a model ordinance that was used by many local governments in the state to craft their local historic preservation ordinances, and then there's state code, which kind of governs the entire historic preservation process statewide, including what HPD does in terms of nominating historic districts for national recognition. So they're two distinct different things, and there's nothing in our local ordinance that is in conflict to or more restrictive than what is in state code.
Commissioner Gamble's got a comment there.
I think clarity is going to come. Let's go back to the conversation we had in my office yesterday.
Okay.
Because this brought great clarity to me in regards to this code. The Concord Historic District, while we have it shown as historic, it is not recognized by the state as a historic district. Jason, can you elaborate on that for us, please?
Okay, so State Historic Preservation Office is basically the conduit to have local districts nominated for national recognition. And the Concord District has been submitted to the state in various iterations for national consideration as a national district. And multiple times it has been denied by the state for a variety of reasons, namely the presence of the East-West Connector and the presence of the Silver Comet Trail. So, the state has reaffirmed to us that this district would not be considered for national recognition.
And then also what I found interesting in our conversation is that essentially when this area was designated a historic district, there was no design standards ever put in place. So of the whole area, there's 40-some houses, only 6 of them have the historic features. And I think that is why it has been difficult to enforce the historic preservation standards in the area. Am I correct on that?
Correct. 42 parcels within the district, 6 of which have historic features, correct?
Yes, I mean, this is wherein lies, the controversy of this code, and making these changes will result in a different outcome than even the recent hearing that we had with the property there. If we make these changes, it could direct a specific outcome. And that's the concern of the community. And I know at some point we need to make a decision on this. My hope is that if we do change the code, that we can do it in concert with, in greater discussion with the residents that are there. And perhaps at least there'll be understanding why we're putting forward certain provisions. Right now, the way that it's written, we are going to create great tension with those that live in that historic area. And I would just ask for the board's consideration for us to at least have some opportunity to discuss this a little bit further.
Commissioner Burrow.
My concern is the case that, is it still on appeal or pending?
No, it is not. The most recent application was withdrawn by the applicant.
Okay.
However, Commissioner, the applicant is bringing it forward again.
Right.
And has
but-
already done so.
Right.
So this will have
So-
a direct impact.
What do we have in place, or what would this propose for new construction, if it's just addressing reconstruction or rehabilitation of an
No,
existing
the
structure?
revised language references both rehabilitation, renovation, and new construction, and it refers specifically to the Secretary of the Interior standards.
Okay, so it does apply. New construction, the
Yes.
standards do apply to new construction under
Yes.
the revision. But we don't have anything currently to address new construction in the code.
Nothing explicitly, correct.
We've just been going by the national standards.
Correct. Or design guidelines if they're present, like they are in Clarkdale. One thing about that I'd like to say is design guidelines in a lot of historic districts, if you look at the specific content, you'll see where it mirrors the Secretary of the Interior standards. And that has been proven through our research of various design guidelines for historic districts in other areas of the state and the Southeast region as well.
Okay.
So my question is if the state doesn't recognize this as a historic district, can we apply state standards for new construction to it?
Well, it's not necessarily a state historic district, it's a local historic district that is in alignment with what the state provides for local designations. Where The state would come into play, like I said before, is for a variety of things, but in this instance, nomination as a national district or a nationally recognized historic district, which is not going to happen. As far as, oh, Mandy, you want to say something? As far as, again, as far as the state, there's no state historic district. This is a locally recognized historic district.
And nothing precludes us from considering other standards, I think, with how we evaluate our application, but I think that in lies the challenge is that this is such a
Well, the
unique.
most surefire way to do it would be if there were design guidelines present. But the issue with that, in addition to the fact that only 6 of the 42 properties have historic features, is that the properties in the immediate vicinity, the features within the immediate vicinity of the covered bridge are all different. You know, they're all from different periods. They all have, you know, varying styles of architecture. They've all been renovated over the years. So, you know, if you were to try to create, you know, design standards or design guidelines for this district, what would they be? That's the question that we've asked ourselves that we can't clearly answer.
All right, so, yeah, I just have one last technical question. We as a county have the authority to designate historical areas, districts.
Through our historic preservation
We
ordinance,
can
that's
do that.
correct.
Okay, all right, that's my only question. Okay, thank you, appreciate it. Flee while you can.
Mandy, do you have anything to add?
No,
Mandy does. Come on, Mandy, she heads it.
saving you.
I'm curious to know if she has anything to say.
she'll come back, trust me. Because after public hearing, I'm sure you're all gonna be back on this. This is gonna be a great conversation.
We'll look forward to it. The next one, chapter 78, again, no changes here from the first public hearing. This is changes that have been made to the licenses, permits, and businesses chapter regarding health spas. The changes are to fall in line with legislation that was adopted by the state last year. So it's not any real material changes to our code, just mostly some language.
Okay, thank you. Parks and Rec.
Good morning, Mr. Chairman, Commissioners, Mr. County Manager. We had 2 changes, amendments per board comments. Both were in 9063. Give it that one. In 9063B, we changed the leash or lead line to be no longer than 10 feet at all times. And then in 9063D, under the discharging of firearms in parks, we added a statement after facility except for law enforcement personnel carrying out their duty. And those were the only 2 changes per board comments.
Questions from the board?
Questions?
Okay, thank you.
Thank you.
Okay, the next changes are in the zoning ordinance. The first one with regard to temporary land use permits, we've made no changes here, just deletes poultry on less than 2 acres from requiring a temporary land use permit. Again, no change here, just swapping out a graphic.
Hold on,
Yes,
let's
sir.
jump back to the chicken thing.
We're gonna talk
We're
about
not there
chickens
yet.
again too.
What's that? No,
We're not there.
thought I heard poultry.
Yeah, we'll get back to chickens. The next one, again, just swapping out that rendering in the purpose-built student housing with the one that reflects the language. Limited professional services permit, and this is where we had a number of changes based on our last meeting and speaking with Commissioner Gambrell. We also had some great feedback from the Cobb Chamber of Commerce on this. So basically what's changed here, let me pull up that section of the code. Basically what's changed here is rather than this being a land use permit, this would be a permit that would be allowed as a special exception. So it would still go through The process with regard to planning commission, it would still go through the Board of Commissioners. It would still be approved by the Board of Commissioners, but and Commissioner Ott, when you and I met about this, your point about the land use permit was that it is something that's temporary, and that's something we had also talked about with Commissioner Gambrill. It is something that's more temporary in nature. So with the special exception, this would be something that would, as long as that use continues on the on the property, would be allowed. But as far as the existing home being reused, that's something that is still in here. No more than 5,000 square feet of land disturbance. Plans to be approved by the Board of Commissioners, and again, it would be approved for a very specific use.
My challenge is, what would be the impact in areas like Austell Road where you have changing character of the area, which may encourage us no longer continuing the commercial use of those properties? Would they be able to still continue to use those properties commercially by right under this code revision?
Only if, okay. Are you asking for properties, if someone came in and asked for the special exception, if they would be able to continue using it?
Yes, without going through zoning.
They would be able to continue using it under the special exception as long as it's that specific use. If the use were to change, if they were an insurance office and they were changing to a beauty salon, at that point, the special exception would no longer be
So they have to
valid.
use it for that specific commercial use.
Exactly.
If we have a grandfathered use, let's say it's GC, and they stopped using that building for a period of time, and they would have to come in for zoning, they would still have to come in through zoning under this permit.
Right.
Okay.
This is only for single family. This is only for our district. So
For our
for a
district,
property that's
okay.
zoned GC, they wouldn't apply for this.
Okay.
And I think that when we talked about this, the whole time I've been up here, the board has wrestled with the fact that we have these land use permits, for example, that someone has a beauty salon in their house, and it keeps getting renewed every year for 20 years.
True.
And the thing is, land use permits were initially designed to be a temporary, to allow someone to get a business started and then move into a commercial space. And so what's happened is the board over the many years has continued to just renew land use permits under the understanding that the use that's being done is an acceptable use because the person has demonstrated that they're not interfering in the operation of the neighborhood and everything else. And so the idea here is to try to move away from kind of the misuse of land use permits and come up with something that identifies a use that the board has been approving year after year after year or every other year.
No, I appreciate that because we have a number of them across the county and the district. I just see the language where it only limits this to arterial roadways. So what do we do for those businesses that are deep in a residential area that are not considered arterials?
And I think the arterial, I think that it was kind of like taking baby steps, because when you create a new code or a new zoning category, you have to be real careful about not the things that you think you got it all figured out, and then all of a sudden somebody says, oh, well, you didn't have this part and I'm going to do that. So I think that initially the idea was, the intent was to try to move away from these land use permits that keep getting renewed. And ultimately, I think that you could probably, as you work through the program and see, the mechanics and coming into the board and all that, start then kind of opening up or getting deeper into, smaller streets and stuff like that. But I think initially the idea was to just kind of take a small step to start.
So you're seeing this as less of a risk if it's on a main road?
Right, because this would allow Jessica's staff and everybody to kind of get the process in place and then to kind of see as it comes through the Planning Commission and the Board of Commissioners and everything, and to kind of get that all figured out. Because, for example, when the county came up with the conservation subdivision, the CS, and then the OSC, the board couldn't undo the CS fast enough because it became very obvious. I mean, and that was a code that took a year to write. So I think that this was kind of, the idea, I think everybody understands the idea, but the thought was, let's not open the door to everything right away.
Okay, I see.
Yes, I just have some reservations about this. if they're gonna come in, well, first of all, there's a lot of arterial roads that are residential. And if they want a limited use, why wouldn't they just apply for LRO or something less intense in a residential area? I mean, we see that a lot, you know, in zoning, but, and then the other, you know, without having, if they've got 5 acres, not having to have, paving or whatever, when they come in for zoning, wouldn't that just be a variance or a step at that time? I think you're opening it up too many arterial roads, and the districts are different.
Well, I think the biggest thing is, and you keep referencing zoning, this does not change the underlying zoning category. Okay, so when you come in for zoning and you change it to LRO, you are now changing it from an R zoning to a commercial zoning category. This is simply a professional services permit. The underlying zoning, which would affect everybody on either side of it or across the street, does not change. And so you're not changing the land use map, you're not changing the zoning category, you're simply allowing, it's kind of like when we had the, and Rob helped me with what we called it, like if somebody bakes cupcakes in their house, cottage industry.
Cottage industry.
Right, very similar to that, where we allow those things. So the important thing to keep here in mind, it is not changing the underlying zoning. Because if you all of a sudden plopped LRO in the middle of a residential neighborhood, you've now done spot zoning. Whereas this is not doing spot zoning, it's just acknowledging that you're permitting a use that wouldn't normally be allowed under that zoning category, but you're not changing the zoning.
And, yeah, I hear what both of you are saying, because it impacts the zoning process, right? They would have to come in for a permit today.
Right, they would have to come in for a permit. What's different is instead of just going to community development and getting the permit, they have to come through the county as if it was a land use permit. Same, go to the planning commission, come to the board of commissioners. So it's not a permit by right.
That's today's standard.
No, today they would have to do just a land use permit. So really all we're doing is we're kind of separating out things that could be given an LPSP versus a land use permit.
And it will go through the same
Goes
process
through the
of the
exact
land
same
use
process,
permit, come to
planning
the Board of
commission.
Commissioners.
So they have to file an application, go through staff review, come to the planning commission, come to the board of commissioners. And so, you know, in the case you asked about, you could always deny it.
I thought when I see special exception versus a permit, my presumption is that it's going to staff and seeing if it meets the special exception, special exception without having to come to the board for consideration during the zoning process.
A special exception is always something that would require board approval, because essentially we're allowing them to do something, or you all would be allowing them to do something that typically they wouldn't be able to do in that zoning ordinance. So that would be something that would certainly require board approval and the full public process.
The benefit of this code is to allow them a greater duration in the 2 years.
There are a few benefits, you know, to Commissioner Burrell's point about why not just rezone to LRO, and they could certainly apply for that if that's what they wanted to do. I think the real benefit of the special exception versus rezoning is for you all, the board, and also for the residents in those areas that maybe haven't fully transitioned to a commercial area. It's on an arterial road, but it's still primarily residential. It gives you an opportunity to have some very small scale, very low intensity commercial use that it's still gonna look just like a house. It's not gonna look any different than it did before. It'll still very much be a residential structure. Or at least in character, will still be residential. They'll have to meet ADA requirements, all those sorts of things. But it won't change it doesn't open up the range of uses that a rezoning would, because it's use specific, and it won't have the same impact on the character of the greater area than rezoning.
Commissioner Cupid, we actually have something similar to this. It wasn't achieved this way, but the Dillon Insurance Agency that's there on Macklin at Villa Rica. That's kind of like the model that we use to set this code. Again, it was, you know, an older house. Really, you couldn't redevelop it to a subdivision. It was on the corner of Arterial, and it's served its purpose as a small business. The community ended up embracing it. because it kept the character of the neighborhood, yet allowed a purpose and use to be happen. So that's kind of, for a visual, that's kind of what we created this, envisioning that to be.
I perceive that, I just don't see how that varies from what we are able to do under the land use permit today, other than the time revision, because we can still
Well,
restrict
it's also
use.
the intent. If you look and read the intent of the land use permit, basically it's been being used for
And I know that's been a
outside of what the
challenge.
intent is. So this was just kind of starting to tighten up what the land use permit was supposed to be used for.
So this,
So is this a new category, zoning category? I mean, if they're still coming through,
different.
this a permit, like a land use permit. So they're still coming through zoning,
Yes, ma'am.
planning, full blown.
Yes, ma'am.
Planning commission and zoning, and a hearing. And it would stay R20 or R15 or whatever the current zoning is. This would just give them a permit to have an office or whatever they're doing
Exactly.
of these acceptable uses.
Exactly.
This is like a
For a
different kind of
permanent-
permit.
And they wouldn't have to
Okay.
come back every year or 2 years to renew it.
That's exactly right. And, one of the concerns for a new business, someone who maybe they're starting their business, they're not in a position where they want to go out and get the full scale tenant space, and maybe they are looking to reuse their house or a house for, their insurance office or what have you. The benefit here for them is versus the land use permit where it is temporary. They've got some, they can have the expectation that this is something that will continue as long as they are on that property, that, the use doesn't go away. They don't have to keep coming back and getting it approved and hoping that it gets approved. So that gives them more security as a new business owner. But also, again, really, one of the key points here is that it also keeps the area residential.
So are they allowed to expand the property that's there, the building that's there? Or just interior renovation, or
It
what,
would-
to conform to these uses?
It would be primarily interior renovation. If they were going to make any changes to the house, it would still have to look just like a house. They wouldn't be able to expand more than 5,000 square feet, in terms of land disturbance, so you can't go in and put in a huge parking lot or anything like that. But things that they might need to do to a house, like for instance, to make it ADA compliant or to make it a building that really can be used for that low intensity professional use.
And
They
they'd
would
still
able to do
be
that.
required to have a business license or what?
Absolutely.
And Commissioner Burrow, that if you look at the second, it says no ground disturbance requiring an LDP. And then it says site architectural, landscaping, signage, and lighting to be approved by the BOC. So when it comes through that first time, any changes they make after that, it's gonna have to come back to the board. Because it will have been approved based on what was submitted with that initial application. Now, I understand, like you said, ADA compliance and all that.
Right.
But as to expanding it, the way that you have it written here, they would have to come back.
Well, and just one point of clarification on here, that reflects the old language. The new language, just so that we're all very clear, is that parking signage and lighting is to be approved by the Board of Commissioners. So if they made some minor changes, and then it does say in the language, in the code, existing single-family detached dwellings shall be reused, residential facades shall be maintained, and any new construction has to be architecturally similar to the existing building. So if they did add on to the building itself, it would be just like adding on to a house, or should look like you've added on to a house. It would absolutely be our residential.
But an individual commissioner in approving the permit could put in there that any changes would have to be signed off by the commissioner.
Absolutely, certainly,
The same as any other permit that we do.
certainly.
When it comes to zoning.
No, it could
See,
be put
that's
in,
the
it could be put in
problem.
as part of the approval that any changes to the structure has to come before the district commissioner. I mean, that happens on land use permits.
Right. Yeah, so this would still come to you all, would go to the planning commission, we'd post the sign and everything, they would review it, they'd make their recommendation along with any stipulations that they recommend, as well as DOT, fire, whoever else may have, from staff. It would come to you all, you would have a public hearing, you'd review it. If you had additional stipulations you wanted to add, just like with the rezoning, you'd be able to do that, but it doesn't open up the whole can of worms that rezoning does in terms of the uses that would be allowable on the property.
So is this property now for tax purposes residential or commercial?
I would defer that to the tax assessor's office. That's not really a zoning
Well,
concern.
when we grant a land use permit, we don't change the designation.
Just asking. It's a business now. It's not a residence, it's a
You have a
business.
business license though attached to it.
taxes.
Well, but is it a business building or is it a residential building? I get the second point that, not just this issue, but we seem to be backing into an area, maybe this is a new era in America where more people are working out of their homes. But we have three proposals to consider today that are potentially changing the neighborhood of our neighborhoods. This is one of them. The poultry one's another one, and then the short-term rentals is another one. So I just seem to, I call it mission creep. We're just slowly backing our way into something that the neighborhood was never intended to be. And just have a concern about all this. We're gonna wake up one day, because I see this sometimes where, we have a reapproval of a LUP, and that people, even though they have done a great job of never bothering a neighbor, one day somebody wakes and realizes they didn't have a business down the street from them, all right?
Wait till they wake up with chickens.
Well, that's just a general concern that I have here about some of these.
That's understandable, sir, and I think
Couldn't resist.
I think that some of the mechanisms that may prevent some of that with regard to this is, first of all, that it would be on arterial roads, which, typically are transitioning, but also that you all as the Board of Commissioners, and also it'll go through the staff review, but you all in the Planning Commission, the public will have the opportunity to come out and review each request on its merits. And if there's one that's appropriate, you can approve it. If there's one that you feel like just really is not appropriate for the area, then that's something certainly that you all as Board of Commissioners could take into consideration and potentially deny. So that's why we certainly want to be sure that this comes to you, that you all are the deciding board as the elected representatives on these.
Okay. All right. Thank you, Jessica. Any other questions? All right, thank you.
Okay, the next one in the zoning ordinance. No changes here. This is the property maintenance where we've expanded the gutters and shutters section just to make it clear that gutters need to be kept free from obstruction. The one change that we have to the next section is that we've added roofs. We've added roofs at the recommendation of the Planning Commission to the list of house features that need to be maintained, the exterior house features. So that's on page 24. So what that basically says is doors, windows, trim, porches, roofs, decks, etc. need to be maintained, that the exterior surfaces need to be treated with paint or stain or what have you, and that does need to be maintained in the future.
All right, I got a question about this one, and I'm going to use the house on Paper Mill as an example.
Yes, sir.
Okay, so here we are, we're adding more things for your staff to enforce. And we know that, for example, how long we've been dealing with it now, a year and a half, that house on Paper Mill that building inspector said is not livable. It has probably 90% of this statement in 134-134. We've been to court how many times? 3, 4, right?
I don't even know. Predates me.
Right, and the house is still there.
Right.
So the problem I have is, this all looks great on paper, but number one, we can't enforce it. Well, first off, we can't even look at it because we don't have the people to go out and look at it unless the neighbors call. And even if they call, then when your folks go out, we put stop work orders. Then we end up in front of the judge. The judge says, oh, well, and then we don't have the support in the courts. And so now, if we have an example on Paper Mill Road that the neighbors have been living next to for a year and a half. And it's not your department's fault. Right. My concern is we're putting stuff on paper that just isn't gonna, the community is gonna think that we're gonna tackle this, but the reality is we've got to come up with a way to get the courts or write our code in such a way that it will stand up in court. When somebody, what do? They ask for a jury trial. Right. Well, now we're talking 6, 8 months down the road before we ever get in front of a judge and a jury, and nothing changes. Right. And in the particular case that I'm talking about, how many times has stormwater had to go out because of the mud that has gone across from this property to the neighbor's property because the work that was done by this person, they didn't even have a permit to do. So my concern is, and you and I talked about the gutters, the trees in the gutters. I mean, I think all this looks great on paper, but I just don't think that it's enforceable with the staff that we have, the number of staff we have, and what's going on in the courts.
I think I want to first of all clarify the Paper Mill Road case was a little bit different because that was a nuisance abatement case and it went to court for nuisance abatement. What this does is it helps us get out ahead of those properties before they become a nuisance abatement case. If we had something in our code where somebody could have called and said, this house has not been painted in years, we probably could have tackled it before it became full-on nuisance abatement.
True, but what happens is when you go out and if you find a violation of the code, you issue a citation. And they're given 30, 45, they're given a certain number of days to come into compliance.
Correct.
If they come into compliance, case is closed. Okay, we solve the problem. If they don't come into compliance, you go to court.
Right.
And so, yeah, the Paper Mill Road one got way out ahead of everybody, but the problem is here, if the person decides not to follow the citation or deal with the issues in the citation, that's when we end up in court. And the folks that are habitual know that if you ask for a jury trial, and what happens is the minute they file something in court, we pretty much have to set aside any enforcement of what we're trying to enforce. So, I mean, I hear what you're saying. Yes, I know Paper Mill Road is an extreme example. But the fact of the matter is, in every one of these, everything that we have here in the code, that your inspectors go out and cite somebody for, they have 30, 45 days. And if they don't do it, then we're going to court. So it's a cycle that I mean, you know, we're working your folks to death. And we're adding more and more things. I mean, I understand that we're trying to fix up the community, but the fact of the matter is, it just, all we're really getting out of it is working your staff to death. And we're really not, I mean, the only way, and there was a lot of discussion about the blight, what we did with the blight, where that was based on increasing the taxes and all those things. I mean, until there's actually some meat in the penalties and that it's enforceable, I just don't really see how all this is doing is just adding workload to your staff.
I talked to Kathy Pickett about it this morning and asked her, you know, she actually put together the language for us, and this is something that we had talked about with Commissioner Cupid as our liaison commissioner. And I asked her, to your point, you know, she said, you know, really these are simple citations to write. This is, you know, if you go out there and the house is in disrepair, there's been a blue tarp on the house, on the roof for 3 months. And that's a pretty simple citation to write. So we get a call, we go out there, we address it. She didn't feel like for her staff it was going to be a burden. But to your point, I understand your point about the courts, and that's something we're dealing with on all of our codes. It's not just this one. It's something, if someone just decides they're going to continue parking their vehicle in the grass right by the road, regardless of how many citations we issue. And, you know, yes, some of them they know how to play the system. That's a separate issue that really we are looking at. In fact, Kathy and I have been having some conversation with Brian Johnson in the county attorney's office, and we're really looking at what can we do. Is there something how can we keep code enforcement cases really in magistrate court? So that's something that absolutely we've got to take care of, and something that we're very aware of and working to accomplish. But I think the real value to this ordinance is that, you know, whenever we do get these calls, and we do get calls, you know, my neighbor's house looks terrible and it's beyond just litter or what have you, that it's actually the house itself is in disrepair, but not nuisance abatement. You know, this helps us to have some enforcement mechanisms on some of those properties that are not quite to nuisance abatement case. Our goal is always compliance. We're not trying to bring people to court and issue citations and collect lots of fines. So if there are ways that, you know, we can work with them and help put them in contact with resources if that's an issue, those are certainly things that we want to do, and our code enforcement officers are very committed to trying to be a positive force in the community instead of just bringing down the iron fist of the government. But I appreciate your comments, and I certainly see your concerns.
Oh, I was going to share that I agree. I mean, this is a challenge for many of us in the district, and it may be others as well, with the amount of time it takes for these cases to be dispositioned. I am encouraged by code enforcement support of the code and us being able to tackle some of these things before they become larger issues, but you're dead on with the challenges. I hope that there's a way that we can address these in a different process.
I, I understand it is frustrating for, I have examples too in my district of specific properties that have, we've been out, cited them, over and over, they go to court, but we're at the mercy of the judge at that point. But I still think that this, gives us more teeth to enforce, and, we're still at the mercy of the court, but that's for more discussion and, how we can address that. But, I would support this for now if code enforcement is, agreeable, and from what you said.
Jessica, has there been any thought about maybe having Brian and Kathy sit down with the magistrate judges? And, since we're sitting here trying to write the code, maybe it would be good to sit with the judges that ultimately are not supporting our code and maybe say, hey, is there something that we're not writing right? We're not putting this right? Do we need to address it a different way? Because it sure seems like if the end result is not what you want, let's go to the end result and say, what is it that you need to be able to enforce what we're putting in the code?
Yeah, so we're certainly going to be speaking with the courts as well. A lot of times what happened is the frequent flyers you mentioned, those sort of figured out how to play the system. They recognize sometimes that if it gets out of magistrate court and goes on to state court, there's so many things that state court's trying to adjust, and code enforcement is just like this little tiny bit. So that's where I think the magistrate court judges, they do a pretty good job of working with us on our code enforcement cases. So that's really going to be key, is working with our county attorneys and also with the state court judges to, see what we do need to do in order to make sure that we're getting these code enforcement issues addressed once it gets out of our hands.
Okay, next section.
All right. Next section, small change. The language before said second-hand store here. And again, this is where we're proposing to add thrift store as an allowable use in NRC. Before it said thrift store, second-hand store. Commissioner Burrow suggested at the last meeting changing that to consignment store, so we've changed that language.
Is that just a convention change, or is that change the type of
It's
thrift store?
semantics, I believe.
Because there's some specific consignment stores. Are you looking for this to only include consignment, or does this capture thrift?
This was a result of 2 other business cases that I had last year. One was specifically a Goodwill store going in a shopping center, which was approved and on consent, and no issues. The other was a consignment store for resale that was up at Highway 92 near Sandy Plains. That was a renovated house for a consignment shop and an LRO. So it would be, we changed the language from
Thrift store or
secondhand
secondhand
store
store
or
to
secondhand store to
consignment store.
consignment.
So it covers both consignment resale as well as thrift, like your Goodwill, or it would cover both of those.
Yeah,
uses.
and I know we've gotten letters from Mapleton Improvement Coalition because of, this applying to all the districts throughout, and some concern of, for lack of a better word, junk stores rather than thrift stores, but, and I see that concern, so, it's gotta be already zoned NRC. It's just allowing this, rather than an exception, it'll be allowing it as an acceptable use under NRC. So if the board doesn't agree with that, then it'll just continue to come through other business as an exception, correct?
That's right. That's, thank you.
Okay.
Okay. Okay, traffic and parking, we did have some changes to this section. Per the Planning Commission's recommendation, on page 25, we removed the language that says, "and the property is used for agricultural, equestrian, or other farm-type uses," so it would be allowable on any lot that's 5 acres or larger in an R district. And we changed gravel to non-hardened surface. And speaking with Commissioner Gambrell, there were some concerns about, you know, your agricultural properties where maybe there's a tractor parked on the grass. Well, this, by saying just non-hardened surface, it could be gravel, it could be grass, what have you, just not a concrete or paved surface. And then we added to the concerns about having vehicles parked in the yard all over the place, we added some language to say that no vehicle shall be parked within 50 feet of the public right-of-way unless on a treated and hardened surface per the BOC direction that we got here. Glad to answer any questions about that.
Okay, Jessica, I know we were emailing. I would suggest changing this to 2 acres, because that's pretty much where the farm agriculture uses come in, even though we've removed that. So I would suggest moving this down to 2 acres instead of the 5. And then there's also quite a lot of concern about the added language as far as the no vehicle shall be parked within 50 feet of the public right-of-way. Some houses aren't set back. You know, they're only 25, 35 feet set back. So to sit there and say you can't be 50 feet from the right-of-way, technically you're not going to be able to really park on your driveway. And we do have examples, I know in my district, of where we do currently have gravel or hardened surfaces, but they wouldn't fall within the 50 feet of this right-of-way clause. And while you can sit there and say they're grandfathered, if they sell the home, would the new owner then be able to still park since they're technically within the 50 feet of right-of-way?
As long as they're not making changes to the property itself, then it still keeps its non-conforming status even as it changes owners.
Okay, so personally, I would like to see that language removed.
And Jessica, since this is in section 134, if someone has less than the 5 acres or the 2 acres or the 50 feet, they can always come in and ask for variance.
Yes, sir.
Yes, that would be my suggestion. I mean, this really opens up Pandora's box for less than 5 acres. There could be larger properties, again, in areas where there are non-activities that are not akin to what was originally proposed, agricultural, equestrian, or farm-type uses that can be subject to this code, and we can have parking just rampant all over these lots. And now I'm hearing less than 50 feet to 25 feet. I mean, this could just create a mess in areas where we may have residents parking on non-hardened surfaces today. I like the compromise measure that you propose, but loosening that anymore now takes us out of just a District 1 consideration and doesn't take into account the changing character or the different character in other districts.
Okay.
No changes to the Mableton Parkway at Veterans Memorial Highway Overlay District. Again, that's just bringing the applicability standards into the code. The backyard chickens, we don't have any changes to the code that's been proposed, but in speaking with Commissioner Ott and Commissioner Gamble yesterday, I think there may be some
Right,
discussion.
so, Mr. Chairman, one of the things that Commissioner Gamble and myself talked to Jessica about was that, in essence, the way this is written, there's no way that staff or anybody else is verifying that they're meeting these requirements. And so what Jessica did was I asked her to go and she looked at how Marietta does it. And they have an online form which you have to fill out and then bring in, I believe, to get signed or stamped by the zoning division. And so I have asked her to look into creating something similar. And in essence, the form would have the property information, and it would basically, the person would be saying how big the lot was, how many hens they're going to do, show where the chicken coop was going to go, basically all the things that are kind of like in the rules here. And then they would have to bring it by zoning and just basically get it signed off, and then they would be, and on this form, as in Marietta, it would list all the rules too. So that then that way, there is no doubt that the person before they got the chickens, because otherwise there was a whole lot of reliance put on the people that live in the neighborhood to enforce the rules, and so in talking with Jessica and looking at what Marietta has, I just think that it would be better to add that this online form be created and be required to be filled out and brought to the zoning office and, be verified by staff.
It would essentially be an over-the-counter or online permit. I
Right.
think we could offer both options.
Okay?
Do you want discussion or no?
Yeah, sure, go ahead, Commissioner Burrow.
Yeah, I feel that it should stay as a land use permit, a case-by-case basis. Because I think this opens it up to platted subdivisions and neighborhoods that may be opposed, but they won't get the opportunity of a public hearing to say that for the applicant to say that they have all their neighbors' approval with a petition or what have you, and it doesn't allow for any opposition either. It's just a form with, yeah, they may have to give notice as a requirement, but that doesn't state approval or opposition. So I think it needs to stay as a law. We reduced the fees to $75 over the normal land use permit fees that were, what, 200 or 300 before? So we reduced that a few years ago to make it more reasonable for individual residents to come and get a land use permit. So that would be my objection to.
Okay,
Okay, moving right along. Finally, short-term rentals, and there have been quite a few changes to the short-term rental ordinance that's been proposed, as and through talking with the Planning Commission. And we did, as you know, the Planning Commission held the short-term rental ordinance in their January meeting. It came back to them last week in their February meeting. They did move it forward with a recommendation that the board should also hold this. So they've passed it on. It's not in the ball's not in their court anymore, but their recommendation was that the board should continue to hold this. I'm going to hit the highlights of the changes because a lot of it was really just sort of clean up. For instance, we referenced a short-term rental certificate in there. Separate from the occupational tax certificate, it is one thing, one requirement. You come in and you get the occupational tax certificate. So we wanted to be sure it was clear that there was not another certificate required. The more material changes that were made was, first of all, to change the response requirement for the short-term rental agent from 30 minutes to 1 hour, just knowing how getting around Cobb County can be sometimes. Maybe getting somewhere within 30 minutes may be a stretch, but so we changed that to 1 hour. We added, just for clarity, that these would be permitted in our zoning districts and only permitted in residential structures with a valid certificate of occupancy. And this would eliminate tents, sheds, RVs, some of those other, I don't even want to call them structures, some of those other things that people might want to rent out as a short-term rental. We did change the allowable occupancy for short-term rentals to 1 adult per 390 square feet as shown on Cobb County tax records to come in line again with our single-family code. And then we also made it clear that the short-term rental agent could also be an agency. If you've got a property management company, essentially, that is serving as your short-term rental agent, as long as they can get there within the prescribed time, then that would be allowable. So anyway, as you know, the Planning Commission has recommended that you all hold this. There's also been, and I know I sent an email out to you all last week, the General Assembly is currently considering legislation with regard to short-term rentals right now. That would substantially limit the ways that counties and cities would be able to regulate short-term rentals. And that's it for me.
okay, thanks, Jessica.
All right, thank you all.
All right, so before we get into the public hearing portion of this meeting, let's all take a short break for, let's say, 5 minutes. because I'm sure the public hearing will go long, and I want to make sure we're all ready for that, so we don't have to take a break again. So let's take a short break till 10:30. I got mine. Just want to emphasize, again, this is the public hearing part of the code amendment proposals. So you get 3 minutes, followed by all the public hearing agenda items, say, then there'll be a public comment. But if you're in line against the wall here, you got 3 minutes to talk about all the things we've been talking about for the last hour and a half here, okay? So, and I'll make sure that even if you're not standing in line here, if you're just sitting until the line disappears, I'll make it very clear that I will not close the public hearing until I've, reiterated a couple times, has everyone been heard, okay? So with that, what we ask you is that you come up and let us know who you are, where you live, and 3 minutes, and with that, I now declare this second public hearing open on proposed code amendments. Oh, by the way, there's no limited number of speakers. I just want you to know that my grandson graduates in May, so.
We have 49 at once.
So just want you to know that. Okay, with that, first one, good morning.
Good morning, Mr. Chairman and Commissioners. I'm Carol Brown with Canton Road Neighbors. Thank you for the opportunity to speak. I first want to note that one of the things that jumped out at me the more I looked at these amendments is that short-term rentals and limited professional services permits are opening up all our districts to commercial uses. We support on 134-291, we support the Planning Commission recommendation to hold short-term rentals, to consider limitations on where they would be allowed and potential limitations on the time that a home could be used as a short-term rental. We believe that there is a need for regulation of this very large industry, but that these short-term rentals should be permitted in RAC, CAC, near tourist attractions and sports venues, and not permitted in platted single-family subdivisions, like R15, R20, RSL, RA5, and suburban condo. We want to thank you for the proposed language change in the Animal Ordinance 10-11, General Control, removing the language excluding cats or accepting cats from this, and want to remind everybody that responsible pet ownership does include spay, neuter, and rabies vaccinations, which are required by Georgia law. We also want to thank Best Friends and Good Muse for the fine work that they do with the Trap Neuter Release Program. Finally, I want to speak on 134-39, the new limited professional services permit. We oppose this as drafted. It opens up many arterials in District 3. Canton, Sandy Plains, Bells Ferry, New Chastain, Piedmont, Shallowford, Jamerson, Wigley, and Blackwell. Rather than allowing a homeowner to use a residential property and apply for commercial use, this could create, it could create a hodgepodge of commercial uses, which rather than impacting, which would impact a whole neighborhood. The same thing can be achieved with any low-impact zoning like LRO, LRC, and limiting it to one use. And I just think that this is probably not good as drafted. There are also older structures in our district on arterials that shouldn't be, that really need to be rebuilt. And it's potentially, it would allow these to have a continued life as a commercial use when they really need to be rezoned, rebuilt, totally renovated. Wonder if it's not possible to more narrowly tailor this so that it would be allowed in areas with much larger lots, rural residential, R80, R40, where...
Ma'am, I'm sorry, your time is up.
Thank you. Thank you.
Good morning, Teresa Stendahl, Autry Church Road for the last 45 years. Would like to speak to section 134-272 regarding traffic and parking. Appreciate the responses I received from the board to my email. Two concerns remain are the 25-foot paved or asphalt apron. I live in a neighborhood that surrounds Lake Allatoona and core property. many of us in the neighborhood, of the 75 or so homes, there are 20 with gravel driveways. I understand from Ms. Gwynn's response to me that yes, they're grandfathered in. However, grandfathered for now, what happens when the property sells? We believe, many in our neighborhood, that we're doing the environmentally correct thing by having a gravel driveway as opposed to an asphalt or paved driveway. Most of us didn't have any choices. They were there when we got there. On the other hand, I think by and large, a 25-foot asphalt apron, there are homes in our neighborhood that only have a driveway that are 20 feet long. They have gravel now. At the very best, I think there's a lot of discussion that could be had that has not yet occurred, that has a very tremendous impact on those of us who don't fit inside the box that the county may be trying to achieve in this language. I would respectfully request that you hold this and allow us to have more conversation with ComDev and with the board individually or collectively so that we actually can find a way to meet your needs as well as our own. Thank you.
Thank you.
Good morning. My name is Carrie Millay. I live in East Cobb. I've been a resident of Cobb County for probably about 20 years, in East Cobb for probably about 15 years or so. I am also an executive member of the Short-Term Rental Owners Association of Georgia. I am here, though, in my personal capacity, also to make a plea to the Board of Commissioners here, because there is a perception that short-term rentals will bring or change the character of the neighborhood. I want to put a face on short-term rentals. I own my one home in East Cobb, bought it with my husband in 2012, and my husband unfortunately passed away, leaving me with bills that were made for two. We always thought that I could manage that house on my own income. Our property taxes, unfortunately, have escalated to the point where it has become unmanageable. I've had to make hard decisions. I want to keep my home. I live in my home. I have opened my home up for rentals a couple weekends a month in order to be able to pay my bills and so that I can continue to live there. The last thing I want is to change the community in which I live. As I said, I live there. Some of the proposals as currently planned would make it absolutely impossible for people like me. Now, I'm not the only one. I know the community in which I live pretty well. I also know a lot of the people that are short-term rental owners. They're people just like me. We're just trying to make ends meet. I'm urging you to allow and to work with the short-term renters, with Straga, in order to help draft regulation. Yes, regulation is needed, but also the gig economy is here. You can't put that genie back in the bottle. I'm asking you to help work with us so that we can have the tools that you need to preserve the community, but also so that we can continue to serve the community as well. By the way, most of my renters are actually Cobb County citizens. I rent to that area of the market where short-term people need a short-term residence because they've got damages to their property, or they've got needed repairs. So most of the people that I rent to are people that I actually know, a lot of them in my very subdivision. I wanted to thank you for your time today. Thank you.
Thank you, and we're sorry for the loss of your husband.
Good morning. My name is Kathy McClure. I'm an attorney, and I'm here in my capacity as a board member of the Short-Term Rental Owners Association. I'm also a short-term rental owner. We're here today because we want to urge the commission to table the ordinance at this time. I want to reiterate what Ms. Malay said. Short-term rental owners are Cobb County, in Cobb County, or for the most part, Cobb County residents paying taxes. And they are offering a service to not only to people coming in the community to visit, and also to residents residing in the community. The people coming and staying in these places are often people who are there to enjoy family occasions. They're there for weddings, they're there for funerals, they're there for all manner of graduations and that sort of thing. Short-term rental owners we have created an economic food chain. There's a reason why the gig economy is here to stay, and that is we are contributing guest dollars to Cobb County and to the local community. We owners improve our properties. We hire contractors. We employ electricians and plumbers. We improve our residents. And our guests spend money in the community. They're there to go to restaurants, go shopping, go to attractions, and that sort of thing. On April 1st, Cobb County, and I know you commissioners probably already know this and are happy to hear it, as are the taxpayers who are in the room today, will start collecting taxes, sales tax. The state will begin collecting sales tax, and it will also be collecting Cobb County sales tax. So short-term rentals are going to be contributing to your bottom line. We urge the commission to withdraw this proposal at this time. We ask you to work with us to improve this ordinance because we believe it is preempted by, it would be preempted by House Bill 523, and also because it violates an existing ordinance, statute. OCGA 3674-30B, and I pointed this out to the county attorney, this statute prohibits local governments from requiring the registration of residential rental property. We believe this ordinance plainly violates that statute because it requires an occupancy tax certificate to operate. The ordinance as drafted also violates this same code section because it creates the county's ability to inspect a short-term rental without probable cause. The statute that I've referenced requires local governments to have probable cause.
Sorry, your time is up.
Thank you. We look forward to working with you to improve the ordinance.
Good morning. My name is Robin Meyer. I'm with the Mableton Improvement Coalition, and I want to speak quickly on several different sections. First up is property maintenance. In section 134-33, gutters and shutters, we fully support the addition of gutters being kept free of obstructions. In the next section, section 134-134, exterior building maintenance, surface maintenance, we strongly support the addition of that to the code. We appreciate the conversation that was had about the ability to enforce these requirements, but honestly, that's the case with every single thing in the code that relates to property upkeep and following the zoning district requirements. So I think that Ms. Gwynn is quite correct that this might put some property owners on notice that when a property begins to slide, that slide is being recognized and perhaps head off some of the nuisance abatement cases. And because so many code enforcement cases are honestly solved with the initial visit by the code enforcement officer and pointing out the problem, we would hope to see some improvement in some neighborhoods even without having to go to court. The next section that I want to speak to is 134-213 that would add thrift stores or consignment stores by right to the NRC district. We are strongly opposed to the addition of this use in this district. Thrift stores, resale stores, consignment stores, secondhand stores, whatever you call them, they come in all shades and sizes. We may be thinking about a Goodwill store,
but every kind of used merchandise store that you can imagine will fall under this category. We believe that the code is correct as it's currently written, and it allows each of these uses to come before you and to be vetted for the specific management of that property. Will there be donation drop-off? Where will it be? How will the traffic be handled? How will the inevitable overnight deposit of goods at the front door be handled? Those are all, how will outdoor display be enforced? Those are all issues with virtually all of these stores except the very creme de la creme. And in all candor, in my community, we don't have too many of those creme de la creme uses. So please do not adopt this change. And then lastly, on the issue of traffic and parking, this is not an issue that we had looked at very deeply, but the conversation today that would reduce the property size to 2 acres and apply this concerns me greatly. My community is full of 2-acre parcels that are very visible from the road, that may have a garden big enough that it could be classified as a farm. And on that property, I can certainly see.
Ma'am, I'm sorry, your time is up.
Thank you. Problems arise.
Thank you for the opportunity to let all of us come and have our voices heard. My name is Steve. I live off of Sandy Plains Road, and I will gladly say I have the best job in the world. I'm the operations manager for North America Diving Dogs. We have over 16,000 dogs in this country that compete with us in the sport of dock diving. I want to thank you for your amendment to quantify sporting events, because we currently hold an event in Smyrna as part of Wolfstock with Star 94, where we bring the dock and the dogs jump and everybody has a great time. We have in the past held events at Jim Miller Park and are currently looking at a very big national event that would be held there. Without the change that you made, we wouldn't even consider it. We wouldn't bring 400 or 500 dogs to Jim Miller Park for an event. I do want to talk to you as something else involved in my life. Excuse me. From the time I was in the military, I've worked as a dog trainer. That's how I got into the sport world. I would like to ask you guys to please reconsider your 10-foot leash law. It is unsafe. I am an avid hiker. I walk my dogs. I go to Kennesaw Park. I use the rails to trails right here in Cobb County. I witnessed someone walking their dog on a retractable leashes, which are of the devil themselves, but someone was walking at Kennesaw Mountain. A kid was running, playing, went between the person and their dog because their dog was farther from me than our lady sitting over there. The kid fell, scraped their face. Most people, when they're walking their dogs, are looking at their phones, listening to music, enjoying their time out. That far of a distance is a long way. It is not anywhere in the industry standards. We regulate 6-foot leashes, will not allow anything else, will not allow retractable leashes. That's why we have dog parks, that if people want to take and let their dogs run around and mingle, it opens up a lot of liability for the county. Because now, if I can give an example, this is 6 feet. I can control my dog from there. That's 10 feet. That's 10 feet from me, and I have to control my dog. And sir, you have your dog on 10 feet. We are as far away from each other as me and the county manager. Both of us hopefully paying attention that our dogs like to meet other dogs. That's not always the case. I have one that is CGC certified, but if another dog runs up in her face, she's an Australian Shepherd, she's gonna nip and say, hey, give me my space. And that can be an instant problem. I have to keep my head on a swivel when I'm walking her. So I would ask that you guys please reconsider and follow what other areas, what the American Kennel Club, what everybody else follows, which is the 6-foot lead. Thank you.
Thank you, sir.
My name is Pat Burns. I live at 10 Concord Road, Smyrna, Georgia. Thank you for your time and suggestions, and I trust it's been reciprocal experience for you as well, and you will put a hold on code 6682 and 6685. To clarify, Cobb County designated Concord Covered Bridge Historic District Cobb County's first historic district in the 1980s. Some of the buildings are on the National Register. There is an intact immediate area, as is this contiguous immediate area would be eligible for the National Register. Yes, there have been renovations. I have indoor plumbing. All renovations have been approved by a historic preservation planner and in compliance with the national standards. The new code changes severely diminish the value of historic districts, all historic districts, and invalidate the need for a historic district by the Historic Preservation Commission. With a hold, we can move forward together with community development and historic preservation to come up with a plan Cobb County can be proud of, as Charleston, Atlanta's Inman Park, Ackworth, Monroe, and Madison, Georgia. It was a shock to me last week to be told by community development that Cobb County was, I quote, under a court order to address the deficiencies with the code, unquote. However, this document was not shared. That is not the Cobb County way. CDOT's leadership is an example of sitting down at the table and coming up with a mutually rewarding preservation goal. This is the Cobb County way. Again, I ask for holds on codes 6682 and 6685. This also keeps us in line with the state of Georgia. Thank you.
Thank you.
Good morning. My name is Sarah Rylander. I live in Ackworth in District 1. When I first moved to Cobb County, I visited Petland while I was killing time between classes at KSU. I saw an adorable Persian kitten in one of the windows. She had green mucus coming out of her nose and one of her eyes was crusted all the way shut. The price tag on the window was $800. I asked an employee what was wrong with her. He told me it was just a cold, nothing to be concerned with. I didn't much care for that answer, so I contacted the Georgia Department of Agriculture to file a complaint. After a few days, I received a response back that while the Department of Agriculture receives lots of complaints about this particular Petland, it was very hard to do much about it. Again, this was not a satisfactory answer. But as a young college student, I didn't feel like there was much else I could do. I went back a week later, and the kitten was gone. I'd like to believe that she was purchased by a responsible pet owner and lived a long, healthy life, but I know that the reality is that she probably died alone in the back room of that store. This was at least 20 years ago. For 20 plus years, Petland has been taking advantage of consumers by charging exorbitant prices for often unwell animals that need veterinary care or are simply too far gone for veterinary care. 20 years is a long time to be in the business of sick animals. In closing, banning retail pet sales is good for the consumer, good for Cobb's taxpayers, and good for the well-being of animals in our community. Let's make sure not one more animal dies alone in the back room in the name of greed.
Thank you.
Good morning, Commissioners, Chairman. My name is Cindy Patton. I'm a lawyer who's lived and worked in District 1 for 35 years. I'm most proud of Cobb's long history of setting the standards for Georgia. It's time to lead the way again. I regret we missed this opportunity regarding 10-135, but I'm grateful for the chance to speak again. For more than 20 years, I've litigated cases in every Georgia court, including the Supreme Court and the United States District and Appellate Courts. I realize the impact of the opinion from an Attorney General. I have reviewed the Attorney General's opinion and the Canton Pet Shop Ordinance, that the pet shop ordinance is preempted by state law. I've also reviewed the contrary legal opinions of Law Professor Boyd. I've independently researched the relevant federal and state law. Like the professor, I disagree with the conclusion reached by the AG's staff attorney. In my professional opinion, Cobb's Code Section 10-135 does not conflict with any federal or Georgia law. Therefore, it is not preempted. In other words, the law is constitutional and would withstand a legal challenge. The AG's opinion is persuasive authority only. It's not law. It's not binding on any court or this board. It should be considered along with other, perhaps more persuasive authority, such as the decision of every federal and state court judge who has already reviewed this type of law and heard presentations by attorneys for both sides and found every law to be constitutional. Every preemption challenge has failed. Every appeal of those decisions to a higher court has also failed. Failed even though the courts were required to assume that everything the challengers alleged was true, and the courts were required to draw all reasonable inferences in favor of the challengers. Of the 341 pet store ordinances enacted nationwide, about 45 have been in a jurisdiction with a pet store that sells puppies and kittens. Fewer than 10 have been challenged in court, and as I noted, the challengers have lost every time. Just last week, a federal court confirmed the law passed by Maryland and say it is valid. I'm only aware of one case that did not reach a final hearing. Petland agreed to relocate their store out of the jurisdiction and voluntarily dismissed their Sarasota case after an unfavorable preliminary ruling. By abandoning their case and moving, Petland avoided the risk of a final ruling against them. This board should take the Attorney General's opinion into account. I know you've also considered the contrary legal opinions that were provided, noting the clear nationwide consensus among courts that these ordinances are legally sound. I hope that one day soon, Cobb will lead the way for Georgia again. Thank you.
Thank you.
Excuse me. Good morning. My name is Philip Ivester, and I live in the Concord Covered Bridge Historic District. I came out this morning to express my concern over changes to the code in Section 66 that would add a lot of confusion to the process by mandating that new construction in the district adhere to a guideline that was intended for renovation. And I didn't know that was the community development's position, that it was appropriate, but I do happen to have a copy of some of the guidelines for the renovation. I can pass this out to you. It'd be good to be familiar with the renovation guidelines before we write it in as code for new construction, because I think that's going to create a lot of confusion and not get us anywhere further. A lot of the historic districts around the country have one or two structures in them that caused the creation of the district for protection. Our particular district has 6 structures in it that are historic from the 19th century, which is more than normal. But the process for new construction in this district has been working, and it's been working well. Over the years, about 40 homes have been built in this district after the district was created. The Historic Preservation Commission has applied their process to approve these structures in the district. It is working, and it can continue to work under Section 66. One of the phrases that came up this morning was the immediate neighborhood, and that phrase is used in virtually every other historic district in the country. It's in Georgia codes, it's counties all over Georgia, cities and municipalities all over Georgia. Alabama, Connecticut uses a lot of the same verbiage. It's got a lot of judicial review. It's got a lot of a standard process for historic preservation commissions across the country. And changing the law to eliminate that phrase in response to this last appeal would be unprecedented. So at any rate, I just wanted to close by respectfully requesting that the commission not accept these changes in 6682 and 6685. And I'll be here this morning if I can help in any way.
Thank you, sir.
All right, thank you.
Hi, my name is Jennifer Dural, and I am a resident of Mableton. I want to thank you for considering restrictions to short-term rentals. I know that some owners are local, but the reality is that many are not. Many are absentee owners. In many cities, they are actually not able to collect the taxes that are being proposed from these entities that are controlling, like the Airbnbs and such. These short-term rentals do put a burden on homeowners like me. I don't want to live in a community where I'm surrounded by what basically is a motel. In hotels and motels, at least they have staffing that can address an issue. When these short-term rentals are having parties and events because they don't own the home, who's going to control that? I know from firsthand from a couple of residents in Mableton that have had negative experiences where they had unauthorized parties, they were loitering on their property of the owners. And now, as in real estate, they can actually are keeping data as to what homes are being rented for short term. Those are going to affect those of us that are, we move into the community because we want to invest in the community. We want to be long-term residents. And, we appreciate that Cobb County is a beautiful and wonderful community, wonderful county, but if we have where now these residents are renting we're surrounded by rentals that are short-term, the property values for our homes are going to diminish. And so I hope that you do consider that the betterment for the overall community, that they need to be restricted. As a business, which is what they are, they should have a permit. There should be some control from the county. Thank you.
Thank you.
Thank you. Hi, Commissioners. Sonia Wheatley. Talking about chickens, so I know we're short on time. My husband made me promise to say this. They're cute, they weigh less than a cat, they eat bugs, and they turn them into breakfast. I do not understand the extreme fear of a chicken. Everybody has opinions. We talked about this at the last meeting. I don't think these things are pets. A lot of people do. Nobody has to get permission to have them, but apparently you do for a chicken. There's a lot of faults. There's fear and prejudice. So let's talk about it. Faults. Chickens and chicken coops are dirty and they make people sick. The danger is not from people having a few chickens in their backyard. The danger is from restaurant handling and from large farms. They're loud. Dogs, radios, cars, and chickens are louder. We talked about whether you need to get permission from your neighbors in a platted subdivision to have a chicken. Well, they didn't ask my permission when they brought in 5 kids. They didn't ask my permission when they got 4 dogs. They didn't ask my permission when they got 3 cars that I can hear are 2 blocks away. So I don't understand why you feel it's necessary for that. This is not going to harm anybody in a platted subdivision or a neighborhood. HOAs can restrict it if they haven't already. Covenants override code, you know that. Chickens poop too much. Not really. It's less than a dog. Again, I had 200 pounds of dog. I'm down 1, he'll be replaced soon. It's a lot of poop I have to clean up. There are businesses that do it. Talking about the safety and the fear, I looked all through the CDC site. So again, what are the concerns? Are they making you sick? Are they too loud? You don't like it? We all have the right to our opinion. But when you talk about where salmonella and where illness comes from, with the exception of 2 years ago, apparently people started kissing their chickens. It was weird. But yeah, otherwise, these are the standard foods. The biggest outbreak was actually from pre-cut melon. It comes from food handling, not the chicken in your backyard. Left is reality. The one on the right, we talk about the areas, we talked about Marietta. I do not know what the issue is with a chicken. In the city of Atlanta, you can have 25. Kirkwood, Torrip Homes, they spent $100,000, they have a chicken coop. They didn't get permission from their neighbors, and they're in a platted subdivision. It's not an issue elsewhere. I don't know where your fear comes from, but I honestly think it's unfounded. You have plenty of things that are important to do. You guys do it every day. You do it every meeting. You talked about getting rid of the special land use or the land use permit. Who cares if somebody has a chicken? Honestly, I'm here again, taking time off like other people. Can we please move on? You guys have more important stuff to worry about. Thank you.
Thank you.
Good morning, Mr. Chairman and Board of Commissioners. I'm Sharon Mason. I have been a Cobb resident for the last 15 years. Also serve as the president and CEO of the Cobb Chamber of Commerce, representing more than 2,500 companies that are members of the Cobb Chamber. And we also work with many entities on Select Cobb on attracting, recruiting, and retaining quality jobs and investment to our county. So I'm here to speak on behalf of the Cobb Chamber in support to Chapter 54, the Fire Prevention and Protection, Sections 5452.1 and 5455. These changes provide opportunities for best practices to be used and vetted for how we use a life safety code to promote public health and support economic development. Also providing options for how occupancy is determined, as has been authorized by the state fire marshal, is of critical importance for Cobb County. And the alternative compliance methods and appeals board will provide us with a fair method to evaluate situations and provide a checks and balances that can ensure that safety continues to be #1 priority, but also operate in best practices as well. And this will support our efforts for not only safety, but also for continuing to be the #1 place for bringing new business and new investment to Cobb. Thank you.
Good afternoon, or good morning. My name's Chris Benson. I'm a lifelong resident of Cobb County. Been 50 years now. I've lived in districts 1, 2, and 3. I currently live in District 1. Wanted to talk to you a little bit about what we're trying to do here, and I realize that the vote to withdraw has passed, but I just wanted to note that over the last few years, we have made so much progress along these humane initiatives that we've had. And I, as a citizen of Cobb County for so many years, I have been so proud of the board. I'm hoping that we can regroup on that. I know that going back to the last meeting, I think we had, I forget the exact number, but nearly 150 people showed up in support of that. And for a 9 a.m. meeting today, I think we have quite a few. And as a matter of fact, if everyone would raise their hands who is in support of the ordinance that we're talking about, obviously it's not 150 this time, whatever, but it's still quite a lot for a morning session. So I just wanted to say that, you know, I think there's a great deal of doubt about the strength of the Attorney General's opinion, and I know that there are a lot of legal minds out there that that have said that it is not a very strong opinion. I'm not an attorney, so I can't, really, comment on that myself. But I'm hearing so much doubt about that. I'm certainly hoping that as we go forward and continue the effort that Lisa and Julie had started with getting us all organized around this. And I just wanted to call out a hand for them for doing such a fantastic job on this. And I thank you for your words, Chairman, last time in support of that. But I hope that as we go forward in the months ahead that we can regroup and maybe reconsider this and look forward again. Thanks.
Thank you.
Good morning, Commissioners, Chairman. My name is Julie Escarcega, and I live in District 3. During the last public hearing, speakers explained in detail why a humane model is beneficial for a pet store business. I would like to highlight some key points. It helps businesses engage in an increasingly lucrative pet retail market, as demonstrated by the following stats. The pet retail industry is a booming $72 billion business, and the stores taking the biggest bite out of that market are pet stores that don't sell dogs and cats, but instead rely on the sale of quality products and services. In fact, a 2018 industry report noted that pet stores with animals reported a $246 in revenue per square foot, while pet stores that sold only dry goods reported $403 per square foot. There are over 30 pet stores in Cobb County that thrive using a humane business model that focuses on offering quality products and services and do not need to sell puppies to turn a profit. It helps businesses build stronger community ties by partnering with local shelters and rescues to be part of the solution to address pet overpopulation in Georgia and not be part of the problem. Stores like Petco and PetSmart are viewed as a valuable part of the business community and the community overall. It can also help improve customer relations and increase customer loyalty and retention. However, good business practices do not include reliance on impulse buying, usage of predatory lending practices, credit agreements with high interest rates, or non-disclosure agreements to silence customers. A humane model can bring in new customers and attract positive media attention for the store. In contrast, the association with commercial breeding facilities and puppy mills can taint the image of a pet store, as seen in these media articles, many of which reference the pet store here in Cobb County. The goal of a humane pet ordinance is not to cause hardship for a pet store, but to encourage transition to a profitable, humane model. Cobb County's motto is Cobb Expect the Best. We do expect the best, not only from our local government, but from the businesses that serve our community. Our community has shown up to show their support for these changes, as you have seen. Lastly, during the previous hearing, we showed you these 24 businesses that are in support of the code changes. We are now up to 31, and here are the new ones that we have gotten. Thank you. I appreciate you giving us the time to hear us.
Thank you.
Good morning, Chairman Boyce and Commissioners. I really appreciate the opportunity to speak again. My name is Lisa Powell-Huberty, and I live in District 2 for over 20 years. And I'm going to speak to you in support of the former code amendment to prohibit the sales of dogs and cats in pet stores. But first, I wanted to specifically thank Chairman Boyce and Commissioner Cupid for their understanding that the AG's opinion is just that, an opinion, and to thank you for your willingness to listen to your constituents before drawing conclusions. Even though there are differing opinions regarding the constitutionality of this type of ordinance, there's no debate that consumer protection concerns exist and still need to be addressed on a local level. During the hearing on January 28, speakers described financial concerns ranging from manipulative sales techniques and risky financing to exorbitant vet bills, public health risks surrounding the way puppies are raised and transported into our county, and how there are problems at every point in this process, which has led to outbreaks of Campylobacter in Georgia and around the country. And of course, the emotional stress and turmoil of losing a puppy. There are now 341 localities across the U.S. that have passed this type of legislation. Most recently, in Naperville, Illinois, passed an ordinance, and like Cobb, the City Council also had to consider pet stores in their area. There were actually 2 pet stores that will be affected there. One of their constituents stated, "Passing a humane ordinance won't be a magic bullet to solve the problem, but it will better protect consumers." Since the amendment was withdrawn, we respectfully ask, what will be done to protect the citizens and consumers of Cobb County from problematic pet stores? We know that each of you deeply care about consumer protection and work hard to ensure these types of issues are addressed appropriately. And for example, the actions taken to deal with the concerns surrounding the sterilization facility in Smyrna. Though not a direct comparison, pet stores that sell dogs and cats do create serious concerns that need to be addressed as well. When speaking to fellow constituents, we often hear the same remark: why are these type of pet stores allowed to get away with this? Right now, we don't have an answer. Thank you so much for your time and consideration.
Thank you.
Good morning. My name is Dr. Judy Johnson, and I'm the veterinarian for Good News Animal Foundation in Marietta, District 2. Previously, I worked at 2 local emergency clinics where I treated scores of Petland puppies. They claim that Petland pets make lives better, yet I've experienced the opposite. As the veterinarian, my role involved relaying the diagnosis, prognosis, and cost of treatment to these pet owners with no guarantee of survival for their new family member. I dealt with heartbreak on a daily level while feeling powerless to stop their pain. My colleagues and I followed the rules of reportable diseases and filed numerous cases to the Georgia Department of Agriculture, yet nothing was ever done. The Petland puppies continue to spread zoonotic diseases and other highly contagious species-specific illnesses. Anyone entering their retail store can carry these contagions home to their own pets on their shoes, clothes, or unwashed hands. A few years ago, during the canine influenza outbreak, we saw confirmed cases from Petland. Myself and their veterinarian at the time discussed they should close down for a period of time for decontamination, similar to what Cobb County Animal Control just did. The owners refused, and I was reprimanded for getting involved in their business. Petland would tell owners that they would cover cost of treatment. In reality, their insurance company pays the bill, so Petland suffers no consequences for selling sick puppies that need critical care. They retain the profit from the purchase, even if the puppy dies. Those who do survive often go on to have lifelong issues, which carry additional financial burdens. Many owners couldn't afford the puppy to begin with, but succumbed to the lure of financing. If they can't afford the initial cost without financing, how can they be expected to afford ongoing veterinary bills? Along with the owners and pets who suffer, let's not forget the veterinary caregivers. Excuse me. Suicide among veterinarians is an epidemic in this country, and a major factor is compassion fatigue. Compassion fatigue stems from mental, physical, and emotional exhaustion from helping those who are suffering. In the case of Petland puppies, compassion fatigue is greatly amplified. Because these cases are preventable, and as caregivers, we feel helpless to stop the cycle. Constantly battling the emotional exhaustion while treating Petland puppies was defeating and caused me to leave emergency medicine. I had to get away before I became another statistic. Petland remains in Cobb County because we are letting them get away with their inhumane care and predatory business models without any consequences. It's appalling that this type of behavior is acceptable in a community where animal shelters and rescue groups are filled to the brim with pets that desperately need homes. I'm very disappointed that some on the board did not have the courage to do the right thing and stand up for this ordinance. I hope when this comes before you again, you do stand up and let Cobb County be admired in the local and national news, like all those headlines that were shown.
Ma'am, sorry, your time is up.
Do the right thing. Thank you.
Hello, I'm Kendra Ledlow. I live in District 1. Commissioners, first I want to express my disappointment that the board has pulled the proposed humane pet acquisition ordinance at this time. Thank you, Chairman Boyce and Commissioner Cupid, for the engagement with your constituents and the thoughtful consideration of the fact-based arguments that were presented before you over the last year. There are dozens of people in this very room who will not stop speaking up for the voiceless. In the future, I really hope there is a board of commissioners that is more willing to do the same. Secondly, I want to read a statement from Adrienne Carter, who purchased a puppy from Petland in 2014. She emailed this to you but was unable to make it today. Commissioners, I want to tell you my story in hopes that you will understand why this issue is important to me and our community. 2 days before Christmas in 2014, I bought a Yorkie puppy from Petland, Kennesaw for nearly $3,000. Our family named the puppy Daydream, and I cannot express enough how we instantly fell in love with her. From the day we brought her home, Daydream was lethargic and didn't want to eat. To make a long story short, just after Christmas, I heard Daydream yelping in pain. I was helpless. I couldn't figure out why she was in such distress, and all I could do is just hold her while she passed away suddenly, unexpectedly, and in the presence of my daughter, who was just a toddler at the time. When I called Petland to tell them what happened, they told me to bring Daydream's body and all of her belongings back to the store. They told me they would run tests to find out the cause of Daydream's death and issue me a store credit for a new puppy. Heartbroken, but at a complete loss for what to do, I did as they instructed. I placed my trust in them. For weeks, I called to find out why this happened to my puppy, but they never offered any answers. As far as I know, they never did any tests to determine the cause of Daydream's death or make sure that she was not infected with a contagious disease. Instead, they offered me a puppy for half of what I paid for Daydream and showed absolutely no remorse for my loss the more I called seeking answers. I decided not to take home another pet from Petland. It took me years to work up the courage to get another dog. When I did, I made sure not to buy from a pet store. After my heartbreaking experience, I learned the truth about pet store puppies, that they come from puppy mills. Daydream was no different. I eventually found out that Petland bought her from a breeder in Oklahoma. Daydream lived a short life, but it was meaningful and I hope will be impactful. For me, her loss is not about taking on a giant corporation or being compensated for my family's heartbreak and financial loss. It is about making sure that we as a community do what we can to make sure this does not happen to another family. Adrian's story is not unique. Families like hers and pets like Daydream deserve better, and in Cobb, we expect the best. Thank you.
Thank you. I just want to say, back of the line, you're probably about 30 or 40 minutes away. So if you want to sit down, take a seat and relax, or just stand, it's fine. I guarantee you sit down and we'll get you back up again. But I just want to show a little, sympathy here for that are standing in line here for 30 or 40 minutes. But, okay, ma'am.
Hi, I'm Joe Taylor. I live in the city of Marietta. I've lived in my home for 26 years. I'm here to speak on the impact of free roaming cats and regarding the ordinances that are going to be removed in regards to cats. In the last 4 years, there's been a significant increase in outdoor cats in my neighborhood. I trapped or picked up almost 30 cats and kittens and turned them into animal control. Each of these times, I talked to multiple officers regarding how TNR is allowed in Cobb with leash laws in place. Repeatedly, I was answered with, "I don't know." Eventually speaking with someone in upper management and animal control to explain the problem more specifically, like the problem with renters moving in, getting a cat they leave outdoors, move, and leave the cat behind. Ultimately, he told me, unless we see them release a cat, then we can't do anything. Untrue, because that's not how it works for dogs. I contacted Mark Murrah, head of the Equine and Companion Animal Division of the Department of Agriculture, asking how they regulated an entity to essentially break the laws here in Cobb. His response was, "We don't have anything to do with the laws." With TNR and Cobb, along with animal control refusing to enforce laws in regards to cats, the numbers have continued to rise of cats outdoors, and less people are being responsible. I continue to witness this in my own neighborhood, where my count is now close to 50 cats that have come and continue to come on my property. I've complained every time I went into animal control and even filed 2 formal complaints against the neighbor, even trapping the cat that killed my pet birds that I turned into animal control. Nothing happened, and the cat returned and still comes on my property. The final straw for me was when a cat I trapped and turned into animal control was back on my property in less than 2 weeks. The officer that finally came out to tell me it may have been released back at your house is here today. So animal control not only repeatedly ignored my rights on my property, but was complicit in breaking the law and violating one of the regulations for TNRs, and that's about them they have to have permission from private property owners before they can re-abandon cats on private property. That has never happened. I haven't seen the cat in about a year and suspect it's dead. It lived in the sewer on my street. She was probably 4 to 5 years old and was re-abandoned with fresh sutures from a spay, which is the other issue. If the cat's on a stray hold for a week, that means that she was re-abandoned outdoors with fresh sutures from a spay. There are plenty of products in the market for cat owners who want their cats to be outside to be contained on their property. Why should I be forced to build a fence just to try and keep someone else's animals off my property? TNRs violate state laws and CDC recommendations regarding rabies vaccinations. They are required yearly or every 3 years. TNR cats get 1 vaccination at the time of trapping, and that's it for life. They aren't re-trapped every year or every 3 years to have them re-vaccinated. They're also not treated for fleas and ticks. They are spreading the #1 zoonotic disease here in the United States.
I'm sorry, your time is up.
Thank you.
Excuse me, ma'am, is it possible, ma'am, excuse me, ma'am, may I see your presentation?
Just my papers that I wrote?
If you have do you have a presentation? You don't, I can talk to you to the side. I'd just like to see someone else's, oh, okay.
She dropped off a package.
I don't envy you. Morning, Commissioners, Mr. Chairman, Mr. County Manager. My name is Scott Denton. I've lived in District 3 for 15 years and owned a business there for 15 years as well. The business, I'm a Mac IT consultant with Mac Fixins Consulting. I'm also a new board member and a volunteer for over 10 years at Good Muse Animal Foundation, a cage-free, no-kill cat shelter in District 2. I'm here today to speak in favor of the Community Cat TNR ordinance changes being considered. TNR is effective. Trap, neuter, return. This is Creamsicle. TNR, how is TNR effective? Humane trapping of community cats, spay, neuter, rabies vaccination, and an ear tip, usually on the left ear to signify that they've gone through this so they don't have to be retrapped and go through the whole procedure again. Then the cats are returned to their place of origin, they keep other cats at bay, and the population stabilizes. It's a humane trap. Why is TNR effective? TNR keeps cats from reproducing, plain and simple. It reduces unwanted cat behaviors, fighting, marking, doing the things that we don't like so much about cats. And vaccinations reduce rabies and disease risk. Are we sure TNR is effective? It has worked for myself and my neighborhood. When I bought my house in East Cobb 15 years ago, I didn't have anything to do with Good Muse or anything. I didn't even understand what TNR was. We had cats growing up, but I saw a couple cats and then 2 turned into 8, turned into 20. It happens. If you don't do anything about it, this is the inevitable outcome. Once I learned how it worked and tried it, I became a believer because I just, there were ways you could get traps for free or low cost, and also the spay and neuter in the entire process. And now it's virtually free to do for Cobb County residents. I have a nice orange tabby family that keeps me company, and they help deal with rodent problems that come up. They like catnip and dinner time. Can cats live outside safely? Feline species have lived outside for approximately 25 million years. It's hard to decide where the domestic cats that we know started doing that, but a long time, safely to say longer than inside, they've lived outside. Not all animals can or should be domesticated. Feral, community, or stray cats are no different. Community cats, in my experience, are resilient, smart, and resourceful. They enjoy their life out there for the most part. They deal with things, and they are, in some ways, wild animals. Not all cats want to live inside, including this guy. Benefits of a community cat program. Community cat programs involve volunteers performing TNR to manage cat populations. It helps keep feral and community cats out of shelters. It gives resources back to animal services so they can deal with other animal issues, because there are plenty. And it uses private funds and grants so it doesn't cost taxpayers anything and save thousands of lives. And that may be—
Excuse me, sir, your time is up.
Okay, thank you very much.
Hello, Commissioners. My name is Rich Monroe. I am a board member of STRAWAGA, the statewide association for short-term rentals of Georgia. I'm also an owner and a manager of short-term rentals, and have managed properties in Smyrna, Mableton, and Kennesaw. And just wanted to basically point out, a lot of what's said before, but to kind of go in a little bit more in depth. There's a reason why this platform has been so successful and taken on so much, traction. There's about 14,000 listings in Georgia. The amount of people that are doing short-term rentals, the vast majority of them, over 90%, are individual property owners. And this is another way to supplement income. This is also a way for families that travel to have another alternative, as well as business travelers, as well as people living in the community to have other options. Pretty much all of our members do not allow parties at all. This is not something that is allowed. In fact, STRAWAGA has worked very closely with the city of Atlanta recently to basically delist a bad actor that was in Grant Park in a neighborhood and had 3 houses that were, violating those rules and interfering with the neighbors. And so I just wanted to point that out, that Storaga can meet with the neighbors, talk about the issues that are occurring, and come in and bring solutions and help with that process. We also reach out to neighbors. So before we go live with a listing, we meet with all the neighbors. We explain to them, we're in constant communication with the guests at all times. This is a community thing. We review the guests review us. And so this is not something that people are just looking for the lowest price or somewhere to stay. There's a respect there. People are reviewed, so I can deny people from coming if they had bad reviews. And the same thing there. There's some bad actors that come into play. There are technology that we use to help with that process. We have noise detection devices that actually measure the level in sound, and this allows us to be proactive. And we have the settings set at a lower level. So if there is something that's happening, music started to play, a large number of people being at the property, we can be proactive and reach out to that guest and ask them to, simmer down and not wait for the neighbors to have to complain. So this is something that we take very strongly. We actually have several monthly meetings. I've got 300 or 400 members that we meet locally of other hosts, and we talk about best practices and ways to make this industry better. So we look forward to working with the commission on potentially reworking the ordinance, and look forward to that. Thank you very much.
Good morning. My name's Rebecca Carlson. I live in Kennesaw, Georgia. And so just to tell you a little story, about 7 years ago, I went into PetSmart to buy cat food because I'm obviously a very lifelong cat person. And I saw the cutest pair of little brown eyes and a little tricolor dog and a pin outside of PetSmart. Promptly fell in love and adopted this dog, named her Rose, brought her home. Now, Rose, not only did she come home with me, so did collars and leashes and bowls and food and treats and toys and even little doggy t-shirts. And because she is a Jack Russell Beagle mix and has the energy of an EF4 tornado, pretty soon we got involved in training and daycare and dog sports. And the reason I bring this up is not to talk about how wonderful my dog is, although she is the best dog in the world, but to illustrate, I had the money to pay a $300 adoption fee, and then the rest of the funds went to primarily local businesses in Cobb County, as opposed to a place like Petland, where it would be going to the Petland company itself instead of local Cobb County business. And this has continued on again for the last 7 years. I started to do a little back of the envelope math on 7 years of weekly doggy daycare and got a little faint-hearted and had to sit down for a minute. But Americans spend billions of dollars in pet care annually, and a small fraction of that is only in dog and cat sales. The remainder of the money spent is spent on food, on supplies, on veterinary care, on services, and other miscellaneous items. And the money spent on buying dogs and cats has consistently gone down year after year after year. And plus now we have statewide bans in California, in Maryland, in New York. We have one being considered in Colorado. Countless cities and counties all over the US have now banned the sale of cats and dogs. And in turn, what has happened is people have turned to adoption. Stores that prior to this have sold cats and dogs instead opened it up to rescue groups where we're able to showcase our animals and get those animals into good homes, which means they're not sitting in shelters or worse, and I won't go into the or worse this time. And I think it's beneficial to all of us. It's beneficial to people who can go in and adopt a new best friend. It's beneficial to local business, which means beneficial to...
Ma'am, sorry, your time's up.
Okay, thank you.
Hi, my name is Amy Barnes. I'm from Marietta. And one of the first things that they teach in law school is when emotion enters, reason exits. And what typically happens is when people are anxious and emotions are running high, they are desperate to grasp for some way of controlling what causes them anxiety. And as I stand here and I look over at that Declaration of Independence on that wall, I'm seeing restriction after strangling restriction on the businesses in this community. And I'm looking at broken windows oriented policing, which makes it difficult for people to climb the economic ladder out of poverty when they are tied up in the courts. And, why aren't we offering options for this parks restrictions, for the photography fee? Why aren't we using a reservation system for $5 and $10 a pop, where it's economically attractive to have a booked-in photography section instead of a $100 fine, fee, tax? And I see the gutters and shutters. Why not provide referrals to people who will do it at an affordable rate so we really don't have the problem? Why not help solve the problem? People don't have 100% capacity. Sometimes we have neighbors who are elderly, stressed. I have a neighbor whose wife is dying. He can't function. So we occasionally stop by and check on him. So why not offer solutions? Not the heavy stick quite so much. And I see this surveillance attempt over health spas. Are health spas robbing and shooting at people? I don't think so. It looks like it's a taboo business, and it looks like registration of employees. I can understand that, but how far will it go down the road? Does every business in the future have to register their employees? This makes no sense. I mean, it's regulation without any reason that I can see. And with respect to the parks, I cannot walk the streets around my neighborhood because 1, 2, 3 people so far have died in hit and runs on pedestrians. I mean, I have a good friend of mine who died 4 times coded out after getting hit just walking. Why not have our parks open at night so that people can walk safely? Anyway, that's my commentary on this. And Airbnb deserves freedom. Let the market reign supreme. Power to the people.
Yes, good morning, commissioners, people. I'm here to speak partially on what the person from Strog spoke on, which is the short-term housing. And
Could you let us know who you are first, though, sir?
Pardon me?
What your name is?
Oh, I'm sorry. My name is John Galsinski, and I have been from Lisa Cupid's district presently, as well as from Bob Ott's district.
Okay, thank you.
I've worked with Prudential on, Prudential on the real estate side, for the enforcement on both short and long-term rentals. And while we may not have had audio equipment to be able to register complaints, we did have an ear towards the local community, and we're very quick, because I was one of the people who went out there to make sure that they complied with the restrictions that we had on the property. And if somebody locally called us, we were also, regardless of anything that came from the tenant. So essentially, I'd like to speak in support of the industry, regulating the industry. That's it. That's basically what I'd like to go.
Thank you, sir.
Thank you.
Hey, good morning. My name is Darius, and I live in Smyrna. My family, we all live there in Smyrna. I wanted to talk about the support with short-term rental. Pretty much with that, it has helped me and my family as a, just as far as taking care of our home. And the thing is, with firefighters, we serve the community and we are away from our home. Most people here are going to see a firefighter or is going to need service from a firefighter at some point in their life. The thing is that people don't think about is that firefighters have multiple jobs. And with that, we were working like 2 fire department jobs or like another ambulance job and so on and so on. And the thing is with the short-term rental, what we were able to establish is an extra income for my family. With that being said, I am home now. I'm able to see my family. I'm able to, spend time with them, go on vacation, and we don't have to work I myself don't have to work as hard anymore because, we're tired. We're doing running calls. We're going from house to house and, just doing what we love to do. So with short-term rental, I know a lot of people, you see a lot of bad connotation with it. The thing is that we were able to establish ground rules for our home. We were able to establish security systems. And then, we meet all our guests and we get real personal with them. And we found that the more personal that you do get with them, the more regulation you do have in your home. So there's ways to control anything that you might think people are bad coming to your home or anything like that, but there's ways around that, and we don't accept everybody, of course, because you have to be careful on, just regulating your home. So, this helps us out as far as having a short-term rental. It helps us out as a unit and as a family, and we do support it and we love it. We've met many great people all over the world from other states. And when they say that they come to our home, they're going to come to Smyrna, Cobb County, not to Atlanta, because they have a good time. They go to the Battery Park, and that's two of the main people who do come into our home. They come and see, the Braves. And so we get good connection with people, and we get good times, and we just we love sharing our home and meeting new people. So yes, we support short term. So thank you.
Thank you, sir.
Good morning. I will break the ice by saying I'm incredibly nervous at public speaking, but I felt compelled. The added nerves are because I just found out my dog won at Westminster. I'm Sonia. I'm an AKC inspected, Georgia State licensed, 30-year veteran AKC silver status breeder of merit.
Ma'am, could you let us know who you are first?
Sonia Lopez.
Thank you.
I said, yeah, I did. Okay, thanks. I'm a recipient of GoodDog.com's excellent breeder status and a grateful resident of Cobb County. Let me first thank the good commissioners for their work and hearing me this morning. Ooh, listen to that voice just shaking, sorry. With regard to the proposed code changes, I believe they are overreaching and will have a negative effect on rescue organizations and dog breeders and dog owners in the county who are making responsible choices. I fear that these proposed animal code changes will push out the good sources we so desperately need in order to make a truly better world for our dogs. Additionally, dog rescue and breeders should have the right to decide what constitutes a reasonable and safe place to sell their responsibly sourced and bred dogs. Responsible breeders and rescue organizations often present their dogs within their home or other places of their choosing. And by forcing responsible breeders or rescues to open up their private homes to anyone claiming to want to meet or purchase a dog, breeders will face higher risk of assault, theft, and other crimes. This is especially worrisome because most of the time rescue operators and breeders are women. And we already know that they are more susceptible to these types of crimes. Even more troubling is the anti-breeder sentiment that has spread and been unfairly aimed at responsible breeders, putting them additionally at risk. Forcing people to open their homes to the public exposes us to real physical harm. I firmly believe, and through my own experience, we know what is truly best for our dogs, both well-bred, purebred dogs, well-bred dogs, and rescues, that people should be allowed to prioritize their safety as well as their dog's well-being. Additionally, leash laws, such as those being proposed, would restrict the ability of dog owners to engage in therapy work, search and rescue work, livestock guarding, herding, bird, truffle, and mushroom hunting, to name a few things. This could have disastrous effects, not only in people's livelihoods, but also could prevent trained dogs from performing the work that is vital to our society. With that, I respectfully and thankfully dismiss any other comments that I have to the commissioners, and I very much appreciate the time. Thank you.
Thank you, ma'am.
Good afternoon. My name is Edward Morgan. I am a Cobb County resident since 1996. We've been a homeowner since 1996. My wife and I have an Airbnb. I'm here to speak about the support of the Airbnb. We've been running the Airbnb, or the short-term rental, I'm sorry, since 2016. In 2008, my wife and I moved to California, then we moved to Delaware. We returned in 2016 and turned it into short-term rental. During that time, we've made great money, but at the same time, we've spent a lot of money at the two Costcos, one in Cumberland and one in Kennesaw. We spent a lot of money with contractors, housekeepers, landscapers, you name it. We've spread the wealth with everybody. We're part of our plan with the short-term rental is it's part of our retirement community. I'm 7 years away from retirement. I plan to wake up when I retire and walk to the front of the Airbnb or the short-term rental and greet my guests, and that is part of my retirement package. Along with everything being said, in addition to that, since I've been on the short-term rental platform, I've become a certified beekeeper on the actual platform. And since we've been away, I didn't realize this until last week, I guess there's been an issue with chickens. Because I live on a 9-acre estate, we have chickens now. So I guess I need to investigate what's going on with that, because I may be out of compliance. But with that being said, this has been informative to me. I didn't realize there was a chicken issue, but I have chickens. So I'm saying all that to say, I belong to a short-term rental group. We meet once a month. We discuss best practices among everyone within Metro Atlanta. We police ourselves, but we welcome the recommendations from the commissioners, and we would like to work with you guys, because there are times when we call the police because someone's having a party and the police don't know what to do. I have cameras on my particular property, so if anyone is doing anything strange on my property, I go out there or I call the police. But I just want to let you know that we don't allow parties. We operate within the parameters of what is respectable business. And we spread the wealth between the contractors, the housekeepers, the Costcos, the Walmarts. That money is being spent. And prior to that 9-year period that we were gone, I wasn't spending any money when I was just a homeowner renting out to a tenant. There was no money spent in the community. So, thank you.
Thank you.
Good morning, and it's still good morning by a few minutes. My name is Ann Jones. I have lived in Cobb County for 30 years up in District 3, and I have been a dog trainer and a classroom instructor for 26 years. 15 of those years I had my business up in Cherokee County. In 2017, I moved down to Marietta here, about a mile from the square. And when you did the exception to the 10-foot leash law. The one thing that was not looked at was if we go off and we do performance events where we are allowed to have our dogs off leash for that event, we have to train for that event. At my training building, I have an indoor area, and if you read 1011 carefully, it says from the time that dog leaves the owner's premises, it has to be on a 10-foot leash, no longer, which would mean that inside my training building, when we were doing obedience classes, we could not help the dog owners learn how to call their dogs off leash. We couldn't go outside into my fully fenced agility field and actually do agility classes. We would be incapable of training for the events that Cobb County will allow us to do and compete in, but we would not be able to train for them. So I would respectfully ask you to look at that language again so that the training of those things are allowed. You do allow for the dog parks, Sweat Mountain and a couple others were mentioned in there. Nothing in there actually allows for dog daycares, and those dogs are no longer on the premises of their owner. So there's some definition part in there that truly needs to be looked at. And it's very important to do the training for these dogs because if a dog is off on a leash, occasionally they pull out of a collar, occasionally they pull out of a harness, sometimes they get out of a dog park, sometimes they bolt out of their front door. How do you train them how to come off leash if you don't have a training facility where you can go to and do those things? And the other thing that I wanted to look at just briefly was 10.1 and the definition of breeder. I have never bred a litter in my home, but I do own purebred dogs, and I'm a co-breeder on many. I do have some rescue dogs because as a dog trainer, I kind of end up with an assortment of dogs. But as a breeder, I would be a little concerned. I live alone about having somebody come to my home. I know that in the past, when I sold 2 bench seats from one of my large vans, I had a Craigslist ad. People came to my home, they threw money at me, they grabbed those seats, put them in the van, and off they went. They were as nervous as I was. So requiring a breeder to have somebody they do not know come to their home puts a lot of people at risk. And right now, from what I understand, Craigslist, Facebook Marketplace, you can go to safe places to exchange items and the money for those items.
Ma'am, I'm sorry, your time is up.
Thank you very much for your time.
Thank you.
Hi, I'm Pat McClellan. I am a Cobb County resident of Ackworth for 32 years. I own my home. I've lived in Cobb County probably 50 years. I am a responsible dog owner, and I would like you to represent me. This does not represent me. It represents the people that are not responsible. Give me a break here, people. I take care of my dogs. They have their shots. They have everything that they need. Don't restrict my training. This doesn't say I can train my dogs. It doesn't mention fly ball, lure coursing, fast cat, frisbee, tracking, dock diving, nose work. It doesn't mention any of those. You haven't qualified what's good and what's bad. I'm retired. I'm enjoying my dogs. Give me a break. I'm a good person with good dogs. The restriction for the leash. Tracking is done on a 20 to 40 foot leash. Tracking needs to be done with 450 yards. I don't have that kind of space. I go to Kennesaw Mountain for that. Can't do that with this. I can't even get ready for my sport, much less participate in my sport with this. You require tags and leashes, or collars, tags. My dogs wear collars. They have a slip-on ID. It's not a tag. I don't wear rabies tags. They're dangerous. They get caught by other dogs pulling on them. They'll choke your dog. They get caught in crates. They'll choke your dog. Not reasonable. Look at what you're doing. Reasonable dog people know how to protect their dogs. We are not going to do something that will kill our dogs. This thing here about in heat, and they're confined to a building or other enclosure? Oh, come on, cut me some slack here. I am not a breeder. I don't want to be a breeder. I do not spay or neuter my guys until their growth plates are closed. With a big dog, that's about 2 years old. With a little dog, it's a little bit younger, maybe a year and a half. It's because that adversely affects their health. When it's healthy to do that, I take care of my dogs. Where are they gonna pee? Inside a building? I don't think so, not in my house. I can't guarantee they'll stay in my 6-foot fence. I can't guarantee that a boy dog will come over the fence to get my girls, but I tell you what, I'll be out there with them, watching them, making sure there's nobody there. I'm a responsible dog owner. I take care of my guys. Under this, they can't go to class. I don't want my girl home for 30 days with no exercise, no outside time. That's what you're telling me here. And she's in season? And she's crazy? No, she needs training. Let me train her. Give me that freedom. You say over here that I have to have rabies information on my dog at all times. My rabies tag, my rabies ID, they get their shots regularly. They go to the vet. We go to the same vet. Been there 30 years. He's been in business 50.
Ma'am, I'm sorry, your time is up.
Okay. Thank you.
Thank you.
Good morning, or good afternoon, I guess now. My name is Anna Rains. I'm with Best Friends Animal Society, and I'm here again to speak in favor of the proposed code revisions supporting the community cat program. Thank you again for your time today. I wanted to remind everyone of the proven benefits of TNR and the success of the program here in Cobb County. Community cat programs, we know, are fiscally responsible. It's more expensive to trap, house, and euthanize a cat than it is to sterilize it, vaccinate it, and return it to its outdoor environment. Public health is also supported as cats are vaccinated against rabies, and the rates of diseases such as toxoplasmosis and other diseases are decreased in the environment as less kittens are being born. Many vets are now saying that rabies vaccines can last up to 7 years. The unfortunate reality is outdoor cats, many of them are not living that long. That said, many responsible caregivers and trappers are retrapping their cats to vaccinate them. The bottom line is we all want less cats outdoors. After decades, we know that trap and kill is expensive, inhumane, and frankly, that it doesn't work. TNR programs have proven to work for communities across the country and successfully decrease the number of outdoor cats, which is what we all want in the end. I also want to speak briefly to the changes that were brought up today requiring any cat that's not ear-tipped to be impounded by animal control. We agree entirely that indoor pet cats should be kept indoors. We don't want owned cats outdoors. The issue is owned outdoor cats will appear very similar to unaltered outdoor community cats. Both will not be ear-tipped. There won't be a way for Cobb County Animal Services to identify one from the other. Our goal with the community cat program is to fix as many cats as possible, owned and unowned, without placing an additional burden on Cobb County Animal Services. Enforcing this additional restriction would be burdensome and impractical for Cobb County Animal Services. I would suggest instead adding a clause that owned pet cats be kept indoors instead of mandating that all un-ear-tipped cats be impounded. Thank you.
Thank you.
Good afternoon, Chairman and Commissioners. My name is Elizabeth Finch. I am a resident of District 2 as well as Vice President for the Good Muse Animal Foundation Board of Directors. I spoke at the last meeting in favor of the changes to Chapter 10 of the proposed code amendments as they relate to the management and handling of feral and stray unowned cats. I'm here today to reiterate my support for those changes. My foundation, Good Muse, has recently assumed the operations of this program, which was started by Best Friends 4 years ago. Since January 20th through yesterday, we have sterilized 76 cats just in Cobb County alone at no cost to the county or any of its citizens. For the 45 females we've already spayed, that's the prevention of up to 480 births just this year so far. And the number of births prevented with the sterilization of 31 males is countless, as they may impregnate unlimited numbers of females. Clearly, the method works. It's been adopted in counties across the nation, and the results show it. Not only are these cats surgically sterilized, but they are also vaccinated before being returned to their colonies, which makes this method responsible for both the health of the cats as well as public health.
With this program, we aim to surgically sterilize approximately 1,000 cats in Cobb County just in 2020, which prevents the birth of many thousands more. These ordinance changes will allow Cobb County Animal Services to operate more efficiently and ultimately better use their resources so that we can save more lives together. It will allow them to divert these feral and unowned strays in need to us directly. And while I understand the good intent to additionally alter the proposed leash law provisions as they relate to cats, I'd like to note that this actually places an undue burden on county services. The leash law provision, as originally amended, actually allows more time, space, and resources for lost or displaced owned cats. I would suggest that we at some point address responsibility for owned cats in another way at another time. Good News strongly promotes pet cats being kept indoors, and we even require such of all of our adopters. We certainly agree with responsible pet ownership. We do request that the amendments revised as of February 6th be adopted as written in relation to Chapter 10. Thank you.
Thank you.
My name is Anthony Szymanski, and someone left their cell phone up here. I live over by Altoona High School. I think you're my commissioner that I vote for. Is it really? Shows me how much I know. I've lived there for almost 20 years. And some of the things that I talked about last time was how language matters. I want to go to the Parks and Recreation portion, C1. It says, no owner custodian of a dangerous, vicious, or guard/protection canine can go to a dog park. Now, I want to preface this with that in the contracts when I sell a puppy, they're not allowed to go to dog parks anyhow. So dog parks aren't personally something I have a vested interest in, but I do have a vested interest when we go back to the training. What does that mean? Guard or protection dog? There's no clarification. My breed in the AKC is considered a guardian breed. So is my dog a guard dog? If I train for PSA, which is a sport, or IPO, is my dog a guard dog? Because as we speak, entering the ring in Westminster, 2 dogs of my breed have titles that are in protection sports. Both of them also do therapy work, one at the University of Michigan. So what I want us to be concerned with is not necessarily because I care about dog parks, but once again, I go back to the language we're using. What does that mean? Does that mean someone who does extensive training can't bring their dog where they want to? And could someone else not twist that to say that Cobb County has insinuated that this type of training makes your dog inherently dangerous? The other thing I would like to talk about is the in-heat cycle, and I just want to stack on with what someone else said. I train my dogs. My dogs are nationally ranked. How do I train during their heat cycle? Let's be honest, I spend a lot of money on cute little panties to make sure that they're all covered up. Because I don't want anything happening that's not supposed to happen. But I think we need to clarify that language about dogs at large, because I really believe that's what you folks were trying to do, is address dogs at large. My dogs aren't at large. They're traveling with me to training areas. They're on leads at training areas. Now, since I use the term lead, I also would love to see for you folks put some clarification on training in the parks. Once again, I train off that park in Stilesboro Road. I'm generally there at 8 a.m. There's no one else there, and I use a 25 to 30-foot lead to train recalls. I walk the dog out, I slowly go back, I call the dog. If he doesn't come or doesn't come the way he should, I reel him in like a fish. There's no one else in there. That's open green space. It's different than walking on sidewalks on Cobb Parkway or in Marietta. It's a different situation.
Sorry, your time's up.
Thank you. And thank you for taking the time.
Good morning, Commissioners. My name is Linda Hunt, and I'm a resident of Cobb County. There's not a thing I can say that everybody else hasn't said. I just want to lend my voice to the ban on kittens and puppies and I hope you'd reconsider that ban. Thank you.
Thank you.
Good afternoon. My name is Bud Hidley. I live in the Brookmont subdivision off of John Ward Road. I'm here on behalf of the Kennesaw Kennel Club. I am the AKC delegate. And we have a group of breeders that when I read the initial statement, now I understand it might go away, but I'm afraid it'll come back. So I just want to reiterate. In our club, we probably have 7, what I'll call at least prolific breeders of specialty dogs. And by that, I mean any dog that you will breed that you will see on AKC. On Westminster today, yesterday, Cobb County was represented, still is. I was glad to hear the other lady who already spoke about that. But we are not dog breeders that breed dogs to sell them for money. We breed our dogs, we test our dogs, and not just with ordinary tests. We test our dogs with expansive tests looking for diseases, looking for other things that would make our dogs not conform to the standards. And we cannot be lumped in with somebody that's going to sell a puppy. The other thing is, every one of our dogs, when they leave our house, they come back to us if for any reason, whether it be health, whether it be the person who got it just feels they can't handle the dog. We take those dogs back and they live in our house. I can tell you that makes some trouble. I had to take one back from 4 months from a home. They'd already brought in a dog psychiatrist, which when I heard that, if I'd heard that, I went and got it in the beginning. Because the dog has no problem. It was the people who have the problem. So we as breeders who are responsible, those dogs are our dogs. Nothing hurts us unless we lose that dog. There's one other thing I want to speak to, and that's the showing the dog at the home and selling the dog at the home. I can't remember the last dog I sold from my house. Normally, I pack it up and we go to Jim Miller Park, and I meet them in the pavilion there, and I let them see my dog. Or they meet me at a dog show. Just recently, I had a gentleman call me 2 weeks before a show in Jonesboro, Georgia. He called me 4 times. He got very angry because I would not let him come and buy a dog today. I said, you meet me at the show, I'll show you the dog. We go to a lot of trouble to ensure that these dogs get in good homes. And we can't do that if we allow him to come to our homes, because he would have come and got one of my dogs. Thank you.
Thank you, sir.
Hello, Galt Porter. I'm going to go very rapid here. A few things on the animals. I don't understand why we'd pick on pet stores that are paying taxes to Cobb County to solve a problem. It's if you have a problem with the manufacturer cars, you don't ban car dealers from selling cars. You go to the manufacturer and fix the problem. So that one makes no sense to me whatsoever. We know we have breeders here in Cobb County that have come forward, gotten land use permits to breed in their homes, follow the state regulations. We've actually put extra stipulations on them, but a lot of people would consider them puppy mills. And they've told us they're selling them out on the internet. Nobody has the ability to go back to that person for any real recourse. They say, oh, we're selling them out of state. That out-of-state person gonna come to Cobb County and sue that person? Or would you rather have them have a brick and mortar pet store that's paying taxes to Cobb County for people to get pets from? So that's that. On parks, there's a couple things in the parks amendment that bother me. One is there's some wording in there that says that the Board of Commissioners will set certain policies in conjunction with the Parks Director. Conjunction seems to mean that they have some ability to approve it. I think the BOC's the policy board, and there shouldn't be a limitation on you guys setting your rules. There's also a stipulation in there removing damaged vegetation, shrubbery, things like that. If this ordinance is adopted, if a tree falls in a park, a county employee cannot go remove that tree, even if it's blocking a driveway, unless they come and get Board of Commissioner approval. Same thing for any county-approved vendors. Sloppy language. I know what the intent is, but it needs to be written better. Same thing with parking of vehicles. It says parking of vehicles in the title, but then it refers to automobiles. What about trucks, RVs, motorcycles, scooters, all the other kinds of vehicles? They aren't restricted by this wording of this ordinance because nobody paid attention to details. And there's more in there on that. You know, on the special land use permit for limited impact professional services, I saw the debate earlier. I'm not going to say a whole lot on that other than a SLUP may be a better way to go about it so that you can put a time limit on it. Really, the problem with the LUPs are, they were, as Commissioner Ott said, they were supposed to be temporary, but they've never been used as temporary. You know, maybe we need a third classification, a temporary, a land use permit, and a special land use permit, with the special being the permanent things for towers and things like that that are built.
Excuse me, sir, your
My
time's up.
time's up. Okay, thank you.
Go. If you have that documented, I'll take a look at it.
How you guys doing? My name is Corey. Corey Davis. I'm a resident here in Cobb County. And I'm here in support of the STRs, and I just want to just tell a little short story about how I got involved with it. I got involved with short-term rentals after a motorcycle accident. I had a hole in my knee. I broke my ankle. I broke my hand. I was messed up. There's no way I was going to pay my bills. I would have got evicted. I found out through, about short-term rental. I was living in a 2-bedroom condo alone at the time. So in order to keep from losing my place, I rented that spare room out, and it covered my bills for that entire about 3 months that I was not able to work. And that's how I got involved. I met a lot of people, and I started looking at it a little bit more seriously. And people, I see a lot of people like to compare STRs to hotels and stuff, but it's not. When was the last time hotels are giving away a whole bunch, like hundreds of beds to victims of natural disasters? Like they Airbnb, when there's a natural disaster in the state like Florida or somewhere close, they'll send all of us in Atlanta messages. We need some beds, and hosts they're coming together and allowing people to come to these places for free. And I know young women who got pregnant wouldn't have been able to pay their bills because they couldn't work with whatever type of job they had. These STRs are saving people from losing their places, and it's helping a lot of people with more than what people on the outside are looking in think about. They don't generally think about these things. And as far as controlling them, it's like people have a vested interest in keeping the parties down and keeping all the noise down. And they do. Like most people I know, they have cameras, they have smart locks, and for me, calling the police is the last. I don't want to stretch resources in the county. So to me, that's the last resort. So I go there myself. I have video on my phone when I go and break these places, and I've had to break parties up, but they're done before 10 o'clock. If they reserve the place for 3 people and I see 4, I'm going down there myself immediately. And yeah, it's a lot more to it than what people realize, and it's actually helping communities more than people realize, especially through helping with bed space and helping homeless people. I've relocated a homeless family. I found I do general contract work, and I found a family of 5 children with their mother living in it's an apartment building that I'm clearing out. And they were living in one of the apartments. They don't have any water. There's rats in here. This is a building not in Cobb County, but it's just related to the story. And it's just one of the most horrible things I've seen. But me being an Airbnb host and having other vacant places, I was able to move them somewhere else. And it helps so much. It helps way more than people realize. And that's all I have. Thank you.
Thank you, sir.
Hi, I'm Jeannie Grimm.
I live in District 3. I'm a veterinarian. I practice in Cobb County. I'm also a dog breeder, a proud preservation breeder. I breed a breed to preserve the breed. I will be watching Westminster tonight. That said, I do want to talk about your definition of a breeder. And selling puppies, that they have to come to the home where they're born and reared. I don't sell most of my puppies out of my home. I do meet people in parks. I use Cobb County parks. I rarely meet people at dog shows. I participate in a lot of AKC events. I've titled dogs in almost every AKC venue, from agility, obedience, conformation, hunting, and a lot of my dogs, I have people on a wait list because of the reputation and what my dogs are known to do. Some of the people can't come to Cobb County to get their dogs. Most of my dogs are sold off a wait list before they're born. I do try for pet owners, because there's always pets in every litter, to meet them, let them see the mother, let them see a puppy. A lot of times that's much easier in a neutral environment, in a park. And I feel like I'm at risk if you're making people come to my house. I used to date a Cobb County police officer, and he told me, don't ever let anybody come to your house. Meet them in a public place. And we now know from Craigslist deaths and things like that, that this is not a safe thing. I live alone. My dogs are my children. I certainly don't want someone to come back and rob me and take one of my precious dogs that they met when they were there to look at a puppy. I would really like for you to consider the wording of that definition so that you can protect the breeders in Cobb County, the law-abiding breeders in Cobb County. My next comment is on the leashes in the parks, and I'll just go along with what others have said. In training dogs, I have over 200 AKC titles, performance titles on my dogs. That's a lot of training. I would be a rich woman if I wasn't training and showing dogs. But we do need these parks, places where we can take our dogs. Tracking is a long leash. We are responsible owners. We're not the average owner. I think looking at the wording, retractable leash, as someone else mentioned, those are the dangerous leashes. Maybe the wording needs to be done. Maybe a dog person, I'm sure there's others here, myself included, be more than willing to work with you to try to get the wording so that it's safe. And I know you're trying to protect the general public walking in the park on a Sunday afternoon, but we need to, in the exemption, maybe allow for people who do the training of dog sports. And then obviously the in-heat issue. Again, I am a breeder. I do take my bitches in heat. Even some of the dog venues, you can do barn hunt. You just have to put the little britches on.
You've run out of time.
Thank you so much.
Thank you.
Good afternoon, Commissioners, and thank you for taking the time to hear all of us. My name is Gloria Dorsey, and I am in leadership and employed by the Atlanta Humane Society for the past 23 years. And during that time, on more than one occasion, I have been deployed to puppy mill operations to participate in the rescue of numerous animals. The first time that I participated in a puppy mill operation, I was led to a structure behind a home, and upon entering the structure, I observed cage after cage of dogs. Many cages contained contained mothers with their suckling offspring. Other cages contained multiple dogs, many of which were crouched in the back of the cage, fearful of roaming eyes and hands reaching out for them. Their food and water bowls were always empty, and the floor of the cages and the ground where I stood were caked with filth and debris. And every dog I saw was either fearful, stressed out, or showing signs of illness. The very next time I was deployed to the site of a puppy mill rescue effort, the images were exactly the same, only the location was different. There were, these were the images and the experiences that no lesson in my veterinary classroom ever could have prepared me for. And the aftermath of these efforts involved caring for animals until they were well enough to be made available for adoption or old enough to be weaned. Some of the animals required additional time in foster care so that they could de-stress and heal from the emotional scarring they had experienced. And we do all of these things because they're the right thing to do and because the animals matter. During the calendar year of 2019, the Atlanta Humane Society adopted 9,614 animals, and we're grateful to say that 1,212 of those animals were to homes in Cobb County. We appreciate the residents of Cobb County for caring for the animals, and we appreciate you commissioners for your leadership, and we would appreciate you if the next time you have an opportunity to consider the Humane Pet Acquisition Act, that you will give it another chance to hear all of the voices just as you have today. Thank you for giving me the time to speak before you.
Thank you, ma'am.
Good afternoon, Commissioners, Chairman. My name is Jennifer Mays. I live in Marietta in District 1. I had written up a long speech. I'm going to keep it very brief given the length of today's meeting. I'm here to speak in favor of 10135. The Humane Pet Ordinance was obviously removed. Despite the AG letter, we know we're on the right side of the law, and equally, if not more important, we just know we're on the right side of what is just, what is ethical, and what makes sense. We obviously experienced a setback today, but as the great Vince Lombardi said, winners never quit and quitters never win. So stay tuned. We hope to be back. Thank you for listening to us. And like I said, we hope we can revisit this soon. Thank you.
Thank you.
Good afternoon. My name is Tammy Ream. I am not a resident of Cobb County, but I am a trainer of dogs in Cobb County. I travel from Cherokee County 45 minutes every Monday night to train with my individual students, whether it be a junior or an adult, whether it be confirmation, obedience, tracking, scent. I bring those people to Cobb County to train their dogs. If you put some of these leash laws in place, my students will not be able to come to me to train. If you put the laws in place about the bitches in season, excuse my language, you will not, sorry, that's dog terminology. You will not be able to have my juniors come. 1 month, you have no idea how much training can be lost if my students cannot come to my facility with these new laws in place. Thank you for your time.
Thank you, ma'am. All right, just want to make sure that everyone's been heard before I close this public hearing. Because once I close it, there's no second chances, all right? So seeing none, now declare the second public hearing closed on proposed code amendments. All right. I think there's some provisions in this, if I could get some concurrent consensus from the board here, that we take the proposed amendments chapter by chapter. Does that work with everybody? Then vote on them individually? Some of them clearly have had no comments made about them. So what I'll do is I'll make a motion on those that I think that I've not heard any issues about. Well, I'll make a motion on the proposed chapter, and then we'll have a second and a discussion about that, okay? So let's start with chapter 2. I make a motion that we accept chapter 2 as read. You have a second? You have a second. All right, any discussion on chapter 2?
Yes, if
So
you
we'll
can
take some
bear with-
time.
Yes, please.
We'll take some time. There's no rush. There's a lot of pages here. We're good? Thank you. Okay. All right, any other discussion? I'll call the question. Passes 5-0. All right, the next one is chapter 10. Now, how do we want to deal with chapter 10? Section by section? Since there seems to be some, obviously gonna be a lot of discussion about this. Exactly, right. Mhm.
Can we have
Sorry?
guidance from the county attorney's office for this?
Sorry.
Can we have, I guess Shanna and Randy and Debbie Blair to come up? to
Sure.
help us with this?
Sure, you can have.
Mr. Chairman.
Sure.
The big issue I see with, at least on the definitions, okay, so
Right.
10-1,
Mhm.
we've heard quite a few breeders talk, and I agree with them. I mean, you know, all the issues with Craigslist and everything else. I think it's not appropriate to require the sales to occur in their home.
Yeah, I agree.
You know, I think that, and let's see, Jessica's in the back. Jessica, if these folks are based in Cobb County, they have to have a business license, correct? Because they're operating a business, right? Or do they not?
They're a trainer.
No,
I
no.
can resolve the issue. Well, actually, no.
Well, no, it's just a question. I mean, I'm not saying that they have to or they, I mean, it's really more just, I'm asking, do they have, are they required? I'm talking about the professional breeders. I'm not talking about the people that own a dog and breed on their own.
It's regulated by the state. It's
Yes,
not
regulated.
us.
They have a state agriculture license.
Yeah.
So they have some sort of license?
Yes.
Okay, all right.
Well, and please remember that if 135 comes out, we're eliminating definitions.
All right, well,
They
so
are
long,
now.
you're not supposed to be talking from the, okay, I'm trying to help you here, so just, okay? And so Randy, the private breeder, is that coming out as a result of 135 coming out?
Yes.
Okay, so then that would go away. So let's,
Can you clarify, yes,
Yeah, I
can you
was gonna
clarify
say-
if the entire section, not just that definition?
so what in 10-1 goes away because we went through 135?
There are 3 definitions that will go away as a result of 135 being withdrawn, which is animal rescue organization, broker, and private breeder.
So with the fact that private breeder goes away for the folks in the audience, then that rule of having to sell the animals in their home goes away. Okay, all right, then I'm fine.
Okay, so with that, then there really is no change to chapter 1.
Your
I
certificate,
mean,
chapter 10.
10-1. All right, because the only changes that I saw were the term director was added, okay? And then the definition of feral cat was changed. That's the amendments that I saw as a result of the last meeting. Those are now in here.
Correct.
Okay, so actually we voted on 10-1 as revised. That's what we
Yes.
voted on.
Yeah, we could vote on that.
Okay, all right, so I make a motion that we approve chapter 10-1 as revised.
Second.
All right. Any discussion on that?
I'm sorry, just for clarity, in the as revised would be the removal of animal rescue organization, broker, and private breeder,
And
correct?
correct.
Yes.
Okay.
I do have some points for discussion. We've had extensive public comment for both days, of which I'm still digesting some of the comments. Some of the other terms that are in here are not clear to me without referring back to other sections of code. And I'll just share with you a larger issue than going through some of these one by one. But I have a concern about how closely we've looked at this entire section in light of all the comments that have been shared. For instance, if we look at the definition of pet store, that wasn't a definition that was removed. Is there a need to modify that with removal of 10-135? There's also other terminology that relates to 10-135. That includes offer for sale. Is that a definition that we need to revise, or is that something that we should keep when those terms were considered with respect to 10-135?
If I may ask Elizabeth Monyak to come up in our office. She worked
Sure.
extensively with this particular code section, and she
Okay.
can address these particular changes.
Okay.
10-135 goes away completely. We're not there yet.
Correct.
Yes, my
135.
concern is, Commissioner, is that there are other terms that we did not strike in our revised code amendment that seem to refer to 10-135.
Okay, because besides definitions, Debbie or Elizabeth?
Elizabeth confirmed that offer for sale and pet store can also go away as a result of 135
Okay.
going away.
Thank you.
Okay. Okay, and then,
Sure,
so
right.
these are just
We're just
definitions.
clarifying
The
what
other
the-
ones to me more.
We're just clarifying what revised
cleanups.
means, that's all. Okay, any other questions?
Anything else?
I'm just waiting, one commissioner has some, so she's
No,
still
I was
checking the,
asking-
I'm okay with.
Okay, with that, I call the question. Passes 5-0. Okay, section 10-11. I'm gonna make the motion that we approve 10-11 as revised, and then we're gonna discuss what as revised means, okay? We all understand that, all right? So I make a motion that we pass 10-11 as revised. All right, now,
Okay.
so it begins.
So the first revisions we talked about were the removal of with the exception of cats and the words not feline. The other part that I have an issue with, and I think this goes back to some of the comments we heard, was in A3, where it says, or to dogs participating in a sporting, herding, or agility competition. So that basically, I just want to clarify that that's saying that if they are participating in those things, then this section does not apply.
The
Is that
leash law
correct?
does not apply when they're competing in the agility or the,
But I think they
Right,
also
but
want to know for training.
Well, that's where I was going, because sporting, okay, I mean, we know everybody that, whether we're talking about animals or humans in sporting events, you don't just all of a sudden show up one day and run a marathon. I mean, when Commissioner Cupid goes and runs her 5Ks, she's out there running or working out ahead of time, and if you can't do what you have to do to compete, then we're not helping you at all. So I think that it needs to be added in here, some wording that says, or training for.
Training
What-
and tracking.
What if you went right after the word agility and put training/competition?
That's fine. Something that basically allows the folks that are competing in these things, because, I mean, we kept hearing about, and I don't own a dog, I own really big fish, but they don't have competitions like Westminster, but it sounds like Cobb County is pretty well represented, and I think that that's great for the county and businesses in the county, but I think that we need to at least give these folks an opportunity to train the animals.
and if I could just, the change that's in there now is the dogs participating in a sporting, herding, or agility competition or training for same.
Yes, I think that would be good. Okay, I would be good with that.
Yes, and this is where I have, I'm sorry, Commissioner, if I may speak to that. Yeah. I'm concerned about a level of subjectivity with respect to that, because is there a certain type of competition they're training for? There could be an amateur trainer, someone like myself that's training my dog for a neighborhood competition. I mean, I am just concerned about the level of subjectivity with allowing changes to the leash law. One of the qualifiers I heard with many of the speakers is, I'm a responsible breeder, I'm a responsible dog owner. And the reality is, we have these laws in place because we have to consider all persons included in the class of responsible and not responsible. And I just want to make sure that as we revise this code, that we're looking at the entire population of persons that could have a pet on a leash, and not, and to be fair across the board. So, I mean, I appreciate the revisions being proposed, but I have great concern. I'll just give a personal example. I take my children to a soccer park to train. There have been numerous instances where I've called animal control because of people letting their dogs off of their leash, people who consider themselves responsible, people training their dogs and their dogs becoming playful. And we're talking about allowing a Cobb County facility to also facilitate multiple uses where you have their, people there for multiple purposes. And as much as I want to support those who are there training their dogs for certain competitions, I want to support parents such as myself who want to keep, their family members safe when they're utilizing the park. And there was a great example given by a gentleman who says he trains dogs for competitions that said even when you have a leash that's of certain length, it poses a trip hazard. So I'm very concerned about how we balance all of these things. I personally, my suggestion is for us to wait on making any changes to Section 10. I think we need to have a more thorough discussion about all the things that we've heard today. I'm concerned about us making decisions today that can have lingering impact to many stakeholders in the county that could be impacted by these changes. I think we had a good run. I think we've given plenty of people opportunity to share their perspectives, but I do not feel today is the day to make the best revision to this code in a way that's not going to detrimentally impact someone. So with that, I mean, I move that we reconsider this code at a later date.
If I'm not mistaken, I think there is a motion that's on the table that's already been seconded, a motion that was initially made by
But Commissioner Cooper can
Chairman.
make a substitute motion.
She can make a substitute motion, sure.
Yes,
Sure.
yes, that's my desire, to make a substitute motion that we take another look at this and not make a decision on Chapter 10 today.
I'll second it for discussion.
My only concern is that we're trying to seek perfection here, and there may be so many caveats that we make the law so cumbersome that it confuses everybody. All right, I get your point, but and I certainly hear this gentleman about the leash being in a way that could trip someone running down the path. This goes back to the responsible dog owners too. You have some responsibility, to take care of your dog. You can't control or try to legislate every single action that a human being can do. So what we try to do here is find a approach that will encompass most reasonable situations. And I'm just a little bit careful about doing one-offs to try to turn that into some kind of a code.
Well, Mr. Chairman, I mean, to Commissioner Cubitt's point, I mean, just listening to her example about the soccer field, we have parks that have mountain bike paths. We have parks that don't have mountain bike paths. We have parks that allow certain things, and we have parks that don't allow certain things. And so maybe what needs to happen for this control of animals section, because obviously, there's some parks in District 2, like Ryan Park in Smyrna and some of the smaller parks, that they're just not suited for animals to be running around even if they're on a leash. For example, East Cobb Park, I mean, there's not a whole lot of room there most of the time because it's pretty crowded. So it may be that we have to designate, because what you can do at Kennesaw Mountain or what you can do at some of these bigger parks like in West Cobb and some of the other places, you have the park down in Commissioner Cubitt's district, and Commissioner Burrow, you have some really large parks, and it may be that in working with Parks and Rec, that we come up with places where we just say, you know, hey, you can't do certain things here, or you can do certain things here. We do it with a lot of other things in the interest of safety or in the interest of the preservation of the parks. I mean, you know, mountain bikers, they enjoy doing it, but we all know that it's very rough on the trails. And so there's some places that we don't do it, and the national parks are the same way. So, I mean, I understand what we're trying to do here in 10-11, but at the same time, I mean, I think Commissioner Cuba does have a point in that there may be ways to do what's in section 10-11 that we just haven't thought about looking at until we heard the public comment.
Yeah, and, I'm sorry, Commissioner. Yeah, and I would say maybe even clarify, like, where they're required to be on a leash, or if it's during training, or if they're in heat, or whatever, to be just if it's open space where other dogs are allowed, not, I mean, if it's in a building and they're training or showing or whatever, they're gonna have that, they're gonna address that, and it's not gonna be really an issue. Or if they're in a fence, yeah, they may get out or escape. Beagles are known for that. But, you know, if they get out, that's a one-time kind of issue that we would deal with, not an ongoing issue of not being confined to a fence or indoor or what have you. I think we need to maybe revisit this and get with
Commissioner Gamble?
staff.
And while we're going to be looking at this and reviewing it with staff, we're almost penalizing the responsible dog owners instead of looking at language to penalize the irresponsible dog owners that, you know, let their dogs out in parks. So maybe we need to change our approach and our focus to address the real problem. It's not the responsible dog owners, it's those who are irresponsible.
Okay, I understand where Commissioner Cooper's coming from, and I'll support her, but I just want to say one thing. We have over 60 parks in this county. And the moment you start putting a restriction on a park, someone's going to say, but I train my dog there, and he does just fine. So we're going to have,
Well, and
we'll just get to bring our sleeping bags here, where all the people are going to come here and say, we start taking that making that list and saying, you can't train your dog here, all right? That's all I'm saying. Just want you to be aware of that, okay?
I hear you, and trust me, I gave that as one example. One example out of this code. There are other aspects of this code that I think that need revision. You know, the same slippery slope or Pandora's box argument has been made on code enforcement. We can apply that law to anything. We can look at cars that speed. We're telling officers to catch every car that goes above 55 miles per hour, but that does not give us pause for making sure speed limits are in place. I mean, again, I think our goal is to make sure that we have a safe, you know, that we're protecting the health, safety, and welfare of our citizens. And, you know, we put code in place to make sure that we have the ability to do so, recognizing that there's county law, and then there's also just a law of public good that people have with how we respect the laws that are put on the books. But I just ask again, in light of everything that the commissioner shared, that we take another look at this so that we are not unfairly overlooking issues that could arise if this ordinance is put in place.
may I make a comment, please?
Sure.
This section 1011 applies to the entire county. We're talking about
Not just
parks here.
I agree.
And the parks is chapter 90, so if we
just
wanted
haven't
to.
gotten there yet.
Yes.
Right, I know, but I just wanted, excuse me, just to clarify that this is throughout the entire county and not necessarily in parks.
Yes, ma'am, and again, I use that as an example, not as the only circumstance
But to
which
your
an issue
point,
can arise.
in our discussions with one part of staff about this. And then in the discussions with parks, part of the reason that the changes were proposed in the park section was because of the discussions that we had with public safety. And so the fact is they're different code sections, but the fact is they are very intimately related to each other. And so you can probably see some of those sections be suggested to have the same treatment if this one is indeed held.
Agreed.
But I mean, I understand, I get your point.
Mr. Gamble.
And if we are going to review this code, I would ask that we have a stakeholder group from the various representing the different districts to participate.
Yeah, you can go ahead and reserve Jim Miller Park right now for that. Okay, any other discussion?
Well, yes.
All right.
If we're looking at 10-11, we're taking out with the exceptions of cats and non-feline.
No, we got, yeah, we're
No,
holding,
I'm saying going back to, well,
we got a discussion about the current motion, okay?
but I'm just
Commissioner
trying to.
Burrell's concern is this going to impact the TNR code, which is a separate section,
Of course it does.
if we don't modify
And-
cats on a leash?
I'm just saying, if we're taking out, with the exception of cats and non-feline, we're, because of 135, correct? Going away?
Well, no,
That
the-
doesn't have anything to do with.
this, the reason it was suggested to remove, with the exception of cats, was because it was proposed that a separate exception to the leash law go into effect as to the operators of the TNR program. But as I understand Commissioner Cupid's motion, she wants to hold, and I think it was second, the motion before the board is for the entire chapter to be held
No.
and reviewed.
10-11.
I said chapter 10 was my motion.
But to your point, Debbie, the separate exception for TNR, that's not in front of us. That would have to be created, right?
No, it's in
She had, excuse me, Commissioner Burrell had proposed it earlier whenever the presentations were going through.
Okay, all right, so it's in 1067, all right.
It's 10-11, A, B.
All right.
No, it's
2.
10-67 is the TNR.
Chapter 10.
Okay, I didn't,
This is,
I want to make sure. that-
10-11 is the
Section 10, excuse me, not chapter.
TNR.
Yes.
Okay, I want to make sure. All right, so we have a motion before of us to hold section 10
I was making,
first for,
I was trying to make a point, rather
Okay, you can still
than
ma-
hold it. If we could make these changes, I mean,
we have to vote on the motion
Okay.
first, all right?
Well, but
we
I think
had a
what
motion,
Commissioner,
now we have a different motion.
That's right.
but I think Commissioner Burrell's concern is if that we hold all of section 10, we're going to prevent the TNR program from doing
Correct,
their work.
that's correct.
So the question then becomes, do we just want to hold section 10-11, which is the control of animals? That way we can allow 10-67.
She can modify her
on.
motion if she wants to.
Well, Chairman, as I understand it, the first motion that was submitted was actually only regarding 10-11.
Correct, and then she came back with a substitute motion.
and-
Chapter 10.
For all of chapter 10.
For
Correct.
chapter,
Okay.
Right, and that's what's on discussion right now, and there's some implications being discussed, but we still have to vote on that motion, all
but
right?
we could still have discussion on the motion.
We're still having that
First or
discussion.
second, so I mean,
Right.
I'm not trying to limit discussion.
No, I know that, but I'm just saying, is there any more discussion about your motion?
I thought.
That's
Did
my
you
whole,
have a
that's my
further
question
point?
right now.
So
If there's no-
Commissioner Burrow was making,
So if
Commissioner
there's-
Burrow was speaking, and then she was limited, so
If there's,
I thought she was speaking to the motion that's on the table.
well, she's discussing the implications, if we agree to your motion, then there are implications about including pulling out the we're gonna delay the
Commissioner
TNR.
Cupid,
I would like
I think what I understand Commissioner Burrell is saying is that her concern is that by holding all of section 10,
Dash 11.
no,
10.
let me finish. By holding all of section 10, the part that refers to TNR is 10-67. All the questions and issues about leashes and all that other stuff is in 10-11, but the whole part about TNR is in 10-67. And that is simply the one that basically spells out that the TNR program can continue to move forward.
Okay, so there's 10-37, which is also on the table.
Correct.
There's
37.
10-67, which is also on the table. I mean, I don't mind excluding, this is why I wanted to thank you for clarifying what Commissioner Burrow was saying.
Yeah, well,
I think we can have additional discussion on 1067. There were some proposals, but there was an additional option that Commissioner Burrow made on that code, which still gives me pause for approving that today, but we did not vet that yet. So we may end up holding it, I don't know. But my concern is, to be honest, it's gonna be a continuing theme of all of my comments, is that a lot of the amendments before us today, we've had the ability to hear from a number of people who've come and spoken to them, and they've shared a lot of points which were not considered in the drafting of these amendments, which can have a far-reaching impact if we are not clear on these different views. And I'm concerned about us putting forward motions today that can have a far-reaching impact. So this is not gonna be the first time you hear that from me today. 10-67, I'm willing to consider that in a separate motion, but I
Well,
still.
no, but, okay, so but I think where the issue is your motion says all of chapter 10.
Right.
With the
So if you want to
exclusion
be
of
able to.
10-67.
I'm sorry?
Yeah, with the exclusion of 10-67.
So you're
or we
modifying
can
your
do
motion.
so it's just 10-11.
Okay, so let's vote on the current motion. Let's just vote on the current motion.
What is
Well,
it?
if you do that, then we're done with chapter
It was-
10.
It was already seconded.
Right, that's correct.
Right, but
Yeah,
if
so
you
we-
change, if you want to amend it to exclude 10-67 as a second, I'm fine with that.
Well, she's got issues with
Okay.
that too.
Okay. I don't. I'm fine with that.
Okay, so you're gonna modify your motion that we hold chapter 10 except for 10-67.
Discussion. And I see that county.
We just
attorney-
approved 10-1, didn't we?
We approved 10-1, but the proposal that Commissioner Burrow made earlier today was to 10-11. Because what is happening today is that there is a leash law in effect for all animals. So it was originally proposed at the first reading that we would accept cats because of the TNR program. So what is happening today is there is a TNR program that is going on. However, when the cats are released, the operators of the TNR program are in essence breaking the current ordinance because they don't have a cat leash. They're releasing it into the community. So the proposal that Commissioner Burrell was making earlier was to make the TNR program, the operator of the TNR program, be an exception from the leash law. However, based on Commissioner Cupid's comments, and I mean, so it isn't as to 67, it isn't as to just 67.
No.
Yeah,
It
I
would be
see-
holding it.
It would be
I see
adding a
67.
section 8 to 10-11
That's correct.
to allow that.
How is 67 not related to 10-11?
Well, the issue with the TNR today is that it's violating the current leash law, which the current leash law, as it's on the books today, addresses, I mean, all animals have to be leashed. And 67 does indeed talk to TNR, but that's not the only issue with TNR.
Debbie, let me ask you this, okay, to try to get us moving on here because we've already been here for a long time. When we have issues at zoning hearings for code violations and the board denies a request for whatever, land use permit, whatever somebody's coming in and asking for, we delay or we instruct code enforcement to delay enforcement of the code for 60, 90, whatever many days you want to call it. Could we not, as part of Commissioner Cupid's motion, go back to holding the section 10 that we haven't voted on and instruct staff to delay enforcement of the leash law for the TNR program until such time that the board comes back with modifications to chapter 10?
10-11.
No, chapter 10. Because if you hold all of chapter 10, and because it sounds like what you're telling us is that what we're trying to do is allow TNR to continue, and the only reason they can't continue under current code is because it's been identified the fact that they can't follow the leash law.
Yes.
And the people that enforce the leash law are the county. So just like we do in zoning cases where we give someone time, we have the students with multiple ones living in a house and they want to finish out the semester, the board could instruct staff to delay enforcement in the TNR program of the leash law until we have time to look at the rest of this code.
Can I ask a question? If I understand it, you just approved 10-1, okay? 10-137 deals with fees. I think we were comfortable with 10-137.
10-37.
37.
Restricting fees or removing the fees.
Right, we're
So that's a
removing
change.
fees and now it's a
Do
donation.
you have a fee currently in place?
No.
Exactly. So to me, I mean, it's, I don't see that being an active point because
Good
we
point.
currently don't have fees in place.
Well, I
And
guess what
think-
I'm getting at is when you say chapter 10, you're including all of those things. In some sections you appear to be okay with.
Well, 10-1 we already approved, so I don't think that's on the table either. And I don't think 10-137 is on the table because. we're not considering-
10-37?
137 where we decided to.
Okay,
Remove
but
the
that
fees.
also, are adoption fees included in 10-37 or just the return, I mean, the owner turn-ins?
Just the owner turn-ins is all that's included in 37.
It says respect to services performed.
As it relates to fees, Commissioner, and like Commissioner Cupid, the original proposed change was that we would ask for a fee. But if that's now changing, then the original recommended change goes away, I would assume.
Well, that
So
was
it becomes
taken
a
out.
moot issue.
That's my presumption.
That was taken out of the revised code, the owner turn-in fee. We removed that.
So that's what I'm saying, so it becomes a moot issue.
But you still, 1037 still addresses fees with that, even without that. So are we taking that out too? Dangerous dogs, responsible dog ownership?
No, the fees aren't changing. The responsible dog ownership law that's new in C is simply to clarify, that's the actual state law name for the dangerous dog control law. So it's a clarification, it's not a change in
Okay.
what.
So 1037 is okay. So can we approve those and hold 10-11?
Well,
would be
it
the
would be
decision of the
dependent on your vote of the motion.
Pardon?
It would be dependent upon the vote of the current motion that's before you, which is not to consider any more of section 10.
That's correct, unless she wants to modify her motion. So. I'm
Okay,
waiting.
the motion is to hold all of section 10 under animal control, with the exception of
10-1, because we passed it already.
We've already, so I just don't see it being relevant, so I wouldn't even refer to it.
Okay,
A
and
lot
10
of these other sections, they're
10,
interrelated.
still.
My suggestion is as is, but I haven't heard clarification from the county attorney with respect to Commissioner Ott's point on delaying enforcement of TNR.
Well, that's currently what's happening. I mean, that'd be just a matter of us continuing the TNR program, which would be off code. That's why they brought this to you to have that fixed, because they're desirous of getting a fix for that.
Right.
So.
All right, so the motion on the table is that we hold for further discussion, sections 10-11, 37, and 67. Those are the remaining fees, those are the remaining amendments that are on the table right now in this section.
And Commissioner Cupid,
Understanding.
would you be willing to add no enforcement so that the TNR program can continue?
Yes, ma'am, I think that's
Until
implied.
this is resolved?
Yes.
And usually we would have a date specific in order for it to be brought back to.
Well, and that's why I said until that time that section 10 is brought back in front of the board to be voted on. Well, the section 10-11, and to be more specific, 10-11, 10-37, and 10-67, because those are the only ones that have been properly read and everything as per, for code changes.
But we have to do another public hearing for these, right? So we gotta advertise it and,
Yes.
Right, but I think that the three that are on the table, because 10-1 was voted on.
Right.
It's 10-11, 10-37, and 10-67.
right. So we gotta have enough time to go through the staffing, the advertising, the public hearing, so whatever.
Right, that's why I worded it as until such time.
Okay.
That sections 10-11, 10-37, and 10-67 are either brought back to the board for reconsideration or.
That'd be fine, in essence, and that they're going away today,
Right.
and they would be
Okay,
just
that's fine.
resubmitted
Just
back.
wanna make sure
another
the
time.
commission-
It helps to facilitate even the group discussions that Commissioner Gamble suggested. We'll have enough time to bring people together.
Because there's no time limit now.
Right, but then that way, at least the folks doing
All right.
TNR, which we all
So
agree
do we
is-
have, does the county clerk have the motion? You understand it as it's read? We're on the motions to not have any, to hold further discussion on section 10, okay?
No, I would say
10
10-.
11, 37,
10-11,
and
37, and
I just want
67.
clarification, all right, 10, 11, 37, and 67, except for
the TNR.
the TNR, and till, what was your wording
Well,
again?
no, it's hold, any decision on 10-11, 10-37, 10-67, and to instruct staff, animal control, whoever, that to not enforce the leash law for the TNR program
Okay,
until such time that those sections are brought back.
there you go. It's exactly what I said.
Right.
Thank you.
All right, so we have
Motion
we have
and
the
a
motion on the floor as modified. We have a second on the modified motion. A second on the modified motion, that's all we're looking for.
Yeah, who was the second?
She's a second, all right, so we had
He made it.
discussion?
He
motion.
is.
All right,
That's a second, and I'm okay with the change.
Right.
It's read it.
okay, so,
Call a
call
question.
call the question. Passes 5-0.
Jeez.
Okay.
Late for our other meeting.
It's canceled.
Oh, it was?
All right, so, now we're on to chapter 18.
I thought we, Randy, did we eliminate all the stuff in 54?
I'm doing 18,
Oh, okay, I'm sorry.
that's right.
I got ahead of you. I was on a different page.
Chapter 18, that's on billing regulations. Okay, so I make a motion that we approve chapter 18 as read. Second, any discussion? Call the question.
Well, wait a
Passes-
minute. Oh, yeah, okay.
Passes
Maintenance
5-0. All right, now chapter 54. Now, I'll let you handle that one, Commissioner Ott.
All right, so Jay, the
Yes, sir.
54-52-.1 is the one that we're saying doesn't need to be changed. Is that correct?
It's the one that we talked about
Right,
not adopting.
right, because we don't need it.
Correct.
But with the understanding, and I don't know, Mr. Chairman, if you just want to make it as a clerk's note for the county manager and fire marshal, that we will put into a policy manual or put somewhere the definition that I read earlier, which I'll give to the clerks,
That is
on
correct.
what the documented evidence, or, I can't find it.
The definition.
Right,
The
oh, here it is.
definition
Here it
of
is.
sub-
Statements
Yeah,
of documents.
what substantial evidence and documentation is provided, and Jay provided that, and so I'll give it to the clerk, and we'll just put that as a clerk's note, and then get it into the fire marshal procedures so that all the fire marshals are on the same page.
Okay.
So, my motion would be to withdraw consideration 54-52.1.
Okay,
This is not clear.
Well, I'm doing them one at a time,
okay, so
Yes.
I'll second that.
okay? And the discussion for that is,
Yes, I just need some clarification on this. This was added and now we're withdrawing it
because when it was put, remember, they started the codes in November? Well, what happened was the state standards came out after the fact, and everything that we were putting in here is included in the state standard.
Okay,
And that's, when we referred to 120-3-3, it was adopted January 1st, 2020.
okay.
And so what happened was we don't need it because state law already
That's
has
clear.
it.
Thank you.
So that's why. So that's why we're withdrawing that one.
Okay, so any discussion? Call the question. Passes 5-0. All right,
Okay, and then on 54-55, we're just adopting that as as in this?
As it was amended most
Yeah,
recently.
as it was amended most recently, which changed it from 3 to 5. And
3 to 5, it defines the members, and it also adopts Appendix A of the 2018 International Fire Code.
Right, and that's all what's in our packets we have right here.
Second.
Right, so make a motion to approve 54-55 as amended.
Second.
Discussion?
Just
One
question.
question? Sure.
Who's appointing this board?
Well, it's by position,
It's-
because
okay, so
it's the
there's a
county
spec-
manager, the public safety director, or fire chief, if the public safety director is not a fire person, chief building inspector,
That was the initial proposal.
These
The-
are,
Commissioner Cupid, I believe that the appendix that Mr. Westbrook referenced provides for the county manager and the chief fire official to be eligible to make the appointments to the makeup of the board.
All right, so I didn't catch that. I didn't know about that
yes,
change.
because I mean, this is saying a general contractor, a business representative. These are any persons that could be out in our community.
Right, well, and the thought was that you would have a fire protection engineer, you would have an architect,
Yeah.
you would have a building inspector, you would have somebody related to fire and the county manager.
And I support the class in
Right.
general, but who makes the specific appointments as who the general contractor will be? Who will be the business representative?
I believe,
Who will be
well,
the industrial safety professional?
what I envision, how I envision that
Mhm.
taking shape would be that staff would propose a makeup of that board, filling each of those areas, and then that would be approved by the Board of Commissioners from time to time, which is the same process the building department does for their code,
I know we
my
have a building
understanding.
code, so, okay, so you would make recommendations to
The
us
board.
and the board.
So then
would
maybe, all right,
approve.
so maybe that,
that
section
needs to be
E,
added
yeah,
to
section E needs to be, have a sentence added to it that, and Rob and Bill, I guess, should we put in there that the, final approval of the appeals board will be by the Board of Commissioners? As recommended by the county manager and fire official?
That's a very good idea, sir.
Okay,
We're fine
then,
with that.
To
so
add some information to that, that's addressed in the Appendix A that is adopted.
That
and
it comes to
says
the
that
board?
governing body will
Okay, well
approve
then,
those.
if
The
it's in
governing
Appendix A,
body,
then we
which
don't
would
need
be
to
the
add that.
commissioners. Okay.
Okay, so then, the motion is to approve 54-55 as revised.
Okay.
Second.
We have a second. Call the question. Passes 5-0.
Thank you.
Okay, now we're on to chapter 66.
I'll make a motion on 66.
Go
I
ahead.
think we need to hold for consideration both, well, all the parts of chapter 66 that are in front of us. That would be 66-1, 66-57, 66-58, and 66-59.
I'll second that.
Until,
Well, actually, there's more sections than that, so it's just basically that we hold all recommended changes to chapter 66.
until, do we have to have a date?
We don't have, well,
Or some
until,
type of event
until that
certain?
time that it's
Are you
brought
just
back.
saying withdraw then, or what, hold
Well, I
until
don't,
when?
no, I think there needs to be the discussion on it, but I know that there was some discussion about having a citizens committee similar to some of the other things we talked about. I don't have a historic district, so I really don't want to say when that should be.
I do.
I mean, I know you like date certains, but, you know, I think that this one just needs to be held until it's ready to come back.
We don't have one for section.
Well, I'd ask that you direct staff then
We'll have a
to do something.
Okay,
to
all right,
get-
so make a motion to hold chapter 66 recommendations for code changes and direct staff to get together with the commissioners to set up a citizens committee along with staff to review each of the proposed code changes and then bring it back to the board after those meetings have been had. Does that work? Okay.
And do you agree with that second, Commissioner Burrow?
Yeah.
Okay. Call the question. Passes 5-0. All right, chapter 78. Chapter 78. I don't remember there being a serious discussion on that.
Make a
So-
motion to approve
I'll make a-
78
I'll
as
second
proposed.
that in discussion.
I
Hold
do
on,
have some,
hold on,
I have some
hold on.
questions with respect
Yeah,
to
sure, go
this
ahead.
that I didn't catch until a comment was made today. In section 78-292, particularly subsection F, I don't know who's over this code. There's got to be a specific policy purpose behind some of these changes here. Are we making this code consistent with the state code, or is there another?
That's correct. We're coming in, the state made some changes at the General Assembly last year to the health spot ordinance. So our changes are directly in relation to that. Now, one thing, like you mentioned, that section F specifically, the change that's been added there, because before it said the county police department shall investigate the background of both the applicant and the licensee and their spouses and employees, and it's been expanded to add and independent contractors except for Georgia state licensed massage therapists. Those state licensed massage therapists, again, in line with state code, they're already licensed by the state. We don't have.
Okay. I'm just, took pause when I saw their spouses on here. That's already in our code for us to
Yes.
investigate. Is this the only business or area where we go beyond the actual licensee or business owner to run a background check on a spouse?
This is the only one I know of. This industry is very closely regulated by the state, so our codes for this are closely in line with the state.
Okay. If it's consistent with the state, then I just, I won't make any recommendations for changes, but seems a bit odd. And then there was another section which doesn't appear to be a change, but just brings in a great level of subjectivity, particularly in light of a pending legal matter we have with the county. But 78-294, subsection 3, it says that, well, if you go back to the introductory paragraph, it states that the license could be denied, suspended, or revoked based on, go to subsection 3, the applicant or licensee is addicted to the habitual use of intoxicating liquors, narcotics, or stimulants. Again, this seems so subjective where is not based on a clear violation of law.
This is part of state law also.
Is it, I mean, yes, if this is referring to, I almost feel comfortable referring to state law in this, or saying that this is a reflection of state law, but I mean, who is to say someone is habitually using intoxicating liquors?
Right. I can't speak specifically to that section. That's not one that was proposed to change, so I don't have all the history there.
Generally, this is why there's a state license, and they would have gone through a process, a due process holding regarding whether they had some sort of treatment related to that interfered with their professional duties, and therefore their license potentially could be suspended as a result of that.
If this is a part of state law, why is this in our code? I just don't, I just see that language is extremely troubling to me. So we can just say, who enforces that?
Commissioner Cupid, I understand your concerns, except that it's not in front of us for changes.
That's the problem.
I
And
know.
so if it needs to be changed, it's gonna have to come
I would
back.
just, yes, I would just say that I just need more detail as to why that language is in our code.
And I understand all that, but I mean, we can only vote on the things that are being changed.
Okay. Okay, it's just included in front of us, and again, it's just,
Well, part of it would be if the state suspended the license and then we still kept that license. So obviously it would just mirror what the state's reaction would be.
We haven't had a chance for the public to comment on this, and this is,
well, it's here for public consumption because it's in our
but
package.
let me handle this, all right? We are here to handle issues that have been provided to a public hearing. We're now arising an issue where we've not offered the public the opportunity to do that, and so to discuss that right now, all right, is not appropriate.
Chairman, all I'm saying, the only reason I'm discussing it because it's in the same materials given to the public.
I get that part.
So I just want, if anything, he can provide some clarification
Okay.
on the matter, which he's doing to provide why it's in our code in addition to state law.
This
And
is-
he was in the middle of doing that, Chairman.
This is not the forum to do that. I mean, I let that conversation go on long enough, but the bottom line is that we could open up this whole book to that, all right? And that's not what we're here for. We're here to discuss those items that we proffered to the public for amendment, and this is not one of them. If we want to change that, then we can bring that back later at another forum.
Okay, but Chairman, then I would ask, why do we include code in here that is not up for consideration? Because typically, let's say we have subdivisions, we have sections, we have chapters where we do not include that language in the code amendment that we're bringing forward. It's being brought forward, so, I mean, it will lead one to reasonably review that section in light of the revisions being
Well,
made.
if you want in the future, we will only use.
I would just,
The underline
Let me
is
finish,
the
all right?
changes.
All right.
The code is already in.
I understand that.
The state law is already in our code.
I understand that, but
So we're voting on the changes only, correct?
I understand that. I'm still asking the county attorney for clarification
All
on
right,
that.
but this is not the place to do it. That's all I'm saying. All right?
Well, actually, the entire chapter is part of the advertisement. We don't put it in the specific sections. So all of section chapter 78 would be as part of that advertising. We'll reference those particular sections in case there is some sort of reference that the board wants to change as part of that.
So thank you for that clarification, because to me, his clarification shares that entire section that we printed is up for review.
The public came here today and last month to discuss the proposed amendments. That's why they came.
Chairman, and what the clarification that the county attorney provided you is that it's being listed because that
I hear that.
section is up
I
for
hear that.
amendment.
Can I have the floor a minute? I'd like to make a motion that we approve section 78-292
Second.
and 294 and, well, just all of 78 as proposed or revised.
So you're calling a question. All right, so with that, I call a question.
I would ask is before I vote is that I would direct the county attorney to provide clarification.
He just did.
No, he didn't. He didn't finish clarifying it. I would just,
Commissioner, you have to vote.
I will vote, but I can add I can also add a clerk's note that
The question has been called, Commissioner. You have to vote.
Chairman, I think you're being disrespectful.
No, I'm not. I'm
Chairman,
being very
had
patient.
Chairman,
The
no,
question has
you're
been
not
called.
you're speaking over me. Anybody in making a motion can ask the clerk to make a note of something, and I am directing the clerk to make a note for Commissioner Cupid's direction to provide clarification on section 78-792 with respect to similarities and differences between county law and state law.
The clerk makes the note, but I will also tell you, Commissioner Cupid, I will be more than happy to provide you with that.
Thank you, I appreciate that.
Okay, passes 5-0. All right, now we're on to chapter 90.
Oh, boy, this one's gonna have to be changed too.
So I'll make a motion to approve the code changes as proposed in section 90, with the exception of any that reference leash law.
Have a second? We have a second? Discussion.
Yes, I still need to review.
So what are they? Which section are we gonna take out?
Let's see, it looks like 90-6, let me go in the beginning here.
Where's Jimmy?
I mean, I think it's pretty clear, I mean, we know which ones are, but, so 90-1 does not have any reference?
63B1.
Well, it's, yeah, it's
That's where it
63B, well, it's 90-63B, and there's a whole bunch on the next page.
Right, but B1 references the 10-foot leash.
Right, and the animal, and just the animals.
No, there's also some on the other page about leash in dog parks and all that.
Yeah, B,
So basically, my motion is to approve section 90 with the exception of any code change that references leashes. And that covers it all.
Okay.
Okay, that's on the table. We have a second. Now we're waiting for discussion.
I would
have a
like to,
question.
yes, I do have some points too.
If we're doing 90-63, the animals restricted is B. So A is pyrotechnics prohibited. And I would support that.
I didn't remove 90-63. I simply said all of section 90 with the exception of any reference to leash law.
Right.
So that covers it. It allows pyrotechnics to be approved. It doesn't allow the animal restricted to be approved, so it covers it.
Commissioner Cupid?
Yes. There were, there was concern brought up during public comment with respect to what's being approved by the board in conjunction with Parks Director or just being approved by the Parks Director. And there are two subsections that refer to that I would just ask for some clarification in. Section 90-52 provides that normal operating hours for parks are from 6 a.m. until 11 p.m. for active parks, from sunrise until sunset. The designation of parks as active or passive shall be the responsibility of the Strike Recreation Board, and it says Board of Commissioners in conjunction with the Parks Department Director.
Right, and
What
the-
does that process look, I'm speaking, what
Yes,
is
ma'am.
that
The,
process?
if you rely on good old trusty Wikipedia, the definition of in conjunction with is in cooperation with.
Yes.
So it is not taking any authority away from the Board of Commissioners. It is strictly that the Parks Director would work with the Board of Commissioners to make that
Is
determination.
this something set as policy, or is this something where you drop by each of our offices, or is,
It could be as simple as an email if it's, or it could be appointments with each one of you, or phone calls. It's just working in cooperation with.
okay. I just think that's a little subjective, to say that. And I'm trying to read here, because I did ask for, the paper here.
If I could provide an example, I'm sorry, Commissioner Cupid. Essentially, Lake Allatoona, or I'm sorry, not Lake Allatoona, Allatoona Creek Park, we allow hunting at the park during hunting season. So essentially, as the commissioner liaison, the Parks Department came to me and said, okay, this is pretty much what the hunting hours are gonna be. We're gonna post it, et cetera. So to me, that's what in conjunction
But that's-
means for this kind of example.
I know what the in conjunction means, but that's also an example of how that does not comply, because that's in conjunction with the liaison and not in conjunction with the Board of Commissioners, when it's the board, which is a 3 out of 5 that sets policy. And that's my concern on subjectivity. Do you consult one commissioner? Do you consult 2 commissioners? Do you consult all 5 commissioners? Do you get 3 out of 5 that give you the nod and you move forward, and 2 other commissioners are not aware? I mean, I just think this is.
If it is a system-wide issue, Commissioner, then it would obviously be all 5 of the commissioners. If it's something like, for instance, what Commissioner Gamble mentioned, that was within her district for that time of that program, it would be with her. But if it's system-wide, like hours of parks, things like that, I'd work with each one of the commissioners to get consensus.
Okay,
It
because it's
says
moved.
Board of Commissioners, plural.
Yeah, and Commissioner, that is only for that section for the hours or listing the active or passive. It's not for your general run-of-the-mill things that would happen inside the department. That is only for that section. Is what it
Correct.
says in conjunction.
Correct. I just don't know what that looks, I just do not want an issue where there's a commissioner that's not in the know, or there's a commissioner that expects, similar to Commissioner Gambrell. It does not seem unreasonable to just talk to the district commissioner for that area. But looking at this policy, it's looking at it from a broader perspective. And just with the broad issues that we have on this board with, participation or lack of participation of all of us, I do not like that subjective language. I just think it should be very clear if this needs to be policy set by the board, if this needs to be policy set by the director with the commissioner of the area where the park is.
Commissioner, would it make you feel better if we replace that word conjunction to in consultation with?
That's the,
Board of Commissioners.
and again,
Just
that's.
put all Board of Commissioners.
All, yes, I prefer that language with each commissioner would be more clear. And I just don't, and I almost I'm looking to the county attorney just for some direction as to what that implies.
So, let me just for clarification.
Sure.
This this is giving the normal operating hours for passive parks and active parks.
Correct.
Passive park being no ball fields, just green space,
Correct.
playground. And those are sunrise to sunset,
Dawn to dusk, yes, ma'am.
okay? Active parks would be ball fields, activities, tournaments, that kind of thing. And league play, that would be a scheduled hours. And those go till 11 p.m.
Correct.
and are lighted. So in order to change the hours at any of the active or passive parks, you're just gonna walk the halls or talk to us and every one of us, each of us, regardless of the district. Because it could affect everybody's district. If you change the hours in one park, a passive park, or an active park, in one district, we could have a similar situation in another district. So I get the point, it needs to be addressed with all of us. But, if you just put each board of commissioners or each commissioner, or that it has to be an agenda, I don't know.
There's
All
another
right,
subsection
I have a
here.
suggestion.
Yes.
The designation of parks as active or passive shall be the responsibility of the Board of Commissioners, period.
There is specific language in subsection, or section 90-55, commercial activity, which is more specific. I would ask that you look to similar language. States here, no person shall sell, offer to sell, operate a concession, or engage in any commercial activity in any county park without the approval and consent of the Board of Commissioners. To me, that applies a formal process of ensuring each one is consulted.
But
3
that's
out of 5.
taken out.
But no, or consent, well, yes, it was, but prior it said Board of Commissioners. Just that language is just very, it's clear what your process is gonna be.
So do you want the board or do you want the parks director in there? I
And
mean,
I'm
I
trying to
see what you're
understand the
saying. I just,
policy intent. I'm trying to understand the policy. I'm open because I think in some instances, it's not unreasonable to consult the district commissioner. Commissioner Burrow brought up a point where it could impact all parks. We had a similar issue with recreation centers where there was so much variation in what was going on at each recreation center. We just looked to have just a blanket policy to address all recreation centers to remove such activity. I'm trying to understand your policy intent as well, because I just couldn't glean what I'm being directed by looking at the word.
Commissioner Cupid, I would suggest, and this may be Mr. Geese's issue with the language, but the approval and consent of the Board of Commissioners, I think, would definitely include an agenda item that would be brought back before the board in order for them to be able to vote on it, so.
Is that,
Which that might be his intent, I don't know, or
Are
that
you
may be
trying
his
to
intent
not-
to move away from that.
are you
Well,
trying to?
the
yes.
only connotation that really, whether a park is active or passive, the only thing that really affects is the hours. There's nothing else that is affected by whether a park is classified as an active park or a passive park.
I'm
So
open to
if
that,
you want,
yes.
I mean, I don't know if you want to be bothered every time we're looking at a park, whether it should be the lights on at certain times, off certain times.
What did you think when you wrote the code? What
Well,
did you, role did you
that was
want us to
already
play?
in there, so that was,
That's why they're changing it.
you're right.
Yeah.
Well, and I guess my thing is whenever we approve a new park,
Sure.
when we approve that master plan, the board approves it as being passive or active. So going back to the 9052, the designation of parks as active or passive shall be the responsibility of the Board of Commissioners in conjunction with the Parks Department Director. We do that right now. We did that when we just approved the last, 4 master plans, I think, this year
Yes.
so far. We've already designated it as passive or active. So I'm not quite sure where the conflict is there.
Well, Commissioner, the reason why this whole thing, we're looking to change it, the ordinance was written at a time when the Recreation Board was a legal board and not an advisory board. They hired and fired the director, they set the budget, they made all of the different major decisions about the department. When the county went to the county manager form of government, the recreation board turned more into an advisory board. So they make recommendations to you as the governing body now. So that's why we're trying to align things up to the way they actually are now.
Do we vote on hours of operation, or do we vote on the designation of active and passive?
You've not done anything so far, other than when you approve a master plan.
Yes, and we don't have master plans for every.
No, we still have a few that we do not have.
Yeah.
Well, it seems to me if you say it'd be responsibility of the Board of Commissioners, you can just say period.
Sure.
All right? Because once you have the Board of Commissioners, you don't need to worry about the Parks Director or anybody else, all right? We're the ones that set the policy. You can make an injunction with anybody you want to, but the Board of Commissioners are ruling.
Does that imply?
So I'd recommend we just say period after Board of Commissioners.
We can do that.
And then, with 9055, I think there's agreement here about the agreement with the Parks Director. So I think if we do that,
Okay.
then we'll be okay.
Does that imply, and for the county attorney, does that imply a vote of the Board of Commissioners?
Well, if it's the responsibility of the BOC, yes, ma'am,
Okay.
that would be a vote. If that's what the intent is for you to consider.
Sure.
Okay, and again, just the language is just different here, because in some instances, the code specifically says approval and consent of the BOC. And then we had discussion about walking the halls, which are two different processes.
Well, just say approval by Board of Commissioners, and then it has to come
I
back.
think.
Just,
That would be the language I support.
okay, so who made the motion for 90?
I did. And I also said,
And did
and I also
second
said,
it?
yes, you did. And I also said that in 90-52, that I said responsibility of the Board of Commissioners, period. We already said that. We got that. So,
Okay, so we're good. All right, so any discussion on this?
And is that point clear? It's still not clear to me. Again, looking at the other section, is that approval based on a BOC vote?
No, he's changing it to just saying responsibility of
Two different
the Board
things.
of Commissioners and taken out in conjunction with the parks. But you're gonna have to bring it to us.
I would agree that approval and consent is more explicit
Yeah.
regarding what you have to do, but.
And I'm looking at, I ask this because you have revisions being.
all
made
right,
to-
all right.
I'm
We
just-
need to
Commissioner,
move
if I
on.
could
It's
just- no, I'm just-
1:38.
no,
I'm
Commissioner.
changing my motion to say that 90-52 will read, the designation of parks as active or passive shall be by the approval of the Board of Commissioners, period.
Okay.
And I call the question.
Okay,
I second.
you call the question. Passes 5-0. Okay. All right, now we're on to chapter 130,
Well, is that all of 50?
chapter 90.
All 90.
Yeah.
It's all 90.
All right, now we're on to 134. I know Commissioner Burrow wants to handle
Okay, what are we on now?
134. I know there's gonna be several questions. We should do that section by section. Let me get to 134 here.
134-36.
Make a motion to approve that change because it's just simply removing reference to chickens.
Right.
So I'll make a motion to approve the change to section 134-36.
Second.
Discussion? Call the question. Passes 4-1 with Commissioner Burrow in opposition.
I just need some clarification to make sure we made an appropriate vote. There was a suggestion made prior to us hearing from the public with respect to some type of documentation.
Oh, no, for chickens?
Oh, this for chickens.
No,
This is
that was for chickens. We haven't gotten.
Okay, I'm sorry. I
We're
thought
getting
you were
there.
approving the whole code, okay.
Yeah, no, when we get to that, I'll go over that again.
So,
Okay.
why would we take out a section before we vote on the new section?
It's all right. We'll see what happens when we get there. All right, special housing, set 134-37. I make a motion that we accept 134-137.
Second.
All right, and just to clarify, this pertains to student or purpose-built student housing?
Correct.
This was just a clarification in the the diagram didn't match the
Yeah, I just
language,
needed-
and it's just,
I just needed to know
Or
what it
clarify.
was referring to.
Okay, I'll call the question. Passes 3-2 with Commissioner Gambrill and not in opposition. All right, now, section 134-39. Who would like to carry that section?
I would like to make a motion to approve section 13439.
Okay, we have a second. Discussion.
Yes, if you can just give me a moment so I can review some of the comments made in this section.
and I don't support this
So,
for reasons stated previously.
Jessica, can you just clarify the process if somebody wants to go through this, what steps they will take per this code?
Yes, absolutely.
Thank
It would be the same process they would take if they were going to apply for a rezoning or a use permit. They would come to our office, they would file the application. It would be then advertised publicly with the sign and the newspaper ad and all of that. It would go to a public hearing before the planning commission, and then it would come, of course, they would make a recommendation as a recommending body, and then it would come to a public hearing before the Board of Commissioners at one of your zoning hearings, one of your regular zoning meetings, and you all would be the ones to vote.
And the only difference between this and a land use permit from from them pulling a land use permit would be?
Right, the difference between this and the land use permit is this is something that would not have a time tied to it. It wouldn't be temporary in nature. The special exception would apply as long as that use were to continue on the property.
Which is similar to special land use permits.
Except this does not have a time frame. What is a trigger for reassessing this permit?
The temporary nature of a land use permit, that this was not something that was intended to be temporary. And so Commissioner Ott brought some great points on that, and also the Chamber of Commerce with regard to, just thinking about our small business owners that, if it's a temporary permit, then that doesn't really give them a whole lot of certainty.
Yes.
Jessica, I think the issue is what triggers, this does not have a time limit, but I think the question is what triggers it to have a time limit, and that would be simply that the use that was originally approved for, if that use changes, so if you have a beauty salon, and all of a sudden somebody comes in and wants to have a accountant's office, it has to come back, because it's not being used for a beauty salon anymore.
Okay.
So as long as it's a beauty salon, if it's approved for a beauty salon, it can be a beauty salon and somebody else can come into a beauty salon. It's that use, as long as that use stays, it's not tied to the person, correct, Jessica?
That's not how the code reads. The code reads it's specific to user and use.
Is it user also, Jessica?
Yes, it would be specific user and use.
Okay, so either the user or the use.
Okay, and then if the additions are made to the property, this is not something that comes back before the board if it's within that 5,000 square foot.
That's correct, unless the board stipulates otherwise.
Okay. Okay. Just give me one second, I'm reading one more
I have
subsection.
one question too, because that's not the way I understand it. The list of uses that would be allowed under this permit, are you saying that when they apply for this permit, it goes through the zoning process, planning commission and zoning? But is it zoned for, or is it granted, the permit granted for a specific use of those allowable uses?
Yes, ma'am. So if someone came and said they wanted to have a professional office, and that was what you all approved, was the special exception for a professional office. If they came and said, I want to, instead of having a professional office, I want to have a photography studio, they would have to come back for a new special exception, although both of those are listed as permitted uses. It's tied to the specific use. But the uses that you see here as permitted uses, those are just things that could be considered as a special exception.
Okay.
Okay, and the 25 feet and the 2 acres down to 5 acres down to 2 acres. Oh, that's in a different one.
chickens.
Okay.
So here's just language that came up as a concern during public comment.
The parking.
And also as a concern of mine, again, when we bring up roads like Alston Road, where it says the existing single-family detached dwelling shall be reused, the residential facade shall be maintained, and any new construction shall be architecturally similar to the existing building. There are instances where we have very old properties that need to be, rehabbed. And I presume that that can be addressed during the zoning process, but I'm wondering, here, do we need to have language that states that the new construction shall be architecturally similar? If that can be language that's also included in the zoning hearing? Does it need to be codified when that's more of a stipulation or a condition?
I'm not sure that I'm clear on your question.
Here, there's concern that was stated in public comment about there are some homes that really need to be addressed,
Right.
that are on arterials that could be utilized for this purpose, and a concern that we can have some of our older properties reused, or not used, but not updated and utilized under this ordinance, and just, instead of it being improved or redeveloped, it would almost just encourage that, the current condition of that home.
Right. Now, with the language here, it wouldn't prohibit them from, addressing the maintenance issues or what have you, but if it was a specific property where, the home is in disrepair and, you all wanted to see that it was improved, that would certainly be something that you could stipulate on a specific request.
Okay.
But nothing in here would prohibit somebody, if there was a property that's fallen into disrepair or decline, that would prohibit them from, bringing it back up to a nice residential standard.
Okay, just as long as it's not viewed to be in direct contradiction to the text here.
Right.
Okay, also it says new lighting to be installed shall be established so that no direct light shall cast over any property line. We're not directing anybody to install new lighting, we're just saying no overcast.
Correct.
Maybe just change that to say where new lighting is installed, it shall be established, so, as opposed to just saying new lighting to be installed. Okay, those are my only suggestions.
Okay, call the question.
Can we change, are we okay with modifying that where it just says where lighting is installed? Because that wasn't included.
But in the language, it says parking signage and lighting to be approved by the Board of Commissioners.
Okay,
So the board would.
where are you referring to?
Right here.
Okay, yes, but here it just says use limitations. It just-
Right.
Okay, it just, again, just the text verbatim, just, it implies to me that new lighting is to be installed, and I just asked, adding in where new lighting is installed.
And if the new lighting's installed, the Board of Commissioners would
Yes,
have to
that's
approve
already,
it.
yes, that's already there, just adding that one term. Are you okay with adding where?
I'm fine. Bob, you seconded, are you? Okay.
Okay, thank you. I'm sorry, I'm supposed, language
Well, it just seems
matters.
that a lot of this stuff
When-
could
when
have
you're
come out
changing-
earlier than today, right now at this time.
This
This
is part
hasn't
of-
changed since 2 weeks ago.
Yes, but there's still discussion on it, in fact.
Well, I
again,
understand there's discussion, but this is not something that's changed since the last meeting.
Commissioner, changes can be made up to the point of us deciding. This is why we have this vetting process.
Okay, wait.
Okay.
All right, so it passes 3-2 with Commissioner Burl and Chairman opposition. All right, on to 134-133.
Motion to approve.
Have a second?
Second.
Discussion? Call the question. Passes 3-2 with Commissioner Gamble and odd in opposition. All right, now
213.
Question 134-134.
Okay,
Okay,
that's what we just
Um,
approved. That's what we just approved.
well, we did 134-133. That's what we
Okay,
just
thank you.
did, okay? Now we're gonna do 1-34-1-34. So I make a motion to approve that.
So,
Discussion. Hold on. She's allowed, there's some comment.
I'm not hearing any, I'm getting ready to vote.
Okay, all right, so I thought I heard you want to have some comments.
I'm
So
hearing
that-
comment.
So that I'll call a question, okay? All right. So it passes 3-2 with Commissioner Gamble not in opposition. All right, now we're on to 134-213. So I make a motion to approve.
I'll second.
Okay, now for discussion.
Yeah, I brought this forward, and because of the 2 zoning cases I had in my district, and I understand the comments from other areas. So, I mean, the motioning,
The issue's been about the language.
yeah,
Well, and Jessica,
but it's,
isn't the only change, I mean, it's, before, didn't it say tailor shop, thrift shop, or secondhand shops?
no.
No, thrift store and secondhand store were not previously included in that. We added thrift store, secondhand store for the last public hearing. At the last public
Okay,
hearing,
all
there was a
right.
recommendation to change it
Yeah.
to consignment.
So,
We're just adding thrift store and consignment store in the allowable uses under NRC.
correct. Right.
Commissioner, does your proposal of this amendment change with respect to comments heard today?
It does not. I'm just saying if the board has, I said I would withdraw and it would still come back as other business. So
Yes.
that's fine.
That would be my request, just this will definitely
Just to
impair.
strike it altogether.
Yeah.
We have a question, we can just vote.
So what's the question?
Yes,
She would
she's willing
recommend we
for.
just take it out altogether.
Take what out? The consignment sale,
Yes.
consignment thrift store? Oh, just take them out entirely?
Yeah.
Okay, all right.
And leave it as is.
Yeah, leave it as is.
Those two definitions will have to come back, under other business for approval in NRC.
So in fact, what we're doing is we're lining out thrift store, consignment store. That's the motion.
Well, yeah, we're denying it if it doesn't pass.
Oh, or so if we,
You made the
haven't made
motion
a
to
Well,
approve this,
right.
I seconded,
right?
and now just call the question and see, it's gonna go 3-2, but
I'm
go
just
ahead.
concerned, yeah, no, I'm concerned the way the language is and the way the motion is, we're
I
not
know.
clear. And if there's support on the board for us to still review this under other business, it will help to protect the residents who've had concerns about some of the uses, which would be,
I brought it forward, the chairman made the motion, I second it, let's just vote.
I know.
It's good,
It's okay.
it doesn't matter,
But I
everything
just-
else
I
has
just think
been
it's
3-2,
important to
just,
I just think
it's
it's,
okay, it's okay.
I just think it's important to recognize Commissioner Burrows, the one that proposed this and is willing to consider,
So I just want to
not
understand
considering it.
what wording is going to go in here. All right? It's as is presented here in this document, right? Tailor shop, thrift store, or consignment store, and consignment store is in parentheses.
Tailor shop is already in the code.
I know that, I'm just saying that what we have here is that if we approve this, we're approving the language of thrift store or consignment store, and consignment store is in parentheses.
That's correct.
All right, if we vote for it, we're approving the language here.
Yes, sir.
And if we deny it,
It comes back, it'll have to come back as another business item.
Which
okay,
it does currently.
okay, all right. All right, so let's call a question.
You made the motion.
Passes 3-2 with Commissioner Cupid and Chairman in opposition.
No.
So, see, I told you there wasn't clarity on that motion.
Okay, we're good. All right.
No, it's not.
Well,
it's
I made
not
the
good.
motion for discussion purposes, all right? I just want to move I'm moving the process along
I
here.
just want to clarify,
All right.
if there wasn't clarification, I wonder what we can do, because
okay, we're good.
what we did today allows that to move forward under you know, with our knowledge that this is going to cause a significant concern and challenge
Well, it passed.
for the county.
3-2.
Okay.
All right, 134-272, traffic and parking.
I would like to make a motion to hold this and to put together a group of stakeholders throughout the community to address, to bring back forward at a later time.
Okay, we have a motion and a second to hold. Any other discussion?
I don't know what that means. I mean, there are differences between District 4 residents and District 1 on this code.
And that's why I want to have a group of stakeholders from the various districts to
Okay,
come and
all right.
sit with staff to review this and come up with appropriate language.
Okay, any other discussion? Call the question. Passes 5-0. All right, 134-289, Commissioner Cupid.
I move that we approve section 134-289.
Second.
All right, any discussion?
That's just a cleanup.
Call the question. Passes 5-0. Section 134-290.
Okay, I make a motion to approve section 134-290 with the additional requirement for staff to create an online registration form similar to the one that the city of Marietta uses that will have the applicant verify that they meet all of the requirements of the code, and that application will then be brought over the counter to zoning office to be signed, and that at that such time they will also be given a list of what the rules are.
Okay, we have a second.
Second.
We have a second. Discussion.
I'm support this, but just understand, we've had a lot of discussion about adding things that are onerous to staff, and this will be one of those things.
And just to your point, Jessica and I talked about this, and part of the reason we're doing it as an online form and over the counter is literally all that staff will have to do is literally look at the form and initial it. There won't be anything that they have to review. Other than that, it's literally just, yes, Bill?
You said what the rules are. I assume when you say what the rules are, you mean what the code says.
Yes, what the code
Correct.
says.
Okay.
Right. So, and so before I added that to it, Jessica and I talked, and she said that that's not onerous.
Right, and that's not a problem for staff, and, you know, we're talking about just an over-the-counter or online. I think we offer both options. Permit that, you know, no cost is very simple. Essentially, it's to have the applicant acknowledge
That they understand what the code says.
Sure.
And the idea of doing the online form was simply that someone could go online, print it, fill it out, walk into zoning, get it initialed, walk out the door.
So, one thing, if I may, I'm sorry, I have one question. Whenever I sent that to Commissioner Ott and Commissioner Gamble yesterday, I just want to be sure that we're clear on what will be added to the code section with regard to this, because if we're going to require some sort of permit, I think we want to be sure that that's reflected in the code. And I'd sent some recommended language.
And I was fine with the language you said, yes.
Should I just read
Please,
that for the
can we all
record?
be made
Yeah,
aware
just
of
read
the
it right now.
language?
I haven't seen it.
Okay, I'll read this recommended language, and this was in this same section, section 134-290. Right now, it goes through H, which talks about HOAs. This would be I, which just says the community development director or their designee shall develop an application form for review of these requests. A person seeking to keep and raise chickens in accordance with this section shall first submit a complete application to the community development department, including a conceptual site plan showing the property with dimensions and locations of existing or required structures. So
Right, that's just the way that Jessica wrote what I just put in the motion.
Okay, but we don't know what those requirements are.
They're-
You mentioned
they're right here.
notice to the neighbors. but
Can we
that
bring it back
doesn't
for
say
approval at a later date?
Hold on.
Can we bring the form back for approval at a later date?
The form is simply going to be listing what's A through H.
Right.
Commissioner Cupid, you had a
Okay.
concern?
Well, I wasn't finished, if I may.
Oh, okay, all right.
Commissioner
I apologize. Then I'll let Commissioner, then,
I haven't seen the form, but I still can't support this because I think it has to be a land use permit that comes back case by case, with approval from the surrounding neighbors. I mean, this has no way of anybody having a say with, what's right next door to them when they purchased their house with a 2-acre minimum code. So that's just me.
Mr. Cupid?
Yes, if we're trying to remove how onerous this is to residents, then the language where you have to provide a conceptual site plan, and you would have to do that online, creates a burden. For one, you're assuming that that's the capability that persons that want hens are gonna have. They're gonna have the ability to draft that and somehow send a draft of that electronically. Even if there's just some type of description that they can put, they will have it at the rear of their home.
And like I said, the conceptuals, the idea was nobody's sending anything electronically. The online form we're talking about is just simply that the form is available online.
Okay.
Okay, and then I think the idea was, you're not asking for something to be drawn by, I mean, you're the one that said that. So I think you're willing to accept anything that just shows basically where the chicken coop's gonna be. I mean, the main thing, for example, is the fact that the chicken coop's supposed to be in the backyard, not the front yard, and things like that, and I think that's really what they're looking at.
Well, and if you wanted to eliminate the requirement for the site plan, I think having the standards
A
there, it
description.
still
Right.
spells out.
Yes, something that just says they can
I was
provide a
simply
description
deferring
of it.
to what Jessica thought we needed to write, and if you're fine with taking that out, that's fine, take it out.
Mr. Gamble?
Well, and the way I took it is because we're tying the number of hens to the square footage, essentially the site plan would give the square footage of the property, therefore ComDev would know the appropriate number of chickens they would be allowed to have.
Well, and getting the square footage of the property is certainly not a problem. With
Yeah,
or
that's not
without
that hard.
site
You can do that with
plans.
GIS,
Right, right.
so that's not
Yeah,
that
we can
hard to
just
do.
strike this conceptual site plan.
Yeah, just strike the conceptual site plan and keep everything else.
Any other discussion? Commissioner Burrow?
No, call the question.
Oh, I thought you said you had a question.
I already made enough
Okay, I'll call the
comments
question.
about the chickens.
Passes 3-2 with Commissioner Burrow and the chairman in opposition.
I thought
Okay.
we
All right, I make a
were-
motion that we hold section 134-291 and direct staff to create a staff citizen task force to take a look at possible changes to. And then also the time frame will be at least till the end of the session because we need to find out what they do downtown.
Yeah.
So that's my motion.
So if,
We're holding it.
I will second that,
It's already been
but I just
seconded.
have one question. Are you directing staff to start this task force before we know what is gonna happen downtown? I mean, it may be all in vain if they pass something that we can't do anything about. And meanwhile, we have this committee going, wasting time if there's nothing.
Well, they may
we
not be
can-
wasting time because we don't know exactly what the language is gonna be downtown. I mean, I think,
Huh.
they're on day 14, and they're on a break right now, so they've only got 26 days more. I just think that we can't even create a task force in 26 days, so I'm just gonna leave it the way it is.
Okay.
But when are,
I don't know what it.
we're
what is-
holding it.
I'm not gonna
and-
get in the weeds and tell staff how to do their job.
But you're directing them to do something.
That's right, and
they don't
staff
have a
can figure
schedule.
out when.
Okay,
they-
all right.
I
all
don't
right.
know what your motion is.
Multiple
but just show
discussions
some.
here. We gotta slow it down here.
The motion was to hold this section and direct staff to create a task force of staff and citizens. And the hold, because Bill likes a date, is till at least the end of the legislative session. Because there is a current bill working its way through the session that would not allow us to have any say in it anyway.
So
But we don't know if it's gonna pass, we don't know if the governor's gonna sign it.
And we have a second for that.
And usually has till July 1st to sign the bill unless it's otherwise
Exactly,
designated.
right.
So.
So,
Okay. So any other discussion?
Just very briefly, this
Sure.
is a policy, it's a policy consideration that came to mind as people were speaking during public comment, is that as we consider the commercial use of residential property in residential areas, that we have been highly restrictive of the residential use of residential properties when it comes to land use permits and having more people in residence. And so I know these are considered two separate things, but I'm concerned about us putting commercial interests above residential interest in the use of property in single-family zoned areas.
Okay, and the task force,
Yeah.
I did not direct what they had to talk about, okay? Simply said a task force, because there may be things, although we may not be able to restrict short-term rentals per this legislature passing something, there may be issues or things that can be worked out with the organization that we heard from today that the county will still be able to do or help get their help. So I think that the task force is kind of open-ended as to things they can talk about.
I don't
And what you're
disagree.
describing are some things that they can discuss.
Yes, I just wanted you to be aware of my concern, or not just you, but the board to be aware of that concern of mine.
Okay, so with that, call the question. Passes 5-0. All right, so believe it or not, we still have other parts of the agenda to carry here today. So let's take a 10-minute break and come back and do the other public hearings and the rest of the agenda. The next agenda item is a public hearing to approve the Chattahoochee Corridor Plan Certificate.
That's odd. Kim, where's your boss? Kim, are you calling?
Hold a second? 1 minute, okay. We got in here. Yeah, absolutely, there's something here I want. Actually, I want two of them. Just give me that look.
Bill,
Hey, where's my
how many
doctor?
do we have signed up for public comment?
Oh, you look just like my doctor.
Do we have anybody signed up? I already got some, okay. We have what?
You can only eat plant-based people.
Dark. This is dark. This is my definition of, this is my definition of dark.
Just throw a little almond in it and sea salt.
They're not here.
Is that your phone? While we're waiting for Hot to come back.
Sure. That's fine. Well, I'll tell you, why don't we do numbers, the public hearing about the $100,000 first, okay? It's okay, just.
Here.
I know, it's fine.
Okay.
Go ahead,
Okay,
Erica.
thank you, sir. At this time, we would like to ask that the Board of Commissioners conduct a public hearing prior to expending $100,000 or more to secure engineering design services for master task order contracts for professional services, please.
All right, just to go over the rules again, unlimited number of public speakers. Each speaker has 3 minutes. Let us know who you are and where you live. And with that, I now declare this public hearing open on expending $100,000 or more to secure engineering design services for master task order contract professional services. Would anyone like to address that issue? Seeing none, I now declare that public hearing closed. Thank you. Is there a vote on that one too? Okay, so I make a motion that we approve the agenda item as presented.
Second.
Discussion? Call the question? Passes 5-0. Okay,
Okay, thank you, sir.
thank you. Now Jessica on the Chattahoochee Corridor Plan Certificate.
Okay, this is a request for Chattahoochee Corridor Plan Certificate of Compliance for a project at 761 Burning Tree Drive. The proposal is to replace an existing single-family residence with a new single-family residence. It has been reviewed by the Atlanta Regional Commission and has been determined by the ARC review to be consistent with the guidelines of the Chattahoochee Corridor Plan. And this is a public hearing, so we request a public hearing.
All right, so I now declare this public hearing open on the Chattahoochee Corridor Plan Certificate of Compliance for a proposed project to replace an existing single-family home at 761 Burning Tree Drive. Anyone like to address that issue? Seeing none, I now declare that public hearing closed. Commissioner Ott?
Motion to approve the Chattahoochee Corridor Plan Certificate of Compliance as proposed in the agenda item.
Second.
Discussion? Call the question? Passes 5-0.
Thank you all.
Thank you. All right. And the rest. Okay, public comment.
I don't see Ron Siphon. Ron Siphon is the first one. The next one was Monica Delancey.
Hello, Monica Delancey, Riverside Community. Thank you for the opportunity to speak today, even though I've been here for 5 hours, but that's okay. That's what we do. So what I'll be speaking about today is housing and schools. I've been attending South Cobb Redevelopment Authority meetings Cobb County Board of Commissioners meetings, Marietta Housing Authority meetings, as well as the Board of Education meetings, talking about housing and its impact. I know that at one time I spoke at the South Cobb Redevelopment Authority meeting, and it was referenced that why should someone call to the South Cobb Redevelopment Authority meeting and speak about housing? But everything is relevant. Last week, I attended the Cobb County Fair Housing Survey input meetings. I went to two of them. One of them at Zion Keepers, and the other one was at South Cobb Library. And the ongoing theme at the meeting was about location of housing opportunities as well as wages to afford housing. Now, yes, I speak about it is very difficult for single income households to maintain, but this morning heard from other people that said it's hard for them to maintain their housing as well. I want to talk about the types of housing assistance that is afforded to Cobb County. One program, is being the Section 8 rental funds. That opportunity that is managed through Marietta Housing Authority has not been open in the last 5 years. And if you are able to get on the list, it takes about 2 or 3 years to even be given a housing voucher. So most of the people that are receiving the housing vouchers are pouring in. They're coming from other states like Alabama, Mississippi, Ohio, New York. And they're coming to the area to use their vouchers. And when they're coming to the area, most of them are being directed to use their vouchers in the Osborne area, the South Cobb area, high school area, and Pebblebrook area. And in addition to those families using those vouchers, at least they are stabilized. Then there's other housing opportunities such as rapid rehousing. Now, rapid rehousing, you guys can go through the Center for Family Resources to get those funds, but they're temporary. Or you can go through, people go through Fulton County through the Gateway Center and get those funds. Again, they're temporary. But again, people that utilize the rapid rehousing, which is temporary, they're directed to places that take those vouchers because people know it's short term. And so there may be a number of multifamily housing units or landlords who don't want to take those because they know that after that voucher run out, which is going to be short term, that person's not going to be able to afford $900 or $1,000 rent. But they do see their way to the South Cobb area. Then you have families that, move to the area because of better opportunities and hopes of jobs. They don't have no assistance at all. So they'll move to these areas on those hopes, and then they'll be moving very fast as well. Now, the South Cobb area has about approximately 45 multifamily housing units. To qualify for an apartment, a person must make at least 2.5 times their income. So that's roughly about $2,400 a month or more a person must make, which equals to $14 an hour. So how can a person afford housing and meet other basic needs such as food, utilities, and transportation, and then also provide for their children? Cobb County School District has a total of 114,000 children that attend their public schools. 47 schools are labeled as Title I, meaning that 47 schools have a high percentage of families that rely on free or reduced lunch. So that means that if they're labeled as economic disadvantage, you have economic disadvantaged schools in North Cobb, East Cobb, West Cobb, and South Cobb. But the majority does rely in the South Cobb area. So we must be intentional making sure that there are housing options for all income levels. If a child comes from a household that's economic disadvantaged and they're labeled that for 12 years, overnight they're not going to become able to be stabilized even if they get a trade or attend college. The state of our schools is the state of our community, and the state of our community is the state of our schools. I just want to remind you also that February is Take Your Family to School Week. A number of schools are having different opportunities to go to school and bring your family there. This month is also Black History Month. Riverside Intermediate School will be having their Black History Month play this Thursday at 6:30 p.m. And also wanted to say that one of our principals...
Delancey, I'm sorry, your time is up.
Well, thank you very much.
Kelly Johnson.
Good afternoon. I'm Kelly Johnson, resident of District 4 since 1999. I'm here to address and hopefully resolve the social experience that I've been dealing with since the past 8 years. What I'm seeking is, well, what I would like to do is move this away from public comment to a public request. And what I would request is a meeting with you, Mr. Chairman, and the board, a private meeting to talk in detail, to express my grievances with the county. In addition, which is kind of, I would say, radical, I'm aware that there is a program in which citizens can drink coffee with law enforcement or have donuts with law enforcement. I find that is not satisfactory for me. I'm not sure if it is possible or exists, but I would like to request that I have the opportunity to spar with a cop. This, I feel, will help restore my relationship with law enforcement. It also, I think, will redeem law enforcement due to the bad character of some of its people. And that's pretty much all I'm asking. Thank you.
Thank you, sir.
Denny Jones. Susan McNulty. Ron Siphon.
Good afternoon, Commissioners. I would like to address I-285 BRT operating in the future managed lanes. And as you know, my opinion is that that particular transit project will have the greatest impact on improving overall mobility in the Atlanta region of any project that the ATL will consider. So not just Cobb County. I think that is the best transit project that will come to the entire ATL from the standpoint of improving mobility in the region. It will also dramatically, it will also help to improve mobility in Cobb County. So we have a CTP process going on right now. And I think that y'all all agree that this project looks reasonable. It's been proposed by the same consultant that you're using who is working on the CTP. And the question is, the study that's already been done was done because all the cities and CIDs between Smyrna and Tucker hired this consultant to look at transit between Smyrna and Tucker. So that's what they looked at. The problem is, for this to be a true regional solution, it needs to run from I-20 to I-20. So it needs to not stop at Tucker, it needs to not stop at Smyrna. On the west side, it needs to go all the way down to I-20. Y'all know that I've been advocating this for a while. On the east side, when DeKalb DOT looked at it, they came to the exact same conclusions that I did for the exact same reasons. It doesn't address DeKalb County's mobility issues, nor its economic opportunity issues for South DeKalb, unless it goes all the way down to I-20. The exact same situation is true for Cobb County. For South Cobb to benefit from this project, but from the standpoint of the entire northwestern part of the entire Atlanta region, to benefit from this project, not just from a mobility standpoint, but also from an economic opportunity standpoint, it's crucially important that this project needs to go all the way down to I-20. Now, I don't want y'all to preempt the CTP process. This needs to go through the CTP process. This project needs to be vetted, not by me, but by the consultants who are doing this. The problem is the project is kind of defined as Smyrna eastward. It would be beneficial. Y'all don't want to wind up with a situation where we finish the CTP and just because of inaction, it doesn't get studied all the way down to I-20. You can't make an informed decision unless this project gets studied all the way down to I-20. Maybe the consultants will study this and say, no, it's better for it to stop at Smyrna. I don't believe there's any possibility of that happening, but you don't want to wind up in a situation where it only gets studied to Smyrna because y'all never gave guidance to say, look, we don't want to direct what the conclusion should be. We just want to assure that this is studied all the way down to I-20. It should connect to the Holmes MARTA station, but it's crucially important that it also connect to South Cobb for let's say the Six Flags area. So just all I'm asking for is for the Board of Commissioners to give direction to be sure that it gets studied. Don't wind up with it not being studied. Thank you.
Thank you, Ron.
Jeff Ledford. I don't see Sheila Edwards. Sheila Edwards. John Gazinski, I think, has already spoke, and Amy Barnes has already spoke. That's it, Chairman.
Okay, thank you. All right, I believe Commissioner Burrow had a motion to revise the consent agenda.
Yes, yesterday at work session, requested that we pull item number 21.
So you want to put it on regular or pull it entirely?
Well, we have to pull it entirely because it could come back at the next morning meeting for a hearing, or it may stay on consent. I just have some
So you have a motion to pull.
discussions I need to have
So you have a motion to pull agenda item number 21. Do you have, we have a second?
from
We
this
have a second?
agenda completely.
Any discussion? Call the question. Passes 5-0. All right, if you'll scroll down the consent agenda, please. With that, I make a motion to approve the consent agenda as revised.
Second.
Discussion?
I have a comment.
Sure, go ahead.
I just want the clerks to note that I'll be voting yes on everything except for item number 25. I cannot support borrowing money to build a fire station. In essence, we're floating a bond. That is why we have SPLOST.
Okay,
I would like that recorded for myself as well.
okay. Any other comments? Call the question. Passes 5-0. All right, on to regular.
Good afternoon. The first item we'd like to request is the Board of Commissioners Approve a contract with Butch Thompson Enterprises, Inc. in an amount not to exceed $186,731 for drainage system repairs on Chattahoochee Plantation Drive.
Commissioner Ott.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you, sir. The next item is requesting the Board of Commissioners approve change order number 1 final to the contract with Butch Thompson Enterprises, Inc. A savings to the project in the amount of $14,269.30 for drainage system repairs on Circle 75 Parkway.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you. Our next item is requesting that the Board of Commissioners approve change order number 1 final to the contract with Accelera Construction LLC, a savings to the project in the amount of $49,892.87 for Phase 5, demolition of 4 buildings located on Arlington Park at Wildwood Apartments for construction of Windy Hill Road, Terrell Mill Road connector.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you. Our next item is asking the Board of Commissioners to approve change order number 1 final to the contract with Accelera Construction LLC, a savings to the project in the amount of $12,588.02 for Phase 4 demolition of 12 condominiums located at Terrell Ridge Condominiums for construction of Windy Hill Road, Terrell Mill Road connector.
So moved.
Second.
Call the question. Passes 5-0.
Okay, thank you. Our next item is requesting that the Board of Commissioners approve change order number 1 final to the resurfacing contract 2018-2 Local Road South with Baldwin Paving Company, Inc. A savings to the project in the amount of $288,017.67 for resurfacing of county maintained streets.
Commissioner Gamble.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you, sir. Our next item is requesting the Board of Commissioners approve change order number 3 final to the contract with C.W. Matthews Contracting Company, Inc., a savings to the project in the amount of $1,227,314.24 for roadway improvements on Cumberland Boulevard.
Commissioner Ott.
So moved.
Second.
Discussion, call the question.
Okay, the next item is requesting the Board of Commissioners authorize the sole source procurement of professional services from Arcadis in an amount not to exceed $44,049.92 for further development of geographic information system crash analysis tools.
Commissioner Ott.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you, sir. Our next item is requesting that the Board of Commissioners authorize procurement of upgraded field and office computer equipment supporting hardware, software in an amount not to exceed $66,663 to replace obsolete equipment for transportation technology.
So moved. Discussion, call the question. Passes 5-0.
Okay, thank you, sir. And our last item is asking that the Board of Commissioners authorize advertisement for and conduct of a public hearing prior to expending $100,000 or more to perform engineering design services for various projects in the 2016 SPLOST Transportation Improvement Program. Further authorize the issuance of requests for proposals or task order work authorization to procure service.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Okay, thank you, sir.
All right, good afternoon, Mr. Chairman, Commissioners, County Manager. Property Manager has 4 items. The first is the Board of Commissioners approve a contract with Southeastern Commercial Flooring Incorporated in the amount of $535,697.64. Carruthers Wallace Courtney Incorporated in the amount not to exceed $450,000. And Irwin Sealing Company in the amount of $96,223.80 for the purchase and installation of flooring, furniture, and auditorium seating at the Public Safety Training Center located at 2435 East-West Connector, Offsdale.
Commissioner Cupid.
Second.
Discussion, call the question. Passes 5-0.
All right, thank you, sir. Our second item is the Board of Commissioners approved contract with Johnson Controls Fire Protection LP in the amount of $113,831 for work related to the fire alarm systems at the Public Safety Training Center located at 2435 East-West Connector, Offsdale.
Commissioner Cupid.
So moved.
Second.
Discussion, call the question. Passes 5-0.
Thank you. The Board of Commissioners approve an agreement with Controlled Access Incorporated in the amount of $181,225 for purchase and installation of county enterprise access control and surveillance systems at the Public Safety Training Center located at 2435 East-West Connector.
Commissioner Cupid,
So moved.
Second.
discussion? Call the question. Passes 5-0.
Thank you, sir. And our last item is the Board of Commissioners approves supplemental agreement number 3 final to the contract with John W. Spratlin and Son LLC in the amount of $13,536.18 for construction manager at risk services to build replacement fire station 1 located at 5781 Mableton Parkway, Mableton.
Commissioner Cupid,
So moved.
Second.
discussion? Call the question. Passes 5-0.
All right,
Thank
thanks,
you,
sir.
Scott. Any other additional public comment? Bill? Okay. With that, I make a motion to approve the appointment of Matthew Brown to the Cobb County Board of Family and Children's Services. Have a second? Discussion? Call the question. Passes 5-0. And I'd like to announce the appointment of Patricia Horton to the Workforce Development Board. So for public comment, I'll start with Commissioner Ott.
Thank you, Mr. Chairman. I just have one since we've already been here for almost 6 hours. Just announcing my town hall schedule. I guess you could call it my farewell tour.
T-shirt?
Hey, maybe we will have to have T-shirts. First one will be March 17th at Chestnut Ridge Christian Church. And then in April, we'll be at the East Cobb Library. And then in May, we'll be at, May 12th, we'll be at Smyrna City Hall. And then after everybody comes back to school in the fall, we'll have one last one in Vinings.
Okay, thank you. Commissioner Gamble. I know, I'm jumping around here, just trying to see if you're awake.
Okay, well, if they're ready for it though, too.
I know he's ready.
Next Thursday, February 20th, at the North Cobb Regional Library from 6 to 8 p.m., we will have our Emergency 911 Communication Department Town Hall. We will have a special guest, Cassie Masloom, who will brief us on understanding the sirens and emergency management system. Then on February 27th, at the North Cobb Regional Library from 6 to 8 p.m., we will then be hosting our Voting and Elections Town Hall with Janie Eveler from the Director of Cobb Elections and Registration. And then finally, on March 7th, Cobb County Parks, along with Sergeant Ablashi, hopefully I said that right this time, we are going to do a Gambrel Spring Bike and Archery Day, along with a chili cook-off. This keeps expanding. The event will be free, and parking also will be free. Bring your bikes and helmets and experience a free flight bicycle demo. We will also have an archery shoot, bike swap meet, archery swap meet, and chili cook-off. Hope to see you there.
So are you shooting arrows from while you're riding your bike, or is that a simultaneous event?
You know, there is an equestrian, you know, in the equestrian, we do have a shooting competition, so, you know, we might as well put it to bikes.
Could be a first.
Riding the bike, shooting bows and arrows, and eating chili.
Could be fun.
Got potential. Commissioner Burrow.
First would like to say thank you to Cobb County Police Department for their outstanding work. In 14 days between January 16th and January 29th, officers and detectives from the Cobb County PD have arrested suspects and solved the following crimes. 4 suspects responsible for an armed robbery, armed carjacking, home invasion, robbery, and murder. 3 suspects arrested for 3 separate murders. 2 suspects responsible for an aggravated assault. 1 local gang leader on federal gang and weapons charges. 1 serial armed robber who robbed an elderly women of their purses, and 1 bank robber. These arrests are due to the outstanding performance of our officers and detectives. And detectives and officers worked 30 hours in a row, slept for a few hours in their cars after being up all day and all night, and assisted one another on solving these cases and solved the crimes despite many obstacles. These are just a few of the examples of the outstanding work that occurred in 14 days by Cobb County police officers and detectives. The impact on crime in Cobb County from these arrests is significant and cannot be understated. Thank you so much to our police and public safety team. We appreciate your dedication, commitment, and tenacity in keeping our community safe. So as the Public Safety Liaison Commissioner this year, be on the lookout for more updates on their activities. Okay, congratulations are in order. This last week was a banner week for Superior Pets for Patriotic Vets. We had 4 adoptions in 1 week. The first is Mr. Cooper, who served 6 years in the Army and adopted a senior Chihuahua. Mr. Robertson served 6 years in the Army and adopted an American Eskimo. Ms. Brown served 6 years in the Air Force and took home this little pup. And Mrs. Vinson served 4 years in the Marine Corps and adopted Dudley. Dudley came in as a stray with an ID, but his owner never returned for him. He was injured when he came in and had to undergo a tail amputation. He's also heartworm positive. Miss Vinson and her family had no issues with taking on a heartworm positive dog. They brought one of their own dogs, a Siberian Husky, who wanted to be held for the picture, to meet with Dudley before deciding to do the adoption.
Is that a puppy?
Thank you. The Husky? Or the, I don't know how old they are. So thank you to all of our veterans, our 4 veterans that adopted pets. Thank you for your service to our nation. Thank you for giving forever homes to these pets. So if you are a veteran or if you know a veteran that would like to adopt a forever best friend, have them go to the Cobb County Animal Services Shelter, complete the form, select your new forever best friend. You can also visit Superior Pets for Patriotic Vets on Facebook and see all the pictures of all the veterans that have adopted. So a special thanks to Superior Plumbing for their generosity and support of this program and the staff at Cobb County Animal Services. Also, on another note, regarding the shelter, from now through Friday, Valentine's Day, adoptions are at a discount rate for dogs and cats, $20 through Valentine's Day. Okay, on February 13th, we will be hosting in this room a technology town hall featuring Deputy Chief Van Hooser and Captain Fisher. They will discuss the technology platforms being used, how, why, where the police uses technology, and the restrictions in place. So please come. We want to hear your concerns and hear about these new technologies and procedures. It will be in this room Thursday, the 13th, from 6 to 8 p.m. And it will be recorded and shown again on Cobb TV. On February 19th is the next Veterans Connection, 10 o'clock at the Tim D. Lee Senior Center. Come and learn how to protect yourself from fraud. Connie Gertz is a retired HR manager and an active volunteer in the senior community. You can call 770-528-1448 for more information. And then in March 19th, we'll have the next Coffee with Your Cop at District 3 from 8 to 10 a.m. Perfect coffee time at the offices of Janice Overbeck Real Estate Team on Roswell Road. And this is a great opportunity for you to meet your local police officers and discuss the issues and concerns in the community. And also, one last announcement. I think it was mentioned by one of the speakers. This is Black History Month, and to celebrate, the NAACP Cobb Branch is having an open house from 11 to 3 every Saturday in February and the address is 605 Roswell Street. And then also their 18th annual Black History Program Profiles in Black and General Membership meeting is Tuesday, February 25th. 6:30 is the meeting and 7 o'clock is the program across the street at the Strand. I know that's during our night meeting this month, but for those of you that are interested, please support Black History Month. Thank you. Oh, and happy Valentine's Day, everyone.
Commissioner Cupid.
Yes, thank you. Just in interest of time, please refer to my newsletter at cobbcounty.com/Cupid. Thank you.
Okay. A couple small things. So, we're going to have continued weather through the week. So I ask you to, if you have any concerns about potential flooding in your roads, fallen trees, please go to the county website. Cassie Maslum is standing up the emergency action team to respond to any potential weather-related incidents. And I'm proud to say that my Emmy-winning award, State of the County, will be on the Cobb County website if those who want to watch it again. So. Rotten Tomato Award, whatever. With that, we're adjourned.